present, but he's with us in his mind. He has to be, for political reasons, in one of those meetings politicians must attend, so please excuse him, but he supported our conference, and this was very welcome. We will now address some opening remarks to you, and en premier lieu, ce sera l'honneur à l'Organisation mondiale de la propriété intellectuelle, qui est tellement proche de nos destins et de nos intentions, que je voudrais demander à Madame Sylvie Fourbin de nous adresser une parole. Merci.
Peut-être plutôt après, vous allez savoir quand vous saurez ce que je vais vous dire. Merci. Cher Frank Godsen, chère Margarida Almeida Rocha, cher Victor, je ne sais pas, je ne l'ai pas vu ce matin, je ne sais pas où il est, mais cher Victor, chers participants au congrès de l'Alai, chers amis, bom dia a todos. Es un enorme placer para mí que esta edición se realice en Portugal, país de cual tanto gosto, en esa oportunidad en que Alai volta a reunirse de manera presencial. Et j'ai évidemment une pensée pour Raquel, qui avait préparé l'an dernier une magnifique session à Barcelone, la première en présence après le Covid, mais malheureusement nous avions encore des contraintes très fortes de voyage, et pour nous c'était la veille de la première assemblée générale de notre nouveau directeur général d'Arentang, et nous ne pouvions pas prendre aucun risque d'attraper le Covid en voyage. Donc c'était la raison pour laquelle je ne m'étais pas déplacée. Comme certains d'entre vous ont pu le constater, l'activité multilatérale, fortement impactée par la pandémie du Covid-19, dont nous ressentons encore les effets, a connu en 2022 une seconde secousse majeure avec les événements intervenus en Ukraine. C'est sur cette toile de fond que s'impriment deux tendances fortes à l'OMPI sur lesquelles je vais concentrer mon intervention. La première, au moment où nous désespérions de voir progresser les travaux normatifs, la dernière Assemblée générale qui s'est tenue en juillet de cette année a apporté un démenti magistral en permettant l'adoption d'une proposition décisive du groupe africain, la convocation de conférences diplomatiques pour deux traités quasiment aussi anciens que le podcast, le traité sur le droit des dessins et modèles et le traité sur les ressources génétiques issues de l'IGC. Cette avancée a été rendue possible par l'adhésion des pays du Sud à ce projet, grâce également à une volonté de la présidente des assemblées qu'elle nous avait déjà manifestée avant l'Assemblée générale et qu'elle a continué pendant l'Assemblée générale, l'ambassadrice Tatiana Molcean, et in fine, grâce au soutien de l'Union européenne. Hélas, cet élan n'a pas bénéficié pour l'instant à la proposition de traité sur la radiodiffusion du SCCR. Toutefois, les efforts conjugués de Yucalides, que je vois dans la salle, dont vous connaissez bien ici l'infatigable ardeur et la maestria sur la mécanique du SCCR, pour en avoir été le président pendant plusieurs années, grâce également à l'intervention des actuels présidents et vice-présidents du SCCR, de facilitateurs et d'un groupe d'amis du président, dont je vois également des membres dans cette salle, venus de tous les horizons. Tous ces efforts conjugués par ce groupe ont permis d'aboutir à un texte qui pourrait potentiellement constituer la base d'un compromis possible sur ce projet de traité. Ce serait évidemment un immense soulagement pour tous qu'un accord puisse être effectivement trouvé, si possible, lors du prochain SCCR et que les conditions soient de la sorte enfin réunies pour convoquer également une conférence diplomatique lors de l'Assemblée générale de 2023 sur ces enjeux ô combien importants. Mais je ne veux pas passer sous silence une autre évolution marquante dans le fonctionnement de nos travaux dont les États membres sont à l'origine. Rappelons tout d'abord que pendant 2 ans, les contraintes sanitaires nous ont obligés à tenir des réunions à distance, puis progressivement hybrides, ce qui a limité les avancées du SCCR, avec un pendant positif qui est que, par exemple, pour le dernier SCCR tenu en mai, nous avions, grâce à ce format hybride, 600 personnes qui participaient au SCCR. Donc quand même un fort intérêt que suscite toujours notre exercice. Les États membres ont alors introduit un nouveau format de discussion moins formel et permettant l'interaction, y compris à distance, sur des sujets d'actualité que nous avons appelés sessions d'information. Et lors du dernier CCR, le thème retenu a été l'impact du Covid sur le secteur créatif et éducatif. Et pour 2023, le prochain SCCR, le groupe d'Amérique latine et des Caraïbes a proposé dans le même format le thème de l'industrie musicale à l'heure du streaming et ses conséquences sur la chaîne de valeur. Le principe de ces sessions est de favoriser le partage d'informations avec le renfort d'experts et de susciter une discussion entre les États membres et les professionnels. Vous l'aurez compris, la tendance qui se dessine semble être de privilégier plutôt des résultats concrets avec le témoignage direct des acteurs et créateurs sur le terrain plutôt que de s'arc-bouter de session en session sur des discussions dogmatiques frontales. Ce nouvel état d'esprit irrigue le champ de la également le champ de la réflexion sur les exceptions et limitations. Nous préparons actuellement une boîte à outils sur les questions de préservation, sur le patrimoine des bibliothèques, des archives et des musées au regard du droit d'auteur. Ce toolkit, qui sera prêt pour le prochain SCCR, s'ajoute à un projet d'étude sur les exceptions et limitations dans le domaine de la recherche qui manquait à notre travail récent sur les institutions culturelles et éducatives et à quelques présentations sur des cas concrets sur les enjeux transfrontaliers des flexibilités au regard du droit d'auteur dans le domaine des industries et activités créatives et éducatives. Si certains membres continuent de mettre en avant la pertinence d'instruments internationaux dans ce domaine, l'idée commence néanmoins à faire son chemin que la soft law pourrait constituer une réponse adéquate. La voie de recommandation ou de ligne directrice internationale, International Guidelines, pourrait offrir à la fois une réponse utile pour les pays en développement et, pourquoi pas, le dénouement tant attendu de ces années de crispation au sein du SCCR. En disant cela, je suis consciente que nous avons plus que jamais besoin de votre soutien, membres de l'Alai, pour nous aider à faire émerger des réponses innovantes, out of the box, excusez-moi de l'anglicisme, mais c'est quand même mieux qu'en français, pour traiter des questions, pas le contenu, mais pour traiter des questions longtemps considérées comme clivantes, polarisantes et finalement décourageantes. Et comme cette session, je n'ai pas abordé les sujets de fond, vous l'aurez compris, mais comme cette session va aborder des sujets que nous traitons soit au sein du SCCR, soit au sein du secteur que je dirige, le traité sur la radiodiffusion, le sujet de l'audiovisuel que vous allez traiter, le sujet des metteurs en scène de théâtre et de la chaîne de valeur des acteurs du théâtre au regard du droit d'auteur et des droits voisins, la question des droits voisins dans le domaine du sport et l'importance croissante que ce dossier représente, notamment pour les pays en développement, et je suis sollicitée par exemple par le Sénégal qui va héberger les prochains Jeux olympiques de la jeunesse panafricaine et qui m'a fortement sollicité pour l'aider à construire un cadre législatif et réglementaire pour protéger les droits du sport et les valoriser surtout. Et enfin, le sujet, l'un des sujets les plus importants dont nous nous occupons actuellement, la chaîne de valeur et la chaîne des droits dans le domaine de la musique à l'heure du streaming. Je ne parle évidemment pas de tous les sujets qui sont devant nous et sur lesquels la vie et les conseils et les analyses que vous faites dans les universités et les centres de recherche est absolument capital pour nous. Comme vous le savez, j'ai déjà eu l'occasion de le dire, l'OMPI, c'est une enceinte à la fois passionnante mais très complexe, dans lesquelles non seulement nous avons des cultures, y compris des cultures de droits d'auteur différentes à gérer, mais également des états de développement différents. C'est une enceinte donc extrêmement complexe où il est assez difficile de trouver des consensus sur des questions normatives. Nous n'avons pour autant pas baissé les bras pour embrasser tous les sujets qui se posent aujourd'hui, mais qui vont se poser demain, et sur lesquels une réponse internationale est absolument nécessaire et indispensable. Nous avons les yeux ouverts sur tout ce qui se fait, aussi bien de l'autre côté de l'Atlantique que dans les pays de l'Union. Nous avons également les yeux ouverts sur toutes les innovations qui sont apportées par nos collègues d'Amérique latine, d'Asie et d'Afrique. Et avec tout cela, nous essayons de faire avancer ce vaisseau amiral des Nations Unies qui est l'OMPI, aux côtés d'un directeur général extrêmement dynamique et pour qui, comme vous le savez tous, le droit d'auteur des industries créatives est une priorité. Donc voilà, je suis là pour vous témoigner cette énergie que nous avons. Nous ne sommes pas désespérés, nous sommes extrêmement optimistes sur tout ce qui peut se passer, malgré un contexte international très difficile. Je voudrais remercier nos hôtes portugais pour leur accueil, cette salle est absolument magnifique. Elle va nous inspirer, je sens.
will be
Et vous dire que je suis à vos côtés, je reste pendant toute la session pour vous voir en bilatéral et vous rencontrer et bénéficier de vos avis et de vos conseils. Et comme toujours, je termine en disant, nous avons besoin d'un vivier de professeurs et d'experts pour nous aider à monter nos dossiers, pour nous aider à faire nos actions de formation. Et nous avons besoin de vous. Nous avons vraiment besoin de vous. Donc voilà, je termine sur ce message. Merci beaucoup et à tout de suite.
Merci, Madame le Directeur général, de ces informations. Chers amis et collègues, le président de l'Alai qui m'a précédé dans mes fonctions, Victor Naban, nous a fait le cadeau d'un dessin merveilleux. Vous pouvez voir projeté derrière moi, qui illustre sa perception du Saudade. Bien qu'empêché pour des raisons de santé de nous rejoindre en ce moment, il participe ainsi pleinement par sa contribution artistique à la construction de notre événement. Vous aurez remarqué dans ce dessin, c'est une note noire qui rappelle le souvenir nostalgique de nos réunions anciennes, datant d'une époque sans pandémie et sans menace de guerre. Les Portugais le savent et la présidente Margarida Almeida Rocha va vous l'expliquer encore que la Saudade n'est jamais dénuée d'espoir. Elle dépasse la mélancolie du passé en ouvrant le regard vers le futur. Voilà pourquoi les lignes noires du dessin de Victor se montrent agiles et ouvertes à certaines notes rouges qui annoncent une vitalité nouvelle. Cette nouvelle vitalité, c'est maintenant, c'est la réalité que nous vivons aujourd'hui. C'est celle de ce congrès d'Estoril, organisé par notre merveilleux groupe portugais. Notre réunion ici et en personne confirme le mouvement que nous avions entamé l'année passée à Madrid. Si l'amertume que nous avons pu ressentir pendant de trop longs moments d'absence était bien réelle, elle se trouve ici et maintenant compensée par le bonheur de nos retrouvailles. Ladies and gentlemen, why is Alai recognized and respected for its defense of authors' rights, now turning to neighboring rights? The answer is quite simple. It is because it matters. To know your own domain well and to be able to defend it effectively, you must be aware of the possession of your neighbor. Authors, in the defense of their own rights, will also find in certain holders of neighboring rights possible allies in battles to come. It will therefore be a question of discerning the possible alliances. If, in some other cases, frictions persist, it is also important to clearly define them. And finally, the study of neighboring rights is also very interesting because it is necessary to carefully monitor the current tendency to establish new neighboring rights. This is a phenomenon that my colleague Pierre Sirinelli has sometimes called les droits voisins du droit voisin, which could be rendered in English as rights related to neighboring rights. This is reflected in the title of our program under the name Special Rights. Here again, as far away as some of these new neighbors may appear to us, it is important as a precaution to study their possible installation and their impact on the classic copyright system well in time. this conference, I'm sure, will no doubt give rise to exciting prospects. C'est la raison pour laquelle je voudrais demander à la présidente du groupe organisateur portugais, Margarida Almeida Rocha, de nous adresser quelques paroles et de lui laisser l'honneur d'ouvrir formellement ce congrès portugais. Merci.
Madame la vice-directrice générale de l'OMPI, chère Sylvie Forbin, Monsieur le président de l'Alai, cher Frank Godson, chers conférenciers et congressistes, au nom de l'association Círculo de Autor, représentant de l'Alai au Portugal, j'ai l'agréable plaisir de vous accueillir au congrès international Alai 2022, lequel a lieu pour la première fois au Portugal. Le succès de ce congrès, y compris les conclusions auxquelles nous parviendrons, consistera à avoir su intéresser et réunir des participants d'un savoir aussi élevé, parvenant de diverses origines géographiques, représentant des cultures différentes ainsi que dissemblables systèmes juridiques, mais tous animés par la conviction de que le droit d'auteur et les droits voisins sont une cause pour laquelle il vaut la peine lutter, soit ce sont le socle de toute la vie culturelle. Un grand merci à tous. Un grand merci aussi à l'Alai, à son président et à tout le comité exécutif qui nous ont donné leur confiance pour leur aide dans la composition du programme scientifique et surtout l'encouragement pour mener jusqu'au bout cette tâche qui nous enorgueillit et avons exécuté avec une si grande joie. Un remerciement très spécial à 3 de nos sponsors, GDA, GDIP et Audiogest, lesquels, depuis le premier moment, bien que le programme scientifique ne fût pas encore spécialement dédié aux droits voisins, nous ont donné un appui généreux et inconditionnel, tout en nous aidant à dépasser les vicissitudes survenues, permettant ainsi l'accomplissement de ce congrès. Merci beaucoup aussi à Google et à Visa Press qui se sont joints à nous comme sponsors et nous ont donné une aide précieuse, et aussi bien à APED pour son soutien institutionnel. Finalement, et parce que les derniers sont toujours les premiers, je veux exprimer ma profonde reconnaissance au vice-président de notre association, Victor Castro Rosa, lequel, avec son savoir, dynamisme et optimisme réaliste, fut l'artifice de ce congrès et lui a transmis la vie. Le programme scientifique du congrès Alai 2022 se centre principalement sur les droits voisins, dès lors ceux consacrés à la Convention de Rome, ceux des artistes, interprètes ou exécutants qui rendent la vie aux ouvrages des auteurs, ceux des producteurs de phonogrammes qui les fixent et les mettent à la disposition du public, et ceux des organismes de radiodiffusion qui les communiquent au public en permettant une réception chaque fois plus élargie. L'élaboration d'une convention internationale sur droits voisins causa une appréhension aux auteurs, craignant qu'une telle protection ne fût préjudiciable à la sauvegarde de leurs intérêts. Pour maîtriser leurs soucis, l'article 1 de la Convention de Rome dispose que la protection prévue n'affecte en aucune façon la protection du droit d'auteur sur les œuvres, et donc aucune disposition de cette convention ne pourra être interprétée comme portant atteinte à cette protection. En plus, la Convention de Rome donne une garantie importante aux auteurs. La protection des prestations des auxiliaires de la création est strictement réservée aux pays liés par les conventions qui protègent le droit d'auteur. C'est que, ne l'oublions pas, tout commence par l'œuvre et son auteur. C'est donc bien plus fort ce qui rattache les auteurs et les titulaires de droits voisins de ce que pourra les séparer. Nous ne nous occuperons pas à peine de la protection de ces titulaires, mais aussi de tous ceux dont l'importante activité devant de ces jours indispensable, de celle des producteurs de bases de données aux éditeurs de presse, aux organisateurs d'événements sportifs, passant encore par les arts performatifs et de scène, et sans oublier un thème actuel et incontournable, la directive marché unique numérique, nommément son article 17. De toute cette réflexion, nous retirerons des conclusions qui mettent en perspective le futur. Nous terminerons nos travaux avec un important panneau sur le futur de la gestion collective, reconnaissant ainsi son rôle fondamental dans l'exercice du droit d'auteur et des droits voisins. C'est ainsi clair le dessein de ce congrès à Alai 2022. Construire le meilleur futur possible à partir de ce présent, bénéficiant de l'expérience du passé. Et bien aussi, nous souhaitons que ce congrès constitue le point de départ pour que des travaux, des nouveaux équilibres puissent être atteints au bénéfice de tous les ayants droit et des utilisateurs. Ils nous permettent aussi d'envisager un avenir où l'Alai deviendra de plus en plus écouté dans son souci permettant de rendre hommage à l'humanisme et à la vision de son fondateur, Victor Hugo. Chers amis, avant de terminer, je vous invite à détenir le regard sur le dessin projeté devant vous au fond de la salle. Cette œuvre, que notre cher Victor Naban, ancien président de l'Alai, a voulu dédier à ce congrès, exprime l'idée de saudade et évoque l'âme portugaise. Comme son auteur a dit, saudade est un mot portugais qui exprime un sentiment complexe où se mêlent mélancolie, nostalgie et espoir. Mais le dessin reflète aussi l'esprit d'aventure et de courage des Portugais qui ont sillonné les mers et découvert des pays encore inconnus. L'aspect mélancolie et nostalgie est représenté par les lignes noires et l'aspect découvert et conquête représenté par les lignes rouges, les deux aspects s'entrecroisant. Il s'agit donc du voyage, de l'agrandissement et du retour à l'essentiel. Au fond, c'est le voyage par la connaissance que nous ferons aussi pendant les 2 jours du congrès. Malheureusement, Victor Naban ne pourra être physiquement présent, mais il sera parmi nous à travers de son art et de son cœur. Pour signaler la réalisation de cet événement, nous défiâmes un artiste des plus reconnus du contemporain, M. Cabrit Reich, à concevoir une nouvelle œuvre d'art. Le défi aurait comme point de départ les 2 strophes de Lusíadas de Camões, qui sont le distinctif de ce congrès. À travers la mer jamais en avant croisée, des nouveaux mondes au monde montreront. Et l'œuvre est née. C'est la geste portugaise représentée par l'aquarelle imprimée sur vos sacs. C'est sur cet encadrement, l'âme et la geste portugaise, que je termine en invoquant notre grand poète Fernando Pessoa. À la fin de son œuvre Message, où il revoit le passé et lance un regard d'espoir sur le futur, Pessoa nous laisse une exhortation. L'heure est arrivée. Et ahora. Je souhaiterais que cette exclamation fasse écho en nous tous. Et j'ai l'honneur de déclarer ouvert le congrès Alai Vendôme. Merci de votre attention.
Je voudrais peut-être tout de suite inviter le premier panel à vouloir prendre place et je laisse la direction des opérations à la modératrice Fabienne Brison.
Does it work? The green.
So we have this one.
Ok, mesdames et messieurs, bonjour et bienvenue au premier panel dédié aux droits des artistes, interprètes et exécutants, probablement de loin la catégorie de droit voisin le plus proche du droit d'auteur. Alors j'ai le plaisir de pouvoir vous introduire 4 éminents collègues. La première, Silke von Lewinsky du Max Planck Institut à Munich, Allemagne. Raquel Xalabarder de l'Université ouverte de Catalunya, Espagne. Ole Andreas Ronstadt de l'Université d'Oslo, Norvège. Et enfin, Marshall Leifer, Indiana University, Bloomington, United States. Alors nous avons déjà un peu de retard, donc je ne vais pas utiliser beaucoup de dentelle. Commençons tout de suite par le rapport général sur les droits des artistes, interprètes et exécutants. Comme vous le savez, le rapport général est basé sur tous les rapports préparés par les groupes nationaux de l'Alai, pour lesquels nous les remercions vivement, et rapports nationaux que vous pouvez consulter sur le site web dédié au congrès d'aujourd'hui. Alors Silke, peux-tu, s'il te plaît, nous présenter la série sur le gâteau, le rapport général? You have the floor.
Merci bien Fabienne, et un grand merci aussi au groupe portugais pour m'avoir invité à ouvrir la partie juridique de cette conférence très importante. Margarida et Victor, merci aussi d'avoir mis les artistes, interprètes et exécutants au début. Et je vais continuer en anglais, because I think the performers are actually the closest neighbors to authors because of their artistic achievements. Fabienne has mentioned it. I will give the general report for those of you who are new to Alai. That has been a long tradition, going back to Victor Hugo in 1878, who based, let's say, work on comparative law, on expertise from different members, and thereby paved actually the way to the Berne Convention. And we have kept this tradition to have these general reports based on responses, in my case, on the performance rights, on responses by 20 countries to 30 questions put by the Portuguese group. And you can imagine that this is too much for going into detail, so I concentrated the talk on certain issues which you can see. And I will right away start with two general remarks. The first is that, well, we have in the past always talked about differences between common law and civil law countries, copyright countries, droit d'auteur countries on the other hand. And this is particularly pertinent in the field of performance rights. As you know, common law countries generally do not recognize the concept of neighboring rights as such. You have certain achievements like phonograms being protected by copyright in these countries. But when it comes to performers, you have sometimes problems to find protection, really similar protection as we have it in the neighboring rights system. This may be a little bit different for the UK, which had undergone European harmonization and had to kind of follow the civil law concepts to some extent. But the US law is really quite far apart from what we have otherwise in most countries of my report. That is one general remark. The other one is on the strong influence of the international treaties in the field as far as they regulate performance rights. You have the Rome Convention of 1961, which is still the basis, which has been taken over into the TRIPS agreement and slightly extended. And then you have the 1996 WPPT, which has quite extended the minimum for performers. And this all in the contracting parties to these conventions has brought about a quite strong similarity of national laws, which we will see. As to audiovisual performers, they were not included in the Rome Convention, or hardly. The same goes for the WPPT, because we had the opposition mainly of the US law, which is again quite different, the US government, and we managed in the end to bridge the gap in the Beijing Treaty of 2012. It's still a very young treaty, so you can see that only 5 of the 20 countries which I had in the survey have ratified the Beijing Treaty. The EU countries have not yet, because it's the EU as such which has to adhere according to our now own rules. And we would have to harmonize especially reciprocity rules, which are particularly complex in the Beijing Treaty, and this needs some time. And at the same time, I have to say that the national laws of the EU member states are mostly already complying with the minimum standards of the Beijing Treaty, because in the civil law system we generally do not discriminate between different kinds of performers, in particular audiovisual or audio performers. So basically they have the same protection. So when we introduced the WPPT protection, we extended that automatically to all performers in most countries. There was also a question about national treatment, and of course the countries have to comply with the obligations in the convention, so I will limit myself to recall that the Rome Convention has a provision which is disputed in doctrine. It is a little bit controversial how far the extent goes, whether it is limited to the extent of minimum rights or not. The TRIPS agreement has clarified that explicitly by saying that national treatment only extends to the minimum provided in the TRIPS agreement. And the WPPT has even been clearer in saying that national treatment only extends to the minimum rights in the form of exclusive rights, not remuneration rights, which we have in the WPPT. And I just also want to mention Article 4 in 4.2 of that treaty, which says national treatment does not at all apply, in no case without further ado, in cases where another country has made a legitimate reservation to the right of secondary use of the remuneration right. And it seems that the European Court of Justice has misunderstood that rule, or not really read it, or has met obstacles from on the basis of EU law in its famous RAP decision, about which we'll talk later. My colleagues will do so. There's of course also reciprocity outside the treaties. Where the treaties do not apply, you have national provisions on the status of foreigners. That's nothing special. Who is protected as a performer? And it's here where we see a particularly grand influence of the particular definition of the Rome Convention, extended by the WPPT. So most countries have taken over this definition or a similar one. Others have not explicitly integrated the definition, but just their case law refers to it. It's still the basis. This also goes for performers of non-works, like the Rome Convention mentions performers of circus, or arts and variety art. They are also performers of folklore, which are not works. You find that sometimes explicitly in the national laws. Otherwise, well, it's in the conventions and followed by the national laws. In Switzerland, Germany, and Poland, we have, in addition, an extension of the performers to those who do artistic or creative contributions to the performance or participate in that way in a performance. So we might talk about directors of theater performances as being performers, maybe even of sound engineers. So there are still some areas not totally clarified. Excluded, either explicitly in the laws or by means of interpretation of what a performer is, are mostly extras, or in French, artistes de complément. Then a question was about featured or non-featured performers. The laws do not distinguish between them. They treat them the same way. One exception is an EU rule on session musicians, and very, very specific in the context of the prolongation of our term of protection. I'll talk about that later. But often in practice there is of course a distinction, because non-featured performers are usually not named, they are getting less remuneration and so on. And then we have most countries who do not basically differentiate between the rights of audiovisual performers and audio performers. However, there's some weaker protection in most countries when it comes to legal presumptions of transfer, or even a shorter term of protection in Europe. So some slight differences, but not in principle. Also, the economic and moral rights provided are largely influenced by the international treaties, so I will not go into detail here. You find the rights of the Rome Convention in live performances and fixed performances. They are, of course, especially those of the WPPT, reproduction, distribution, making available. In all the national laws who are bound by these treaties, the rental right is less clear in the treaties, and therefore also in the national laws you find more countries who do not provide the rental right. Then a very important right for performers is, of course, the remuneration right for secondary uses based on Article 12 Rome Convention, extended by Article 15 WPPT. That's the right of remuneration for the use of commercial phonograms for broadcasting and communication to the public. I will get back to that. It is usually managed by CMOs. It is limited in these conventions to commercial phonograms. Some countries have extended that right also to audiovisual performances, like Germany. Well, if you look into all this complex of communication rights, broadcasting, transmission, public performance, and so on, you have to pay attention if you do comparative law, because these notions are not used in the same way in all national laws. So you really must make sure what the national law you talk about is meaning by a certain expression. Regarding streaming, there was also a question. It is, however, well, it is not a legal term, it's not in the laws, but it is used in practice, and it is normally, well, in all countries, considered to be a form of making available once it concerns the on-demand uses of streaming by platforms, for example, and a form of broadcasting when you talk of linear streaming, which is, for example, live broadcasting via the internet. And that is quite uniform. Then you have a number of countries, mainly in the EU, which have additional rights, in particular remuneration rights of different kinds. For example, for public lending and public libraries. Then we have a lot of cases where countries, again, mainly in Europe, have introduced remuneration rights as a kind of compensation for limitations to exclusive rights. The most important case is that of private copying, but then especially, well, I would say the winners here are Switzerland and Germany, who have the longest lists of such kind of remuneration rights and a long tradition of that, to kind of rebalance the loss of the exclusivity by a limitation, which is then possible without, so the use is possible without authorization, but then the law comes in and provides for a statutory right to remuneration, which is usually also managed by CMOs. And then again, in the EU, you find two other kinds of remuneration rights, statutory remuneration rights, which I will talk about in the context of contract law, because they aim at kind of rebalancing the weaknesses of a contract law. Finally, moral rights have been introduced by Article 5 of the WPPT in the form of the integrity right and the right to be named, like in the Berne Convention for authors. And those countries who have ratified the treaty, and even others, mostly provide for those two rights, with the exception of the USA, although it is a member of the WPPT. At least I have not found any moral rights for performers there. Then we have also, I think, the Czech Republic, which has extended moral rights also to the right of disclosure, as we have it often in authors' rights. I already mentioned that we have many remuneration rights, and they, in fact, can only be normally managed by CMOs. So CMOs play a big role in performance protection. In some cases, especially in Korea, they also manage exclusive rights. In the EU, they managed the exclusive cable retransmission right that was harmonized due to internal market reasons. And we have now, with the implementation of Article 17 DSM directive, partially also national solutions which apply the extended collective license to that right, to that situation. In 7 countries, you have only one CMO for performers. And in most cases, these CMOs are common ones between performers and phonogram producers. This is, I believe, based on Article 12, or the tradition, historically, 12 Rome Convention, this common right of remuneration for the broadcasting, etc., of commercial phonograms for producers and or phonogram performers and or phonogram producers. And the article says that there must be a single remuneration, which means broadcasters and so on wanted to be faced only to one counterpart to pay the remuneration. And that's why in the beginning performers got together very often with phonogram producers to build these common CMOs for that purpose. In the majority of the countries of this survey, there are even more than one CMOs. Often you have a dividing line between, on the one hand, audiovisual performers, on the other, music performers. In some countries you seem to have an overlap even of several CMOs in the field. The Netherlands stands out because it distinguishes according to different kinds of rights. So you have a CMO for public lending, or a CMO for private copying, a CMO for the secondary use remuneration, and so on. So it's a colorful picture. Transparency rules have been introduced in nearly all countries, in the EU mainly in the CMO directive, to oblige CMOs to reveal where their revenues come from and how they distribute them, etc. So that is quite a progress in the last 10 years maybe, to also create more trust in the CMOs, and that's really important because they are so important for the management to guarantee in the end that performers will see money. So my final point is on contract law and individual rights management. The exclusive performance right is usually transferable in most laws, except in Czechia and Greece, where, however, you can get licenses. Actually, in Germany, we have that system of licenses and non-transferability of the right only for authors' rights. Presumptions of transfer of the exclusive rights exist in many countries for the audiovisual field. So audiovisual performers, if they do not state anything else, usually they are rebuttable presumptions. So if the contract doesn't say anything else, then the law presumes that all the exclusive rights, or in some countries, some of them are transferred to the audiovisual producer, except in the countries indicated. This is in particularly, again, in the European Union, based on the first thoughts of the EC rental directive, where we introduced that it is often combined with an inalienable remuneration right. And the idea at the time was that if you introduce a presumption of transfer which benefits the producer, because, well, he needs to have these exclusive rights to manage the rights on the market, then you should also take care of the interest of the performer by ensuring that they will get an adequate, equitable remuneration in exchange. And that's what the EC rental directive has stated already in 1992. And so that is kind of combined. But this idea of having remuneration rights in the shape of inalienable, unwaivable, and rights which are transferable only to CMOs, so with mandatory collective administration, this combination, these elements have been seen in a great majority of countries, except those indicated, as an element to protect performers against the pressure by their contractual partners, like producers, which could arise in order to, to pressure to also transfer their remuneration rights. So the idea is, if you make them transferable only to CMOs which act on behalf of performers, and the CMOs are stronger than individual performers, then you can safeguard some kind of equitable remuneration. And again, this idea comes from the EU today and is largely applied there. In addition, again, the EU has invented two kinds of remuneration rights which address contract law weaknesses. The one is very specific in the context of the term of protection prolongation. It was in the Directive 2011, the term for performance was extended from 50 to 70 years, and it stipulated that this extension will be automatically covered by existing contracts. So in particular, session musicians who only get one lump sum payment would not have benefited from this prolongation. And that's why, again, EU has thought of the performers and said, well, they should benefit from this prolongation, and that's why we have now this obligation to have a statutory right of these session musicians to receive an annual supplementary remuneration of 20% of the revenues of the producers from certain income as stipulated in the directive. So you see, we care for the performers a lot. And the second model is, so to say, the residual right, which actually I had the honor to invent when I was drafting the proposal for the EC rental directive back in, well, even before 2006, because that's the revised version. And that was actually also taken as a model for other rights afterwards. I will explain it just in a minute briefly. It is, has been extended in some European countries, in particular to the cable retransmission right, the exclusive one, and now, most recently also, and I would say Belgium is the winner here, also to the online streaming right for legal platforms, and the Article 17 right for UGC platforms, and for direct injection. How does it work? In brief, it is a statutory remuneration of performers only, which comes, well, authors also, in addition to their exclusive right in the same notion. And I just put this, I made a talk about this in the Bonn conference in 2015. This is just the rental right, but you can extend that to other rights. The performer transfers the exclusive, let's say, making available right to the producer, who then gives a license to the platform. And the remuneration question is being outsourced, because there's a general idea that performers would not really gain equitable remuneration from the individual contract, so that this question is being managed. Well, there's a statutory right of a residual right, which is a kind of rest retained after the transfer of the exclusive part of the right. So the remuneration part of the right is then managed mandatorily by CMOs, who are stronger to manage, to negotiate good remuneration with the platform, for example. So that is very recent that it has even been applied to Article 17 right. And I come to the conclusion. I believe that performance protection is meaningful not only by having exclusive rights, but I think you often need legal safeguards to ensure that they can truly benefit from these exclusive rights. And we have seen some examples. There may be contract law safeguards. I didn't mention them. They were also in the questionnaire. The right of revocation a license when the producer does not exercise the license anymore after some time. This exists in many countries, but again, mainly European countries. And the so-called bestseller clause, if all of a sudden the performance sells much better than thought at the beginning, the performer has a right to adapt the remuneration. Again, an idea very European. I have to mention that the revocation right, well, you have also the termination right in the US law, that is particular. And then the right to appropriate proportionate remuneration on the basis of contracts. That's also a legal obligation for contracts in the new Article 18 of the DSM directive, about which Raquel will talk. And then we have these statutory unwaivable remuneration rights, which I mentioned in context with limitations and the residual right, regularly managed by CMOs. So we can see also the important role of CMOs. So should I say, well, and the best protection for performers you get in the EU? I shouldn't say so because I'm from the EU, but I think if you make this comparative research, which I did, it becomes quite visible that there is a lot of care for performers in the EU, and maybe this could be a model for other countries. Thank you very much.
Thank you very much, Silke, for this beautiful overview. In the European Union, as you all know, scope of protection is largely determined by the European directives. The last one to be implemented was Directive 2019/790 on copyright and related right in the digital single market, known for its its much debated Articles 15 and 17, who will be discussed later. However, in this directive, there's also a chapter on fair remuneration in exploitation contracts of authors and performers. And in this chapter, we also have an Article 18 concerning the principle of appropriate and proportionate remuneration. Now, to have a better understanding about Article 18, we rely on Raquel.
Good. Thank you. No, that's the third. We changed the pace. OK. Je veux remercier l'Alai pour m'inviter à être ici dans ce congrès. Comme Sylvie a dit, c'est le premier congrès normal depuis Prague. Et nous sommes toujours très contents, ravis d'être ici. Et beaucoup d'entre vous, vous avez la chance de venir à Madrid, mais beaucoup n'avaient pas la chance. Alors, on était très contents, les groupes espagnols qui sont tous ici, Pilar, Alfonso, José María, Paloma, everybody who's here. Nous sommes très contents d'avoir passé les bâtons à nos voisins portugais, Margarida et Victor, et nous sommes très contents d'être ici. Alors, English, because my slides are already there. So, as Fabienne was telling, I'm going to give you a bit of context about this new what we could call a European Union contractual corpus that has been introduced for the first time in this Digital and Single Market Directive of 2019. Traditionally, we didn't want to harmonize, or we refrained from harmonizing contract rules in EU copyright. We were thinking that there was no need for it, it was premature, and that after all, contractual rules did not affect the internal market, and that's how we have always been legislating on copyright, EU copyright. But at the end of the day, we have now realized that these contractual rules that basically exist in all national laws, at the end of the day, do have an impact on the internal market. They do have an impact on protecting authors and performers in securing remuneration for the transfer of rights that they do towards the assignees, the producers. I'm going to talk about the producers, but put the publishers, everybody who obtains the exclusive rights. But what we were seeing also is that in some specific markets and chains and exploitation markets, these contractual rules were not enough. They were not doing enough to secure performers and authors. I'm going to talk about performers, but put them all in the same basket. They were not doing enough to secure fair remuneration in exchange for the transfer of rights, and that quite often in some markets, what they were doing, think of audiovisual phonogram productions, what they were doing was transferring all the exclusive rights to the producer in exchange for one single payment, and then they were not getting any further revenues from the long chain of exploitation that these productions have. So that we were talking about a value gap, another value gap of the one we talked about so much on the Article 17, but a value gap that was being more and more visible as new online markets were developing. Lots of money was being made in these markets, and authors and performers did not get any remuneration out of it. So we thought there was a need to start acting on that. What have we done? Very quickly, we have introduced what we could say a new European or EU contractual corpus, 5 contractual obligations, principles. Let me elaborate them, but I'm going to talk about Article 18, but let's see them all here. Article 18 states a principle of appropriate and proportionate remuneration. We'll talk about it. Article 19 states a transparency obligation, like this. Basically, the producer, the assignee of the exclusive rights, has an obligation, contractual obligation imposed by law, that he's going to be providing performers and authors information about all the revenue streams, all the revenues and from the different modes of exploitation along the different markets. Article 20, a contract adjustment clause. We call it the bestseller clause, but it's nothing like a bestseller. Don't think of bestsellers. It applies to any contract where the performer has transferred the rights to a producer on an exclusive basis, and this producer is not exploiting that performance anymore or not at all. Of course, we have to give a reasonable time before this, oh gosh, I'm talking about the revocation right, I'm sorry. Contract adjustment, bestseller clause. When the performer has transferred the rights to a producer and in exchange for a remuneration, a fee, and then when the exploitation is taking place, we realize that this fee that we agreed in the contract is disproportionately low in comparison to the amount of revenues that the exploitation is producing. So the performer can claim for an additional remuneration. Article 21, alternative dispute resolution. The directive only requires them to settle issues regarding Article 19 and Article 20. This dispute settlement resolution may be done by public bodies or by private bodies, industry-led bodies. Only for Article 1920. Well, maybe member states' national laws may go further. And then the one I was telling you about, because I was wrong, Article 22, the revocation right. It has nothing to do with the termination right in the States, because that's after 35 years from the transfer. Here, basically, it's what we're saying is that when there's a transfer of exploitation rights that has been done on an exclusive basis, and there's no exploitation being led in the market, the performer has a right to terminate the contract in whole or in part. And as I was saying, after a reasonable time, we have to grant the producer some time to develop the exploitation. In whole or in part may also mean that we may adjust, let me use the other word. For instance, it's an exclusive transfer, maybe we can make it non-exclusive, right? So there's a lot of leeway here, and also a lot of flexibility that the directive is letting member states in implementing these obligations. As I was saying also, another question is going to be the principle of subsidiarity. Are we also interpreting this contractual corpus on a subsidiarity basis? Can member states go further and grant adjustment or adjustment for, not only additional remuneration, but for claiming other contractual modifications, right? So at the end of the day, we cannot expect a full harmonization of contract law within the EU, but that's a beginning. So let's take it with enthusiasm and positively. Let me go to Article 18. It basically states, and I'm going to say it now, it basically states a principle of appropriate and proportionate remuneration. Member states are obliged to make sure that when authors and performers transfer the rights for the exploitation of the work and performance, they get in exchange, they receive an appropriate and proportionate remuneration. How do we do this? Well, basically the directive says member states shall be free to use different mechanisms, and we will get into these mechanisms because, again, as I was saying, there's a lot of flexibility here for member states. One of these mechanisms, as Silke was pointing out, statutory residual remuneration rights. So, Article 18. It's a principle of appropriate and proportionate remuneration. Here we go to other terms, new jargon into the system, new terms that will have to be interpreted by the Court of Justice, because this will be, again, another of these autonomous concepts of EU law that will give us, I foresee, maybe I'm wrong, but lots of rulings by the Court of Justice. Usually we used to talk, when we had this principle in national laws, we used to talk about equitable, fair. Of course it's the same, we're using different terms, but the rationale is still the same. What we want, though, is that the remuneration that authors and performers get is adjusted to the remuneration, to the revenues that are being raised by the exploitation of the works and performance. What we also want is to avoid, to the extent that is possible, these buyout contracts, these transfer of all the exclusive rights in exchange for one single payment. That's what's behind this appropriate and proportionate remuneration principle. Notice a proportionate. Proportionate in some countries has been also directly transposed as proportional, and proportional may be usually translated into percentual. It's not the same. Of course, the percentual revenue is proportional, but there's also other ways to do proportional revenues that not need to be percentual. And in any case, even non-percentual revenues may be proportionate. Even lump sums, in some specific cases, flat rates may be proportionate to the contribution of the author. So there's a lot of leeway for member states. The principle applies to any license or transfer of exploitation rights. The transfer may be done in any manner, maybe in a contract, which is the normal way to transfer rights, but also through a presumption of transfer. Usually the very many presumption of transfers that we have in our national laws, especially for audiovisual productions, phonogram productions, maybe commissioned works in some countries, it applies flat to all these transfers. It applies to new as well as to old productions, transfers that were done in the past before the directive take effect, before the 7th, there's a mistake here, before the 7th of June 2021 when the directive was enforced. Only the transparency obligation is the one that that was set to a longer term of application of implementation to the 7th of June 2021 to make sure that the assignees, the producers, the owners of the exclusive rights will have time to adjust to this, providing this information. So, as I was saying, it's a contractual corpus, and basically Article 18, this principle underlies and justifies and explains all the different contractual obligations, all the other four. In fact, it's fair to say that the initial proposal of the directive by the Commission in 2016 only had 3 of these obligations, not 5. Only had the 3 middle ones: the transparency, the contract adjustment, and the alternative dispute resolution. The principle of appropriate and proportionate remuneration and the revocation rights were introduced by the Parliament during the legislative proceeding. But at the end of the day, even though Article 18 was not there from the very beginning, Article 18 very much is the reason why we have all the other obligations, right? We want authors to be and performers to be fairly remunerated. But as I was saying, it's a contractual corpus, so we need to make sure, as national legislators implement them, that if we take away from one, because as I was saying, many of these obligations, the adjustment mechanism, the revocation right, member states may exclude certain works from it, right? Maybe collective management, collective bargaining agreements also have a lot to say in this. So if we're excluding, for instance, that a contributor to an audiovisual work has a right to terminate the transfer, thus affecting all the other contributors, and that would make sense to say that in these big audiovisual production contracts, you cannot terminate that. But then maybe we have to make sure that we supplement with something else, right? So it's altogether a craft work of balancing and at the end of the day securing authors and performers a fair remuneration. And as I was saying, it's not only a contractual rule, it's also a principle that's binding for member states, binding for the parties, of course, but it's binding for member states. And member states should be doing something else than just copying the beautiful principle and leaving it there for the parties to do something with it. So, member states need to go farther, I'm saying, but how can they go farther? What are these mechanisms that Article 18 is putting at their disposal to make sure that authors and performers will be fairly, if you let me say fairly because it's shorter, remunerated? Article 18.2, this second paragraph, refers to using different mechanisms Recital 73 even stresses that they could be using existing or newly introduced mechanisms. And when we talk about these mechanisms, they are talking about collective bargaining, sectorial agreements, bottom-up agreements, of course, but other mechanisms. In order to find what these other mechanisms could be, we could go to the Parliament, the report that introduced this Article 18, as I said, introduced by the Parliament. And basically there, we have a specific reference that didn't make it to the end, the finally approved directive, but the reference to a statutory remuneration mechanisms. Of course, contractual freedom, we were saying, we need to improve our copyright laws, and copyright laws will do a lot to secure fair remuneration for authors and performers. But, as we know from experience, this will not be enough, especially in some contracts and some exploitation markets. Then we have the sectorial and collective bargaining agreements, which I believe they have a very important role to play in implementing these 4 obligations, because all these obligations need to be adjusted and fine-tuned to the different sectors, and the publishing sector is different from the audiovisual sector and the phonogram sector, and everybody should contribute to find how we better apply and implement these contractual rules to our national laws. The problem with sectorial and collective bargaining agreements is that, at least within European countries, we are not the USA. We do not have these beautiful guilds that are able to sit at the table with the producers and decide how much authors and performers are going to do. In very many European Union countries, the conditions do not exist in the market to have someone who can leverage with the producers. And also, because let's bear it in mind, even when in some countries, we have these model laws, we have these sectorial agreements, then at the end, when we have the contract for the production or whatever, authors and performers waive these minimal rights that they were in the sectorial contract, right? So it's a problem of having the conditions there to make it happen, but also making these conditions enforceable. And this is not always the case in most European Union countries. And then the statutory remuneration rights in itself, what we call the residual remuneration rights that the Voss report was referring to, and that is very, very useful. How much time? It's very, very useful in specific productions, complex exploitation markets, long-tailed exploitation markets with lots of licensees and sub-licensees intervening there, which makes the initial contract between the performer and the producer less relevant. And so Silke was telling us about the different kinds of remuneration rights. So this is one new kind of remuneration right. I'm leaving it there, I'm not gonna. Many of these remuneration rights, of course, have existed in our national laws forever, and they have the backup of international treaties, the droit de suite, the remuneration, the split share remuneration between performers and producers for secondary acts of exploitation. What we're talking about here is sort of a new kind of residual remuneration rights. We call them residual remuneration rights. They were there in national laws. In Spain, we had them before in our old law of the 19th century, 20th century application. But it was, as Silke was saying, Article 5 of the Rental Directive that conceptualized it as this idea of a residual, right? It has been used in many, many countries, and it has proven to be a good tool to secure remuneration for authors and performers. Here's a bit how it has been conceptualized. The authors and the performers have a right, an exclusive right, for instance, here, of making available online. They transfer the right to the producer. The producer is the copyright is the owner of the exclusive right of the author, the performer, and his own exclusive right, related exclusive right in many countries, on the production. And the producer license all this bundle to a licensee. Imagine a platform. This licensee is going to be the one that via collective management organizations is going to be remunerating directly authors and performers for the license that of the exclusive right that it has obtained from the producer. So at the end of the day, the authors transfer the exclusive right, but they retain the remuneration that's going to be done via collective management organizations. What's the beauty of these residual remuneration rights? That basically, they are not duplicating on an exclusive right. They have been proven to be very successful to secure remuneration. They do not turn exclusive rights into statutory rights. No, it's only when the author performer transfers and then the producer license that we have this remuneration right being paid via collective management organization. The producer is the one in charge of all the exclusive rights. He's the one who controls, she is the one who controls the licensing revenues, the authorizing which licensee am I going to authorize or not. But then authors and performers keep obtaining a flow of remuneration through collective management organization. It's very effective. It has been proven to be very effective when it's subject to mandatory or to collective management. Some countries require mandatory collective management. Welcome. It's effective when it's paid. The law says it's going to be paid by the user, that it cannot be transferred to the producer, otherwise we are caught in the original contract. And it's very effective when the law states that these rights are unwaivable and inalienable. What's the problem? That member states have to live up to the standard. They need to provide for this statutory remuneration right in their national laws. How are we doing? Well, more and more laws are, and we already had some even before the rental directive, but more and more laws are warming up to it, and they are proving that this is a successful mechanism to secure fair remuneration for authors and performers. But we have, let's not deny it, enforcement difficulties. Collecting CMOs in these countries know they have to go to court to convince producers and platforms, for instance, to pay this remuneration, which is not part of the exclusive license obtained. Maybe new countries are now also expanding this residual remuneration right. The next challenge, and then I'm going to stop here. The first challenge is that the law provides for it. The second challenge is enforcement and convincing all the parties involved that that's the best way to go. The third change, and I guess that's also when I pass the baton to my fellow speakers, is going to be applicable law. We usually in copyright law have a tendency, a tradition, to distinguish between territorial copyright law subject to the Lex Article 5.2 of the Berne Convention, and that covers the scope. What the article says, extent of protection, that is the rights, the exceptions, the scope of exceptions and limitations, the need for compensation for some of these exceptions, the term. Of course, Berne allows for a comparison of terms with the country of origin. Remuneration rights, also rather sweet, public lending right, statutory license. Traditionally, all these remuneration rights have been subject to the territorial law, the law of the country for which protection is being claimed, sought. Instead, contract law, and the rules I've been talking to you about, this is contract law, is usually subject, we're talking about criteria to decide which law applies, usually subject to the law chosen by the parties or the law closest to the contract. These rules that I have been telling you about are clearly contract law rules, but the problem is whether these residual remuneration rights, do we consider them copyright, territorial copyright, and then subject to the applicable law of the country of protection plus the national treatment clause that we will be talking about, or we consider them contract law, and then they only apply to these authors and performers that enter the contract through subject to a law, an EU law, that has these contractual clauses and these statutory remuneration rights. That's the big debate, I think a big step to decide. This is going to be the next challenge, and we will have to sort it out, right? Because depending on whether we put them in one basket or another, the solution is very different, and the amount of authors and performers that will be benefiting from these statutory remuneration rights will also vary. And that's all. I'll leave it here, and I'll...
Super, Raquel, thank you. You made a perfect link to copyright and a link, or you gave us some ideas for further reflection, of course. So, on the 8th September 2020, the Court of Justice of the European Union rendered a judgment in a case Recorded Artists, Actors, Performers, collective management organization for performers, versus Phonographic Performance Ireland, collective management organization for the producers of phonograms, the so-called RAP case. It concerns the right to a single equitable remuneration as provided for in Article 8, paragraph 2 of the Rental, Lending and Neighboring Rights Directive, known worldwide as being the mirror of Article 12 of the Rome Convention. Now, the court judged, inter alia, that a member state of the European Union cannot exclude nationals coming outside or outside the European Economic Area from the benefits of this right to an equitable remuneration, even if it concerns nationals from a contracting state that made a reservation to apply that equitable remuneration right on the international level according to Article 15, paragraph 3 of the WPPT. And thus it seems that it leaves aside Article 4, paragraph 2 of the WPPT, saying that the national treatment obligation for contracting states does not apply in the case when another contracting state makes a reservation as permitted by Article 15, paragraph 3. However, she doesn't say that without saying that such an exclusion of those nationals can be introduced by the European Union if such exclusion complies with Article 52 of the Charter for Fundamental Rights in the European Union. Now, to give or to share his reflections on the main effects of this decision, we will listen very carefully to Ole Andreas, to whom I'm giving the floor.
Thank you very much, and thanks a lot for this very honorable invitation to speak at this conference, and also for the wonderful organization by the Portuguese Alai group. I'm sorry that my French forces me to speak entirely in English. And I must also admit that it is a challenge to talk about this very complex decision in 10-15 minutes. But I'll give it a try. As Fabienne mentioned here, the case is about the interpretation of Article 8.2 of the Rental and Lending Directive, which grants remuneration right for the public communication that is non-interactive communication of sound recordings to performers and phonogram producers. And the question is, who are entitled to this remuneration? And here we have indeed a complex regulation in international conventions. And to put a long story short, the Court of Justice interpreted the Rental and Lending Directive, Article 8.2, in light of WPPT, Articles 4 and 15. As we see here, the main rule is under WPPT is national treatment, but there is an exception where another contracting party has made a reservation as to the remuneration right laid down in Article 15.1, which also has an equivalent in Rome Convention Article 12. And importantly, and I think also for the discussion here, is that the US has made a reservation for many instances of communication to the public. And Marshall Leifer will talk a little bit about the US situation here. To put it simple, according to WPPT Article 4.2, there is no obligation to national treatment regarding the remuneration right, but material reciprocity, in the sense that the obligation to national treatment does not apply to the extent that another contracting party makes use of the reservation permitted by Article 15.3 of this treaty. And that means that there is no obligation to grant US performers a remuneration right to the extent that European performers do not receive remuneration for communication to the public of sound recordings in the US. But as already said, in the RAB decision, the court concluded, the conclusion implied that US performers are entitled to remuneration, notwithstanding Article 4.2 of WPPT, notwithstanding material reciprocity. I think before going more into the legal aspects here, I will just have a look at the interests here. And of course, I think there is an underlying notion here of fairness from different perspectives. From the US perspective, of course, it's certainly good that US performers and producers are compensated in Europe for the music that is communicated to the public here, and where US performers and producers participate. From a certain perspective, that is in accordance with concepts of fairness. From a lock-in point of view, US performers and producers enjoy the fruit of their labor. They receive money for their efforts. While the opposite perspective could be here, is there any incentive left to fairness on a global level if it only goes one way? If Europe unilaterally compensates US performers and producers for the communication to the public, what incentive is there for the US to change its laws so that producers, performers, European producers and performers are compensated for the communication to the public in the US? We can see from the premises of the court that the court actually embraced that second notion of fairness. I'll just show the slide here. But on the other hand, it stated that the remuneration right, or it found that the remuneration right was protected by the fundamental rights protection in the European Charter of Fundamental Rights, Article 17.2, and also was obliged by the following requirement in Article 52 of the Charter, that the limitation on the exercise of these rights had to be defined clearly and precisely. And on this backdrop, the Court of Justice held that as of the current situation, there is no clear limitation in respect of remunerating national or third states, because the Article 8.2 is silent on that issue. And the way I read this statement, as the Commission has pointed out in its observation, as the EU law currently stands, neither that provision nor any other provision contains a clear limitation. And the way I read this means that Article 8.2 will be interpreted as implying national treatment irrespective of treaty obligation. It implies that the remuneration right applies to all performers and producers unless otherwise specified. And I will just, I don't have time to go into a thorough analysis here, but I'll just make a couple of statements regarding the reasoning here. First, I think that the reference to the fundamental rights protection under Article 17.2 of the Charter is questionable and not in line with the Court's previous interpretation of Article 17, where the Court has emphasized that the protection under Article 17 only applies to existing legal positions. In this case, the Court refers to Article 17 without having decided first whether the remuneration right in Article 8.2 applies to all performers and producers or only to nationals of third states that grant and not to national of third states that grant producers or only nationals of third states that grant producers and performers a remuneration right. In other words, it applies the fundamental right protection without having decided that there exists a legal position for all third country nationals. And this means that the fundamental rights protection applies to the remuneration right in abstracto and not as an individual right. And in my opinion, that represents an enlargement of the scope of Article 17.2, which is not explicitly reflected in the decision. In other words, I believe that Article 17 is about protecting existing legal positions as property, not about fairness on the international level. And I'm not sure whether the Court of Justice wanted to change that picture. The second problem, I will just mention it briefly, because I think that the Court of Justice does not give a proper explanation why Article 8.2 should not be interpreted in accordance with the principle of material reciprocity. And I'm not saying that they were wrong or anything here, but I don't think that they presented convincing arguments. And I think that they should have done so, especially when the court emphasized the second fairness perspective that I mentioned. But I do not have time to go further into those arguments. when we look into the effects of the decision, sorry. It is to be noted that the ruling says nothing about the retroactive effect of the decision. This is important because many EU countries have applied material reciprocity. And the question now occurs, do US performers and producers now have a claim with retroactive effect? And the problem is that it follows from the Court of Justice case law that the main rule is that rulings have retroactive effect. There may be exceptions to this principle, but restrictions may, according to the court, only be allowed in the actual judgment ruling upon the interpretation sought. And it is to be noted that the judgment is silent here, which means or implies that it has some retroactive effect. And then, of course, the question is from what date? And there are several options here that I do not either have time to go into. I just mention them here. Okay. I will also mention a point that the reasoning of the court, if you look at the reasoning of the court, it implies that its findings have general bearing for the whole field of copyright and related rights, I think. I think that the reasoning as such is applicable to the entire copyright field. And that may imply, for example, that member states are obliged to grant copyright protection for applied arts to all craftsmen, because the scope of such right is not limited in the InfoSoc directive. And I think that the EU legislature will have to make a decision also in this respect. Now looking at the EU initiatives, there is now an initiative launched this summer to amend the EU rules on rental and lending rights and certain rights related to copyright, notably this remuneration right. And in the call for evidence here by the Commission, there are certain signs that it intends to implement the principle of material reciprocity, which I will show in the next slide. The feedback time under the call for evidence is soon over, and we'll have to wait and see what comes out of it. But here it says that it states that recorded music business do not receive an adequate income and have greater difficulty in recouping their investments. Article 8.2 will require specific amendment in order to respond to reservations made by those WPPT contracting states. In any case, and that is my main point, in my opinion, the Grand Chamber of the Court of Justice created an unclear situation that could have been avoided. One, if it had taken a different point of departure. And second, not least also, that it had made some statements about the retroactive effect. And that the latter is maybe the major problem here. Thank you very much.
Thank you so much, Ole Andreas, for your critical analysis and reflection. So there might be coming something on the EU level. Marshall, yeah, from your perspective, from the US perspective, why should European CMOs pay for US performers if the US officially declares to make a reservation to apply Article 15.1 of the WPPT?
Well, this is going to be, of course, the focus of my talk, and that's a nice way of starting. But before I begin, Victor, this is just a wonderful conference. The organization was incredible, the welcome and everything about every detail. I'm so happy to be here, and I think we all share that same sentiment. Let's see, to advance. Just the green one. My talk actually has just two issues, or two parts, if you want to put it that way. I'm going to talk about how the RAP decision is justifiable from an American perspective, and I'm going to take a kind of an ethnocentric approach to that. My second part of the talk will discuss how U.S. law gives limited performance rights in sound recordings, which kind of balances the first part, because this would be the justification for material reciprocity, as we have just heard. I'm not going to talk about the intricacies of the RAP decision. This was done so beautifully by our panelist. So everything, just take everything he says seriously, and I'm going to go on to kind of another approach, another perspective on this issue. First of all, I just want to talk about terminology. I'm going to talk about performance rights in sound recordings. I'm going to focus on music. That's where the money is. And I think that's where the important kind of issues rise. This is where the tensions are created. So I think I'm going to just focus on that. The other thing in the United States under U.S. law, we don't use the term making available to the public. We use simply the term performance rights, which is a kind of the functional equivalent. So let me start by saying that, to say the least, U.S. performers and musical labels were absolutely ecstatic about the RAP decision. It was a pleasant surprise that the CJEU proclaimed that countries of the EU could not deprive U.S. performers for fair compensation for the use of their work. Many in the U.S. were reassured by the CJEU's basis of the fairness of imposing national treatment, and also that copyright is a fundamental right under the EU Charter of Fundamental Human Rights. So in a sense, the RAP case is as much about basic fundamental human rights as it is about copyright. Well, since 2020, some of the ecstasy that we had in the United States has somewhat been attenuated, and Oleg pointed that out, for the push to change EU law, and one in which would impose material reciprocity in the appropriate situation. And I guess the push to overturn the RAP decision is a serious one. Personnel in Sound Exchange, personnel that I've contacted in Sound Exchange, which is the collecting society for digital performing rights, they've told me that up to date, only the Netherlands, you might correct me on this, but this is what I understand, that only the Netherlands has attempted to comply with the RAP decision. Now, in the larger context, the RAP decision was handed down at the right moment because the US and the UK were negotiating a post-Brexit trade agreement. A broad spectrum of organizations in the United States that represented artists, publishers, musicians, and managers have lobbied for the inclusion of a national treatment in the final US-UK trade agreement. Unfortunately, in the UK, American performers whose recordings were made in the US are not compensated for broadcast or public performance rights. And so this is a bone of contention, as you might imagine, in these negotiations. I might also add that let's not just focus on Europe, that much of the same kind of problem has occurred between the United States and other countries, particularly Japan, which has balked at providing a compensation for American artists. For U.S. performers and labels, the stakes are certainly high. It goes without saying that music is a major export, American export. In Europe and around the world, you hear American music everywhere you go. You hear it on the radio, you hear it you hear it in cars, you hear it in bars. In fact, American music is the most popular in the world, averaging 30% of performances worldwide. And this is where the money issue occurs. Unequal treatment of the United States has deprived American creators of an estimated $330 million in direct royalty payments a year. In many countries are taking a free ride on American music. Now, what makes this particularly painful is that the Sound Exchange, the collecting society, has paid out $106 million in royalties to European artists, and we've received practically nothing in return. Okay, so that's my first part. The second part, where I should turn to now, is that the countries that discriminate against U.S. artists justify this discrimination based on the shortcomings of American law. And here's what I'd like to do. I'd like to kind of make an overview, do an overview of American law in this area, which is so highly complicated and convoluted. I'm going to try to simplify this a little bit. And I'm going to do so by using the example of Patsy Cline and Willie Nelson. Now, Willie Nelson created the song Crazy. It was a blockbuster hit, wonderful song, hope you all know it. And Patsy Cline, on a sound recording, her performance was absolutely incredible, and it made this hit into just an absolute colossal hit. Well, anyway, we're going to take a look at the landscape of American rights, and I'm going to do this by a chart. And this is where the shortcomings lie in American law. Now, you see up at the top row, there are what we would call the digital public performance rights, and which involve interactive streaming, non-interactive streaming, and finally the non-digital public performance right. Now let's go to Willie Nelson, who created the music, who created the song Crazy. That's within the copyright owner's rights. He gets complete control of that, whether it's interactive or even whether it's non-interactive. When I say non-interactive, what I'm talking about here is the kind of Muzak or Pandora in which you really don't select the music itself. And finally, he gets all of the copyright owner's rights, even for non-digital public performance rights. Now, this is quite different when you consider the Patsy Cline. And here, Patsy Cline has the right to interactive streaming. If it's played on the internet, streamed on the internet, and and we choose the music crazy, she negotiates this through a private negotiated agreement. Now, when it comes to non-interactive streaming, this is subject to a compulsory license. I hope you all are with me on this. It's subject to a compulsory license, and the statutory license is administered by Sound Exchange, and this is what the revenues that I was talking about before. And finally, this is where the problem occurs, the main problem occurs, is that for non-digital public performance rights, Patsy Cline gets nothing. So the $20 billion FM radio business in the United States can play her music with impunity without paying her 1 cent. And so that is the beef, I think, that Europeans have, and you might say with some justification. Okay, so what's the, if I may just end on one sentence here, what's the outcome of all of this? Well, the outcome is that there's been a push to revise U.S. law, and it's been going on for decades. And there's even a current legislation proposed by Congress to give full performance rights to performers for their sound recordings and the like. My hunch is this is going to go nowhere because of the political clout of the broadcasters, who have been able to suppress any kind of change to American law to this extent. After all, that's where the money is. This is a question of money. The broadcasters are already paying performance rights to Willie Nelson. They don't want to have to pay performance rights to performers like Patsy Cline as well. They claim that they give Patsy Cline a lot of exposure and thus create her sales, but on the other hand, this is just a pretext. But in the future, this will change. The question is when. It might take a while.
Thank you, Marshall. I'm sure that the European Union will be very happy to help the US to change things quicker. Okay, we started late, but actually we are not too late. So there's time for a first little minimalistic debate. Q&As, as we say. We heard quite some interesting things, especially about the residual remuneration right. Of course, I think we can raise questions. Questions are raised on compliance with European droit acquis. There's also the point raised by Ole, Andreas and by Marshall. Should we apply national treatment to all fundamental rights, including that single equitable remuneration? Are we talking, like Marshall was saying, is it all about money, or are there some principles involved? The floor is yours. Who wants to raise a question or to say something? If you just want to say something, be gentle, be short. Anyone who takes the floor, just say your name, say your function, and then go ahead. There's one mic coming up. Lady? Raise your hand so it's clear for the...
Thank you very much. My name's Nick. I'm from the Association of European Performers Organisations, AOP Artists. Firstly, I would like to say thank you for a fantastic conference. Secondly, I'd like to put a question to Professor Zalibada, who made a point about Article 18. And you said that a copy-paste would not be enough. My question is, for those member states that have made a copy-paste, do you believe that that would survive a compliance check by the European Commission in due course? Thank you.
Here, easier. Yeah, no. Copy-paste is good, as long as you copy-paste the principle what I'm saying is that member states should go further. The copy-paste will certainly pass the test of complying. That's easy. That's what we all do when we don't want to be in trouble with the Commission and the Court of Justice, right? But the thing here is, what I was trying to point is that Article 18 allows, and I would say expects, much more from national legislators. And that's what I say, that we should go the distance and introduce, if we have not introduced them, but they're sure for many more, residual remuneration rights, especially in these areas where we know that collective bargaining and sectorial bargaining is not going to do the trick, where we know that there's going to be lots of these contractual obligations that will not be applicable. You know, you cannot allow for one contributor to a big production to terminate a contract or to adjust the mechanism or to revise a contract, because that stalls the whole product, right? So in these cases, the only way to assure fair, appropriate, and proportionate remuneration for these performers and authors is to do something else, is to go the distance and secure, provide for these residual statutory remuneration rights that are, after the few challenges, you know, that we have all encountered, they are working and they are proving to be very effective to secure this remuneration. Because these contractual obligations, they are welcome, but they will not be enough for all performers and actors, for all sectors, and for all markets of exploitation. That's where I'm going, that we should go farther. We should not be happy just copy-pasting. But we do need to copy-paste, of course. It's a principle, and for me, it's an important principle of EU law, as important as saying, you know, that moral rights cannot be waived. This is very much, I think, a good outcome of our European copyright acquis. So copy-paste is good, but let's do something else.
Okay, next question.
Sorry, Thilo Gerlach from
No,
GV.
I was the lady, but okay.
Sorry, I thought.
Thank you. It's Irini Stamatou, law professor from Greece and Cyprus. Now, my question is the following. Do you have any information whether collecting societies, European collecting societies, are paying US performers in European productions? That's my first question. And the other question is, has the court thought in this decision that if the decision was opposite, perhaps European performance would be put at a competitive disadvantage, since someone would be more inclined to use US productions in order not to pay the remuneration? Because this is something I haven't heard of. Thank you.
Now, that's a really complicated question. Let's break it down. Your first point was, if you could repeat, please.
Whether European collecting societies are paying US performers that participate in European productions, not in US productions.
Yes, they are. They are. That's my understanding.
And the second question, we're sure about that? They are. Okay.
The second question?
And the second question is whether it incurred to the court, of course we cannot be certain about that, whether if the decision was different, the RAP decision was different, that would put European performers and European productions at a competitive disadvantage, because some people may be inclined to use US productions because they wouldn't have to pay something for them.
If the RAP decision was not decided as it was. If the RAP decision was not decided as it was, it would seem to me that this would favor, from just a pure monetary standpoint, European interests. I can't see how it would be otherwise. I've talked to people in the industry. It's kind of interesting, particularly Sound Exchanges are my informants in this whole business here. And I've asked them, I said, well, you know, if they impose material reciprocity, why are you paying Europeans for non-interactive, under the compulsory license, the non-interactive digital right? And they said, well, we really don't have the leverage to negotiate. And they said, to keep the future open, we don't want to get into these kind of this sort of reciprocal penalties on other performers, and we hope in the future that this will change and we can strike up some kind of a more generalized deal with the Europeans. And so they said they just want to stay away from those kind of wars. But to me, it seemed logical. I said, well, you know, if they're not paying us, why do you even pay them 106 million? And how much in 2019? I think about $166 million to European performers. Anyway, that's my answer.
Thank you.
Thank you. Thilo Gerlach from GBL, Germany, the Collecting Society for Performers and Producers' Rights. Let me first thank you for the conference dealing with neighboring rights. Just one remark, my understanding or the German understanding is that we are talking about creators' rights, meaning authors' rights and performers' rights. That's a bit the German approach, and I think that's developing. And so I wouldn't regard us as neighbors, but as part under the umbrella of Alai. That's just a small remark from the beginning. Regarding RAP and the US, I would like to clarify some aspects. Firstly, many CMOs pay for US repertoire already based on simultaneous publication, and even in Ireland, and this popped up to be decided in the RAP case, even there the repertoire was paid to the producer's side, who kept the performer's share. So in principle, there was a payment for US repertoire. And just to clarify, there are some member states who do not pay, but that's a real minority. There are lots of payments and they do take place, and with regard to the producers' rights, it has never been discussed in many countries. And just one other additional remark, that's regarding the imbalance of protection. It was very, Mr. Liefert, it was very instructive to see that picture, but what I was missing was the lack of remuneration right for public performance in public spaces. That's, of course, it's not digital, but in Europe, we do have the standard that any shop, any discotheque has to pay for performers, and this is also missing in US law. Thank you.
Thank you. Do I see any other hands? We have one hand, and there. Okay, we will take two extremities. First, Laurie.
Thank you. So, Lauri Reckard, IFPI. I mean, first of all, I would like to join our friend and colleague Thilo in thanking Alai for discussing neighboring rights. Long overdue, so thank you for that. Question to Silke and Raquel, maybe, mainly. You seem to be very convinced about this idea of a residual remuneration, and that would be the silver bullet, if you will, to the real or perceived problems. But I would be curious to know what is your take on the Swedish government's experts' reports that on this particular matter regarding the music sector concluded that this would not be a good idea, essentially rejecting the idea also on the grounds that there's a serious risk that actually it would hurt part of the artist community, not benefit.
Acoustically, I didn't get the rest. Also on the ground that?
Also partially on the ground that they concluded that it would likely hurt, i.e. it be disadvantageous to part of the artist community.
Well, I'm sorry, I didn't read the report.
Well,
so
I can only recommend it.
Yeah, my name is Linda Scales. I'm an Irish solicitor and I acted for RAP in the RAP case. Can you hear me now? Okay, my name is Linda Scales and I'm an Irish solicitor. I acted for RAP in the RAP case. And I did wonder whether there was anything I could say that might interest you. In fact, Thilo touched on one thing that is relevant to something I might say. First, and that is the reason why RAP took the case in the first place. The reason it took the case was because under Irish law, as Thilo mentioned, all producers, by virtue of the 30-day rule in the Rome Convention, all producers are entitled to receive the equitable remuneration. However, the only performers who are entitled to receive the remuneration are EEA performers, or where a performance is given in the EEA. So what the immediate cause of the case was the producers devised a new system. They collect the remuneration. They devised a system whereby they would keep the producers 50% of the remuneration, and then they would also keep the performers 50% insofar as it referred to non-qualifying, non-EEA performers. So as a result, RAP, instead of getting approximately 50% net of deductions, was reduced to something like 20%. So that was the immediate reason for the case. Secondly, it is also, I think, was very interesting to us at least, that the finding of the court was certainly not anticipated by any of the parties concerned. It was not argued by the Advocate General, and it was not argued in any of the observations made by the Commission or by any of the parties involved in the case. It was very much an invention of the court, and it arose, in fact, in quite an unsettling way. Our hearing was on the 4th of February 2020, and in the middle of December, just before the holiday, we got a request from the court to address 4 specific questions at hearing, thereby throwing all our preparations into disarray. But one of them was directly addressed the fundamental rights aspect. It was a direct request to address the question whether the Article 4.2 exception, the Article 4.2 WPPT exception, should apply by virtue of the fact that the right in question is a right protected under 17.2 of the Charter. So it was very much an invention of the court itself. And I did wonder whether, it was an invention, whether there was one particular member of the court that had a particular interest. I don't know the answer to that, and I wouldn't speculate, but it was very much a court invention. And then the last point, just again of interest, it was mentioned that the Netherlands is I'm not sure if that's the case, the Netherlands is the only country that has actually implemented the ruling. In fact, Ireland has not yet implemented the ruling. And as a consequence, we're still suffering, the performers are still suffering that deduction from their share in the remuneration. Thanks.
Thank you, and absolutely right to point out that the facts are very determined in this case, of course. I think the fundamental rights issue was like an earthquake for every one of us. We actually are going over the limits here, and I promised one person to have the floor. So can you be very, very gentle and very, very brief?
Yeah, I will. This is José María Montes from AISC Spain. I have a question for Marshall or Ole Andreas, and this is regarding the principle of no collection without distribution. I mean, should the Commission's latest proposal of introducing material reciprocity in the EU directive, or the 2006 directive, would that entail any collecting society to collect but not to distribute on behalf of, let's say, US performers? I mean, do you think the material reciprocity principle should apply to the distribution or to the collection? Because I think this is what we are all discussing about, even though no one has said it.
Just sure. We don't know yet what the Commission will do, but as far as I understand it, the RAP decision is about distribution. not about the collection. And in principle, the principle of material reciprocity applies to the distribution.
I think we need a coffee. Censorship. I think it's a very good point. It's a point that is really not decided yet. But can we do that now?
1 second, because I think, I'm sorry, I just need to correct one thing.
Okay.
I mean, if US performers or any other performer non-European is not protected because we will have this material reciprocity, I hope not, but let's say we have this material reciprocity, how come any collecting society would be able to collect on their behalf? If they are not protected, users should not be paying for their rights. So what we need to discuss here is whether a CMO can collect on behalf of someone who's not protected and then keep the money based on the RAP decision.
Point taken. No. Okay. Messieurs, mesdames, we definitely need some coffee. And a little pause. No, you cannot add anything. A little pause. Normally it was half an hour. You are going to shorten it a bit because we need also to be very gentle to the organizer. We want to have good points. So try to be back in about 15 minutes. Is that feasible?
Yes, that was what I was going to say. First of all, good morning, everyone. And I am glad to see this room so filled up with people interested on copyright and neighboring rights and special rights and what we are discussing here. I just wanted to tell you that we started a bit late, so we are going to shorten a bit the coffee break. It will be 15 minutes. And so I would say that we should reconvene in about 10 to noon. So it's so that we don't late.
Can I ask some applause for the first panel who was really good?
beside a fire, far away across the field. for suggestions. He's so nervous, avoiding all her questions. His lips are dry, her heart is gently pounding. Don't you just know exactly what they're thinking? If you want my body and you think I'm sexy, come on, sugar, let me know. If you really need me, just reach out and touch me. Come on, honey, tell me so, baby. Now he's acting shy, looking for an answer. Come on, honey, let's spend the night together. Now, hold on a minute, before we go much farther. Give me a dime, so I can phone my mother. They can't get to this high-rise apartment. At last he can tell her exactly what his heart meant. If you want my body and you think I'm sexy, come on, sugar, let me know. If you really need me, just reach out and touch me. Come on, honey, tell me so. Oh, no. His heart's beating like a drum, 'cause at last he's got his girl home. Come on, relax, baby, and now we are alone. Oh, they wake up down, 'cause all the birds are singing. Two total strangers, but that ain't what they're thinking. Outside it's cold, misty, and it's raining. They got each other, neither one's complaining. He says, I'm sorry, but amount of milk and coffee. Never mind, sugar, we can watch the early movie. If you want my body and you think I'm sexy, come on, sugar, let me know. If you really need me, just reach out and touch me. Come on, honey, tell me so. Oh,
halfway up your back, sliding down your body, touching your behind. You look so self-possessed, I won't disturb your rest. It's lovely when you're sleeping, but wide awake is best. Wake up and make love with me. Wake up and make love. Wake up and make love with me. I don't wanna make you, I let the fancy take you, and you wake up and make love. against my body. Get me where you want me. What happens next is private. It's also very rude. I go and get the post and make some tea and toast. You have another sleep, love. It's me that needs it most. Wake up and make love with me. Wake up and make love. Wake up and make love with me. I don't wanna make you. I let the fancy take you, and you wake up and make love. Wake up and make love with me. Wake up and make love. Wake up and make love with me. I don't wanna make you. I let the fancy take you, and you wake up and make love. Down, down, ding, down, 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 day. Down, down, day, down, down, down. We all came out of Montreal on the Lake Geneva shoreline to make records with a mobile. We didn't have much time. Frank Zappa and the Mothers were all the best place around. Some stupid with a flare gun burned the place to the ground. Smoke on the water, fire in the sky. Smoke on the water. They burned down the camping house. It died with an awful sound. A funky cloud was running in and out, pulling kids out of ground. When it all was so far, we had to find another place. But Swiss time was running out. It seems that we will lose the race. Smoke on the water, fire in the sky. Smoke on the water. Ended up at the Grand Hotel. It was empty, cold and bare, with a rolling truck, something just outside, making our music there, with a few red lights and a few old beds. We make a place to stray, no matter what we get out of this. I know we'll never forget. Smoke on the water, fire in the sky. Smoke on the water, There's a calm before the storm. I know it's been coming for some time. When it's over, so they say, it'll rain a sunny day. I know, shining down like water. I wanna know, have you ever seen the rain? I wanna know, have you ever seen the rain? Coming down on a sunny day. Yesterday and days before, sun is cold and rain is hard. I know, been that way for all my time. To forever, on it goes. For the circle, fast and slow. I know it can't stop. I wonder. I wanna know, have you ever seen the rain? I wanna know, have you ever seen the rain? Coming down on a sunny day.
It was 9:29, 9:29 Knox Street, big city. The sun was going down, there was music all around, it felt so right. It was one of those nights when you feel the world stop turning. You were standing there, there was music in the air. I should have been away, but I knew I have to say, let's run to London, just heading out. Let's run to London, just leaving town. But I really want tonight to last forever. I really want to be with you. Let the music play on down the line tonight. It was one of those nights one of those nights when you feel the fires burning. Everybody was there, everybody to share. It felt so right. There you run around, looking like you were the only one around. I had to be with you, nothing else that I could do. I should have been away, but I knew I have to say, let's run to London. Just heading out. Let's run to London. Just leaving town. But I really want tonight to last forever. I really want to be with you. Let the music play on down the line tonight. Underneath the starry sky, time was still, but ours must really have rushed by. I didn't realize, but love was in your eyes. I really should have gone, but love went on and on. Let's run to London. Just heading out. Let's run to London. Just leaving town. But I really want tonight to last forever. I really want to be with you. Let the music play on down the line tonight. But I really want tonight to last forever. I really want to be with you. Let the music play on down the line tonight.
If you wake up and don't want to smile, if it takes just a little while, open your eyes and look at the day. You'll see things in a different way. Don't stop thinking about tomorrow. Don't stop, he'll soon be here. He'll be better than before. Yesterday's gone, yesterday's gone. Why not think about times to come? Not about the things that you've done. If life was bad to you, just think what tomorrow will do. Don't stop thinking about tomorrow. Don't stop, he'll soon be here. He'll be better than before. Yesterday's gone, yesterday's gone. All I want is to see you smile. If it takes just a little while. I know you don't believe that it's true. I never meant any harm to you. Don't stop thinking about tomorrow. Don't stop, he'll soon be here. He'll be better than before.
go changing to try and please me. You never let me down before. Don't imagine you're too familiar, and I don't see you anymore. I would not leave you in times of trouble. We never could have come this far. I took the good times, I'll take the bad times. I'll take you just the way you are. Don't go trying some new fashion. Don't change the color of your hair. You always have my unspoken passion. Although I might not seem to care, I don't want clever conversation. I never want to work that hard. I just want someone that I can talk to. I want you just the way you are. I need to know that you will always be the same old someone that I knew. Oh, what will it take till you believe in me the way that I believe in you? I
Ladies and gentlemen, welcome. Please be seated again. We'll start the session. I know that it's difficult to get coffee, but if we wait any longer, we won't have any time for our session. So after the performers, we deal with the phonogram producers now. And I can introduce to you several distinguished speakers, the first of which is Professor Konrad Visser from the university. He's a professor extraordinarius at the University of South Africa, and he has the daunting task of introducing to you the global system of protection, partly based on the national reports which have been prepared for him by some Alai groups. Professor Visser, please. Thank you.
Thank you, Mr. Chair. And at the start, I would just like to thank Victor and his team for organizing this wonderful conference in this wonderful place. Very happy to be here, I'm sure we all are. So my task is to give an overview of the national responses to the questions relating to phonogram producers' rights. We received, I think, 23 of these country reports, and they're in some extent they're wide-ranging. There are a wide range of options in terms of core provisions, and there's a large extent of convergence. And the reason for that, of course, is that we operate basically within an international framework consisting of three international instruments. I'm not going to deal with these in detail, but just as a background to explain why, for example, when we come to the remuneration rights, the exclusive rights, there's so much convergence. The first place, the Rome Convention, which basically has one exclusive right of authorization, the right of producers of phonograms to authorize or prohibit the direct or indirect reproduction of their phonograms, and then the right to a single equitable remuneration, which is subject to reservations, so it was not an absolute obligation. TRIPS agreement again repeats the direct or indirect reproduction right of producers of phonograms. It adds a commercial rental right, and again there's a reference to a right of equitable remuneration, like earlier. The WPPT expands this to catalogue of rights exponentially. The right to authorize direct or indirect reproduction, the right to authorize the making available to the public of the original copies of the phonogram through sale or other transfer of ownership, the right to authorize a commercial rental, the right of making available to the public, the internet interactive situation, and then again, performers and producers of phonograms have a right to a single equitable remuneration for the direct or indirect use of phonograms published for commercial purposes, broadcasting or communication to the public. So that's the international framework. While we talk about these rights, it may be useful to remember the rationale for introducing them. And here I'm indebted to my friend and colleague, Professor Bengt Hugenholz, who wrote a very searching article about the need and the justification for these neighboring rights. And he notes that at the time when the Rome Convention was adopted, phonograms required substantial investment. Investment in recording studios, technicians, masters, record manufacturing and distribution. So there was a substantial investment on the part of the producer of the phonogram, which then underpins this related right, neighboring right. But over the last, sort of say, 10, 20 years, the nature of the recording industry has changed dramatically. So most of the successful genres like hip-hop and electronic dance music no longer require large and expensive recording studios. Often artists produce their recordings themselves. They deliver these to the music labels who are almost ready for commercialization. Physical sound carriers like CDs or memory sticks are no longer in demand. And the main media of distribution are online streaming platforms like Spotify. So it's a completely different world from the world in which first the Rome Convention, even to a large extent still the WPPT, were adopted. And the question, I think, as we go along, the question would be, this changing commercial economic background, does it still justify what we see as a required catalogue of rights producers? Or do we need to start rethinking the rationale for protection, and then with that, the entry requirement for protection, and then also the scope of protection? I think that all of that comes through very clearly in his article, which I highly recommend. Right, let's look at the surveys. I'm going to paint this in sort of broad brushstrokes. The first couple of surveys about the economic rights just ask countries to indicate whether they have these rights in their legislation. And by and large, countries have to protect these rights, right to reproduction, broadcasting, communication to the public, distribution, rental, making available to the public, cable retransmission. Interesting, in the Italian report noted that when the 2019 EU directive was implemented in legislation in Italy, the reference to retransmission in the Italian copyright law was changed to any type of retransmission technology, so to make it sort of an update to contemporary situation. There also was a question relating to direct injection. Now, direct injection didn't ring a bell for me at first. So in the 2019 EU directive, there's a definition. Direct injection means a technical process by which a broadcasting organization transmits its program carrying signals to an organization other than the broadcasting organization in such a way that the program carrying signals are not accessible to the public during that transmission. And so the interesting thing is that there are basically two physical acts being carried out. The first one is the making the broadcasting signal, and then making that signal available to someone else, who then makes that available to the public. But the directive states that all of these two acts are basically deemed to be one single act of communication to the public. Otherwise, the interpretation would have been almost creating intractable problems. In the Netherlands, interesting, I think there's a shared liability between the supplier of the signal via direct injection and the user of that signal who communicates to the public, and this is one of the large catalogue of statutory remuneration rights in the Netherlands, and also, as we heard earlier, a large number of CMOs to collect on these statutory remuneration rights. One of the questions was, is there any other additional right over and above what we listed above? In France, it's interesting, the requires the authorization of the producer for the making available to the public of the phonogram by exchange, and not only by sale or rental. So it's an extension of that right by including the exchange of phonograms. The rights, of course, are statutory, generally statutory, mainly exclusive, subject to the usual remuneration right for broadcasting and on communication to the public. And there was a question, well, are there any exceptions or limitations that generate remuneration rights for phonogram producers? Greece answered the question. It contains an interesting provision in the Greek copyright law. According to Article 18.3, there's a 2% levy on the sales of computers, portable electronic devices, tablets, and smartphones. And this levy is then distributed between authors, performers, performing artists, producers of phonograms, and publishers of printed material. So there's basically there's a price for the private copying exception, and it's an interesting way of mechanism there. The next question related to stream ripping. The question was, is this still a major concern in the countries? Stream ripping is merely a way of obtaining a permanent copy of content that is streamed online. This can be carried out on audio and audiovisual content, and in either case it's possible to create an audio-only copy of music. Is this still a major concern? Most countries said yes, but without providing any data, economic data to support that, except for two countries, the UK. One of the studies in the UK showed that 22 out of the 50 most popular music-only sites offering unlawful content or stream ripping services. So 19 of these are stream ripping sites, and 3 of them are stream ripping download sites. In the US, for the music stream, again, stream ripping is a dominant concern. For example, in 2021, a magistrate judge recommended almost a $93 million award in statutory damages after a default judgment in favor of recording labels against defendants who owned stream ripping sites. Although piracy generally is of a major concern in the US, the interesting thing is that music piracy is small fry, basically. It accounts for just over 8% of the piracy generally. So the big victims still would be those in the audiovisual industry. In Greece, an interesting provision in the Greek copyright law. Given this major concern with online piracy, the Greek copyright provides for an administrative procedure which enables any right holder who submits a relevant request concerning digital piracy on the internet to receive within at most 60 days the prompt removal of that material or blocking access to that material. So it's a way of getting sort of a quick relief. As far as collective management organizations are concerned, again, there was a wide variety of possibilities, from some dedicated CMOs administering one particular right, one particular remuneration right, to organizations which have a whole catalog of rights that they administer. The transparency and fiduciary principles relating to CMOs, again, there was sort of a wide range of possibilities, from specific legislation in the copyright law, specific provision in the copyright law for applicable principles relating to transparency and the fiduciary matters, to leaving that to a more general legislation to deal with, so not specific to copyright or the specific rights. In the United States, interestingly, again, the music industry has adopted standard identifiers recognized by the International Organization for Standardization to aid in the management of reliable and up-to-date copyright information for musical works. There are 2 standard identifiers, one of which is the International Standard Recording Code for sound recordings. So it's a way of dealing, one way of dealing with the situation without basically any policing legislation. There were concerns or questions relating to sort of whether it is known how much money these collecting society management organizations collect on behalf of the rights holders. And the indication in most cases was that yes, that these figures would be reflected in annual financial statements, which these organizations have to produce. And these statements would reflect both the income stream and then also the paying out of the relevant amounts to the rights holders. There was a question about, are there many are the sort of the notable court decisions in any of these countries? Not many countries offered any examples, and when they did, most of these cases related to the definition of terms relating to the rights of the phonogram producers. An interesting one, these are sort of cases that go further than that. I think in Argentina there was a case dealing with the constitutional validity of the law, which I think is an interesting one, dealing with the human rights and constitutional aspects of legislation of this kind. In Germany, there's the Pelham case against relating to sampling. The UK, this case, Young Turks recordings with BT stream ripping, which we'll talk about again later. And then also an interesting one, Warner Music versus TuneIn, which was an internet radio service which enabled users to access radio stations from around the world. And the US, I've already referred to the Kurbanoff case about stream ripping and the enormous amount in damages awarded. And then two of my colleagues will later talk about the Atlas Media case about synchronization rights, so I'm not going to spend any time on that. There was a question about the existence of the revocation of transfer of rights agreements in the relevant law. And there seemed to be a divergence between the civil law countries, where that may be more often the case, and the common law countries, where there seems to be an absence of this provision of this kind. And in the UK report, there was something which is interesting maybe for common law countries, that the UK courts have used two common law doctrines to basically achieve a similar result. The first one is the doctrine of undue influence, which refers to a situation where a person in a dominant position has used that position to obtain an unfair advantage, maybe enter into contracts on unreasonable or disadvantageous terms to the weaker contracting party, and thus cause injury for the person relying on to have it set aside. To have it set aside, you must convince the court that provisions in the contract were manifestly disadvantageous. So it's a very high threshold of to meet to get the relief. The second one is the doctrine of restraint of trade. Contracts that restrict the right to practice of a trade are acceptable only where they're reasonably required to protect the legitimate interest of the promise. So these relate to contracts, for example, between phonogram producers and performers, musicians, etc. And this doctrine has been successfully used in the case for George Michael against Sony, for example, to challenge recording contracts of long duration and with one-sided clauses. Now, in addition to these two doctrines, I think in civil law countries where you do not have a revocation of transfer rights agreements, it would also be possible, to my mind, to rely on the doctrine of good faith in contract. I think with that doctrine, one could reach similar results to these in the UK. Audiovisual synchronization or production music basically refers to the use of music on phonograms in television, radio, other media, background music or theme music or something like that. The question is, what was to the individual countries, sort of how do you deal with this? Most of them deal with it as an infringement of the reproduction right, but some also added to that the possibility of dealing with it under a distribution or making available right. The German courts, interestingly, will recognize the combination of audiovisual works with music as an exploitation right that can be exercised separately from other exclusive exploitation rights. And then there's the Atlas Media case, about which we'll hear a lot soon. The last issue that was raised in these reports was what is the position relating to sonic or sound branding? Sonic or sound branding is a jingle or a sound like the Nokia ringtone, for example, that represents or reminds you of a product or enterprise. The benefits of sound branding is to draw greater attention to your brand, stronger brand loyalty, and also better brand recall. Germany made it clear, I think, in their report that the rights to sound branding exist only to the extent that the sounds are protected by copyright. And again, the question was, what in terms of national legislation, what rights are involved here? Again, most countries indicated that it would be in the legal system with the reproduction right, but some, like some of the European countries, indicated it would also be the distribution right and the right of communication to the public. And I think these are the main features of the reports that I'd like to share now. Thank you so much.
Professor Visser, for this speech in which you indeed provided us with an introduction on global level, and you were very short on top, very well within the time. So the next speaker I can introduce to you is Shira Perlmutter. Mrs. Perlmutter is the US Copyright Registrar and the director of the US Copyright Office. Mrs. Perlmutter, the United States regularly modernize music, but they also have modernized music law at the moment. So this will be the subject, the US Modernization of Music Act.
Well, thank you very much. I have to start by saying I'm delighted to be back at Alai, and especially in this beautiful city, and to echo the thanks that others have given to Victor and Alai, Portugal. So it's a bit odd to be talking about US law in the context of a conference focusing on neighboring and special rights, related rights, which don't translate very easily to the American system since we don't treat neighboring rights as separate from copyright. But I will talk about developments in copyright protection for music generally, including but not limited to sound recordings and performances, even though I'm fully aware I'm going well beyond neighboring rights, but I've been assured that the broader topic is of general interest. So in the United States, the most groundbreaking development was the enactment in 2018 of the Music Modernization Act, or MMA. And this law was the outcome of many years of debate and discussion. It finally rewrote some of the existing statutory license structure in the United States, which had really become creaky and out of date, especially when it came to today's digital music services. So it fixed some of those problems, I'll talk about that, and it also did deal with sound recordings and brought older sound recordings under the protection of federal copyright law, remedying what had been really a historical anomaly. But that's not all. We've also done a number of things to improve the framework, the legal framework for music in other ways, and I'll mention those too. But let me begin by providing a roadmap of the MMA. And I will say I don't usually use slides, but these are very complex statutory provisions, so I thought it would be helpful. And we'll see how good I am at clicking on these. So to understand the changes made by the MMA, you have to understand a little bit about the statutory licenses that existed before it, and some of this was covered earlier by the prior panel. But we have one license in Section 115 of the Copyright Act that covers reproduction and distribution rights of musical works, and this was created in 1909 to prevent monopolies in what was called mechanical music, essentially player pianos, so we're really going back a long ways, And so it was called, and still is called, a mechanical license, even though there's nothing really mechanical about it anymore. And before the MMA, the mechanical license operated on a song-by-song basis, and royalties flowed through primarily one society, the Harry Fox Agency. Now, to get a statutory license, if the musical work was in the Copyright Office's records, it was fairly simple. A user would serve a notice on the copyright owner and pay royalties. If the work was not in our records, the user could still go ahead and without paying royalties if it submitted its notice of use to the Copyright Office. Now, that was all very well in the era of player pianos and even for a while afterwards, but starting in the mid-2000s, the rise of streaming services with tens of millions of tracks really put a lot of pressure on the system and showed its age. No longer made sense to do this piece by piece, work by work, and in fact, the Copyright Office received close to 90 million notices. And any notices that were missing, of course, meant that there was no license and therefore posed a significant risk of liability for these services. The other license that existed were licenses for public performance of sound recordings, and they were in sections 114 and 112 of the statute. But they only applied, as you've heard already, to certain digital performances, and that was non-interactive digital audio transmissions, such as satellite radio, simulcasting, and webcasting services. And the licenses cover both the transmissions themselves and the associated reproductions made in the course of the transmission. On the other hand, interactive or on-demand streaming is not covered by this. It's subject to voluntary licensing, as is synchronization of music in audiovisual works. And prior to the MMA, there was also no federal copyright protection for sound recordings that were created before February 15th, 1972. Now, the MMA has three titles. There's the Classics Protection and Access Act, which deals with the pre-1972 sound recordings, pre-February 15th, 1972. There's something called the Allocation for Music Producers Act, or AMP Act, which deals with how royalties are paid to music producers and mixers and engineers. And then there's the Musical Works Modernization Act, which deals with the statutory mechanical license. Now, the Classics Protection and Access Act is Title II of the MMA, and it works by providing federal civil remedies for copyright infringement to owners of sound recordings that were fixed before that magic date, February 15th, 1972. And the statute makes the rights subject to fair use and certain other copyright exceptions, not all of them, but many of them, as well as the Section 512 safe harbor for internet service providers. So they are subject to the notice and takedown system under the DMCA. Because some users of pre-1972 sound recordings may have been subject to liability under state law, the MMA also limits that potential liability if the users pay royalties. And to be eligible for the statutory remedies, the remedies of statutory damages or attorney's fees, the right holder must file schedules listing their pre-1972 sound recordings with the Copyright Office. So that's very similar to the way all works have to register with the Copyright Office to be eligible for statutory damages and attorney's fees. And those remedies are only available for unauthorized uses that have occurred more than 90 days after the schedule has been filed. And so far, we've received more than 250,000 schedules. The other aspect of the Classics Protection and Access Act to be aware of is the question of the term of protection. Now, before the MMA, these works were subject to certain common law protection, not federal statutory copyright protection, and that protection extended to 2067. So under the MMA, the remedies are now available for 95 years after the year of first publication of the recording. So again, trying to make it as consistent as possible with copyright protection for new works. And then there's certain additional periods that can extend the term up to 2067, but no longer. So it can't be longer than protection was for any particular sound recording before the MMA. And then there's an additional interesting provision that permits certain non-commercial uses of those older works, those older sound recordings. So if the sound recording is not being commercially exploited by the owner, and a user conducts a good faith reasonable search to determine that, and files a notice of non-use with the Copyright Office, and the copyright owner does not object within 90 days of the filing, then the user can go ahead and exploit the sound recording in a non-commercial way. This is interesting because it was an important part of the negotiations over the statute. It was seen as a big give for the sound recording owners, but not a single notice of non-commercial use has yet been filed with the Copyright Office. So seemed like it was important, but no one seems to be using it yet. The AMP Act, I'm not going to say a lot about this. It's technical. It probably doesn't have quite as broad an impact. So the statutory license for the public performance of sound recordings has a predetermined royalty split built into it. So half of the royalties go to labels, 45% goes to featured recording artists, and 2.5% goes to non-featured musicians and vocalists. But producers and mixers and sound engineers aren't included in the statutory division. So the AMP Act codified the practice of directly paying those parties, the producers, mixers, or sound engineers, but only if the artist or label provides a letter of direction that the royalties can be paid directly to them. So this is a bit complicated, but very specific to particular problems of particular groups. And then finally, the major section of the MMA is the Musical Works Modernization Act. And this really transforms the pre-existing mechanical license for musical works. So it replaces the old song-by-song licensing system with a new blanket license that goes to digital music providers, or DMPs. And boy, do we love our acronyms in the United States, especially in the music space. The blanket license covers the reproduction and distribution of digital phonorecord deliveries, another acronym, DPDs, of musical works, and that includes both the interactive streams and permanent downloads as well. And the license first became available on January 1st of last year, 2021. Now, it's important to know that the old song-by-song licensing system, the notice system, was kept in place for physical uses like CDs and vinyl records. And a version of the old system can also still be used by record companies for permanent downloads of musical works, and that's what the statute calls individual download licenses. And the authority obtained by a record company under one of those licenses can be passed through to a DMP, a digital music provider. And of course, voluntary licensing is still possible. So the MMA also created an entity called the Mechanical Licensing Collective, or MLC. And the idea here is that this would be a centralized administrator for the new blanket license. Now, one of the MLC's key responsibilities is to collect and distribute royalties under the blanket license. And essentially, it acts as a single source. So all DMPs send their reporting and royalty payments to the MLC, and the MLC pays all the copyright owners their royalties and sends them accounting statements. Now, to pay the copyright owners, the MLC has to match the copyright owners to the musical works that are embodied in the sound recordings used by the DMPs. And to help with that, the statute establishes a number of requirements. So first of all, there are expanded reporting requirements for the DMPs. The MLC is required to establish and maintain a free public online database of musical works, their owners, and their associated sound recordings. And the MLC is required to create an online portal through which copyright owners can claim ownership of works that have not yet been matched. And equally important, the MLC has to administer a process for equitably distributing unclaimed royalties, because there's always going to be some that they can't match to the owner. So the way it works, the DMPs now have to pay for every covered activity involving a musical work, and that money goes to the MLC. The MLC then has to do everything it can to match the musical work to a sound recording and identify the musical work's copyright owner. And then the MLC holds the royalties associated with the unmatched musical works for at least 3 years while it is trying to find the owners. And we issued a lot of regulations to govern how the MLC operates. I guess I can look here, I don't have to look up there. And our regulations require that the database contain a lot of information, and that includes the title of the work, the MLC's standard identifier, the copyright owner, which can include a collective management organization, the copyright owner's contact information, and if it's available, the data has to include the work's International Standard Work Code, International Standard Name identifiers, and interested parties information. And if it's available, the sound recording information has to include the work's International Standard Recording Codes and sound recording copyright owner information. The database has to be made available online for free to the public and also available in a bulk machine-readable format at a small fee just to cover costs, essentially. Now, how does the MLC pay people? Once they've matched a musical work to a sound recording and identified the owner of the musical work, they pay the owner, and that includes self-published songwriters, publishers and administrators, and also CMOs. And it's important to stress here that non-US copyright owners can become MLC members either on their own or through their domestic CMO or through the US affiliate publisher. And right now the MLC has 93 CMO members outside of the United States, and you can find that list on their website. So it's important for anyone who represents or advises the owners of musical works to make sure the MLC has their ownership and payment information so they can get paid properly. Now, after the unmatched royalties have been held for at least 3 years, they become what's called unclaimed royalties. And at the moment, they're holding over 400 million in unclaimed royalties. And that includes the pre-2021 unclaimed royalties that DMPs turned over in order to get the benefit of a limitation of liability for those prior uses. And those are called historical unclaimed royalties, and also unclaimed royalties under the new blanket license. So just the numbers for historical unclaimed royalties, over 424 million, and under the blanket license, unclaimed royalties for the first full year was about 150 million. So what happens is eventually the unclaimed royalties will be distributed to the identified copyright owners based on relative market share. So if they know who the owner is, it goes to the owner. If they don't, they will distribute everything based on those shares. And under the MMA, as I'd said, the first of these distributions can't happen for 3 years, so that would be 2023. But we've recommended that they take at least 5 years to gather more data and be able to maximize the matching and the accuracy of the distributions. So just to mention some other legislative activity, we've talked a lot already today about how the US doesn't provide a broad public performance right covering broadcasting of sound recordings. And there is currently pending a bill in Congress called the American Music Fairness Act, which would expand the sound recording right to include analog performances and make those performances subject to the same statutory licenses as digital audio transmissions. So I will say, again, it is the case, as has been noted earlier, that there's considerable political pressure from broadcasters that has prevented this kind of law from being passed before. Multiple American administrations and multiple Copyright Office directors have supported this kind of legislation. I sent a letter to Congress with the former director of the PTO urging that they pass such legislation at the end of the last administration, in fact, the last day of the last administration. And I continue to support it and did so before the Senate Judiciary Committee last week. So we'll see what happens. Also, at the end of 2020, we passed legislation that enhanced criminal penalties for streaming, which had not permitted felony penalties, just misdemeanors. So now the Department of Justice can bring these more serious charges against infringing digital transmission services that are offered for financial gain. And one other important development I wanted to mention, and that is that we've created a new copyright small claims tribunal in the United States. And the idea here is to make justice more accessible for individuals and perhaps small businesses that don't have the resources to pursue federal court litigation, which is very expensive and very time consuming. So Congress passed the CASE Act, the Copyright Alternative and Small Claims Enforcement Act, at the end of 2020 and gave us a year and a half to create this new tribunal, which was quite an assignment, and we managed to do it in the time given. So it's a 3-member tribunal within the Copyright Office. One of the judges, many of you know, David Carson. The judges are all very experienced copyright litigators who've represented both sides, users and creators. And the idea is to provide an efficient and inexpensive forum to resolve disputes that involve up to $30,000 in damages. And participation in the CCB is voluntary. So unlike some other small claims courts, as in the UK, a respondent who's served with a claim can decide to opt out and say, no thanks, I'd rather not participate. And that's because we have a statutory right to jury trials in the United States, so we cannot constitutionally force people to appear before the CCB instead of a federal court. I will say it's important again to note that the tribunal is available for claimants residing outside of the United States, but claims cannot be brought against non-US residents unless they've essentially opened the door by initiating a claim themselves, and then a counterclaim can be brought against them. Now, the CCB opened its doors in June, and so far about 150 claims have been filed involving a very wide range of copyrighted works, including some music and sound recordings. But what's very interesting is because of the amount of time required, so there's 90 days for a claimant once the claim has been determined to be cognizable by the CCB. Compliant is the term in the statute. They have 90 days to serve it on the respondent. The respondent then has 60 days to decide whether to respond or opt out. So since we only opened our doors in June, we don't know yet how many people will choose to participate rather than opt out. So the volume of work that the board will have still remains to be seen. Sort of an exciting point in time. So last, let me just say that one of the very big areas of focus for the Copyright Office is education and outreach. We're really very committed to making sure that the copyright system is understandable and accessible to the public. The CCB is a big part of that, and we have a tremendous amount of materials available on our website. I recommend them. We've got videos and handouts and web pages that are specifically devoted to the MMA, as well as to the CCB, and many, many other topics. But because these are complex areas with a lot of detail, I do recommend those materials if you are interested. So I will stop here. Thank you.
Thank you, Shira, for providing us with this vast introduction on many subjects of the musical copyright. That was really very interesting. Now, our next speaker comes from far away, from Korea. It's Kim Kyung-suk, and she is a professor in the Department of Intellectual Property of the Sangmyung University. I hope my accent is more or less right. She was educated in part from in Japan, where you obtained your master's and your doctoral degree. The floor is yours.
Thank you for this kind introduction. I'm deeply honored to be invited here and today and to give this presentation about synchronization right in front of my honorable audience. Synchronized is not explicitly mentioned in copyright law. Instead, it is a very practical concept used in the music industry as a form of reproduction right. However, in my home country, South Korea, the concept of sync rights has not been completely settled yet. So during my presentation, I would like to outline the Korean situation of sync right in the related context. I will begin with a clarification of the term. I'm certain that you already aware emotionally stirring music is used in movies to stimulate the audience. For this reason, movie producers must use appropriately impressive music, either original songs made especially for the movie or pre-existing music. When music is inserted into audiovisual work, the music should be synchronized in timed linear relation to the visual images. This is where we get the term synchronization. This synchronization takes place during production of many types of audiovisual work, like movies, TV shows, commercials, and is beyond into the metaverse. So more on the later about metaverse. When it comes to copyright, a synchronization right is considered a kind of reproduction right. From the perspective of copyright administration and licensing, the music industry uses this concept to distinguish reproducing music in the background of a movie from mechanical reproduction, like a CD. Even though sync right isn't explicitly mentioned in the copyright law, national case ruling and the guide to the Berne Convention interprets sync right as a form of reproduction right as follows. However, in Korea, a court ruled that a sync right is only a contractual right. Therefore, unless music creators have made sync right an explicit part of their contract with audiovisual producers, they cannot claim the sync right from the producer. When it comes to copyright management regarding reproduction right, the mechanical reproduction rights can be administered by CMOs because mechanical reproduction may not involve the derivative right or a moral right like the right of integrity. However, synchronization involves the derivative right or the right of integrity is where a part of music is mutilated or music is used in scenes that are deemed inappropriate by music creators. So, sync rights are generally authorized by music creators or the music publisher to prevent the future problems such as the infringement of the derivative right or the right of integrity. And due to this, the first step for successfully is using music in a movie or as a TV show is to clear the sync right by getting a license from a qualified licensor. Here, a key question is whether or not CMOs are qualified to license the sync right. It seems to differ from country to country is as to CMOs are qualified to license the sync right. In the United States, CMOs do not represent the sync right at all. For example, ASCA web page states synchronization rights are licensed by the music publisher to the producer of the movie or program. On the other hand, CMOs in some countries, it's like MCPS in the UK, Gemma in Germany, and just like in Japan, represent synchronized where songwriters or as composers consign their synchronized to the CMOs. If not consigned, as a CMO only serves as a link between users and composers. So, however, in the Korean corporate management, it is a different case again. There is no distinction between synchronized and the mechanical reproduction rights. So all forms of reproduction rights are assigned to CMOs where and when music creators join the association. A phonogram producer's license for synchronized usually occurs when they're using pre-existing music on the phonogram. This is a master license. When using phonogram audiovisual producers should get a master license from phonogram producers as well as sync license from composers of work on the sound recording. And so next is equitable remuneration after getting sync right fee. So where a phonogram is broadcast or communicated to the public, the phonogram producers and performing artists on the sound recording are qualified to request the singer equitable remuneration. This equitable remuneration is provided in the Rome Convention Article 12, the WPPT's Article 15, and the Rental and Lending Right Directive Article 2. However, here a question arises whether this equitable remuneration is also due when phonogram inserted into audiovisual work is broadcast or communicated to the public. Then, in this case, the CJU decision address media. So in this case, the issue of equitable remuneration was the core of the conflict between the Spanish broadcasting company, Atlas Media, and the two Spanish collecting societies for phonogram producers and performing artists. The court first noted equitable remuneration represent compensation for the use of phonograph. As the court went on to examine what the concept of a phonogram is. Since there is no definition of a phonogram in any of EU directive regarding copyright law, the court had to take a look at the international laws. Then the Rome Convention Article 3b defines phonogram as any exclusively oral fixation of sounds of performance. And WPPT Article 2b defines a phonogram as the fixation of the sounds of performance other than in the form of a fixation incorporated in a cinematographic or other audiovisual work. Based on these definitions of a phonogram, the court held as phonogram inserted into audiovisual work cannot be classified as a phonogram for the purposes of seeking the equitable remuneration. After the related right holders get this incorrect. As a result, the phonogram producers and performing artist cannot request the additional compensation that is equitable remuneration after they get the sync right fee. So over the last few years, even in Korea, the phonograph producers and performing artists have requested the additional compensation, that is equitable remuneration from platforms for the audiovisual work. So, however, this EU case law also will be a very good reference for Korea so when resolving the conflict between the related right holders and the platform businesses. Now for the future of Synchrite. Virtual worlds like metaverse will surely be the next platform for the music industry. Music in metaverse seems very similar to traditional synchronization. So metaverse types of platforms will offer the potential sync market to the music industry. Therefore, we can expect the sync market will be booming even in the future. Thank you very much for your time and attention.
Kim Kyung-suk, thank you very much for your clear introduction. Now we have a last speaker after this, and this is the head of the global department of the IFPI? Chief Legal Officer. Sorry, okay. Well, go ahead. The floor is yours.
And to begin with, thank you also my part to the organizers having me and organizing, as I think I've already said, organizing a conference on neighboring rights. Highly appreciated. Share could operate this, maybe I can also. Yes. Just a couple of words about IFPI. For those of you who may not know us yet, we are the international association representing the recording industry worldwide. We represent some 8,000 record companies in over 70 countries through our network of national groups. We also work with CMOs, or music licensing companies, MLCs for short, in actually over 80 countries now. And the MLC should not be confused with the mechanical license collective that Shira just mentioned. But with those words, CJEU, Professor Kim already very accurately referred to what's in the decision, but just kind of a reminder, essentially what the CJEU in the Others Media decision said, that after a sound recording has been incorporated, i.e. sync, in an audiovisual work, then the TV broadcaster using those audiovisual works does not have to pay equitable remuneration referred to in Article 8.2 of the Rental Directive. So a couple of, sort of trivial maybe, but important observations about essentially the scope of the decision first. The first point is, it actually, and it's in paragraph 46 of the decision, for those of you who want to take a look, it deals with situations where the synchronization or the incorporation has taken place with the consent of the right owner. Second point, it only deals with the remuneration rights enshrined in Article 8.2 of the Rental Directive. And that is an important point as well. So, is Atlas Media good law? Well, yes, it is, in the sense that it is the decision from the CJEU, the Court of Justice of the European Union, which is the final arbiter of issues dealing with the interpretation of European law. Having said that, interestingly, it seems that other conclusions would also, or could also have been possible. And I'm referring to a High Court of Australia decision from 1998, which essentially looked at exactly the same situation and came exactly the opposite conclusion, and looked at also the Rome Convention and the obligations under the Rome Convention, essentially noting, well, whatever the interpretation of the Rome Convention Article 12, it only sets the minimum standard for protection. So, good law, but arguably not very good policy. And 3 points of concern that really stand out. The first one is it creates significant legal uncertainty and creates a very convoluted, if you will, web of analysis that the users and right owners need to go through before establishing is the remuneration under it to do or not. The second point is, as a result, it also arguably disregards the objectives of the EU law, or the EU copyright law. And then last point, and maybe this doesn't go well in this audience, it actually creates an unjustified discrimination between the holders of related rights and authors of works. So a couple of words on each of those points, just to kind of to show what I meant with this complexity. Essentially, now what you have to do is to first look, has there been a synchronization with the consent of the right owner? If yes, has the incorporation taken place in an audiovisual work, or importantly, in other audiovisual fixation, which doesn't meet the work threshold? And then if we are in the left corner, then it means there's no remuneration due. If we are in those other situations, then actually, yes, the TV stations still have to pay the equitable remuneration, and in some cases, obviously, if there is no sync license and no ephemeral exception, for instance, that would entitle the TV broadcaster to use audiovisual recordings without the sync license, then that would be a phonogram, arguably, under the court's analysis. So, complex, costly to manage. Second point, as said, I would argue that it does disregard the policy objective of EU copyright law by not providing adequate high-level protection for holders of related rights. And as said, it is interesting to read the High Court of Australia decision, which again also considered that point and came to exactly the opposite position, saying that if the right owners could not control the subject to the consequent broadcasting of the recordings in the soundtracks, that would then expose significant numbers of uncontrolled and unremunerated exploitations. And the third point, discrimination between authors of works and holders of related rights. When a musical work is synchronized in an audiovisual product, work, then of course all rights remain, and they can be licensed either at source or subsequently, depending on the contractual organization arrangements. When we are dealing then with sound recordings under the ECJ decision, when incorporation takes place into an audiovisual work, then it means that magically some rights disappear, others still remain. So, where are we and where do we go forward? Now, interestingly and helpfully, as said, if we look at the international treaties, as regards to the public performance and broadcast rights, the treaties actually only set the minimum level of protection. So member states, contracting parties, can go beyond the minimum level. And the same applies arguably also to the rental directive, i.e. the European law. So in order to avoid the negative policy impact of this decision, I think it makes sense for EU member states and countries more broadly, including Korea, to actually set their own national level of protection and go beyond the mere treaty minima and ensure that sound recording rights remain also after their incorporation into audiovisual works. And I hope I made it on time. Nothing happened. Thank you.
Thank you, Laurie Renkart. Ladies and gentlemen, we're running a little bit out of time. Is there still time for Q&A, or I see that... Okay, just one question. Yeah? Is there a micro somewhere?
Thank you for the intervention. I am Paloma Lopez from AIE, the Performance Music Society in Spain. My question is for Shreya Perlmutter about this letter of direction case, because we have been studying the case and we don't have the certitude about the application of this kind of letter of direction. Should it be only, I understand it's included in the US law, and the principle of territoriality would apply when we are speaking about the rights that are issued by the legislation in the US for all of these right holders, let's say. But in our view, would it be only applicable to the US source of rights, or do you think that it could be spread around the world because of the exploitation of the phonograms? Thank you.
That's a good question. I would assume, and I'm venturing out on a limb here, but I would assume it doesn't just apply to U.S. parties. But what I would suggest is I can put you in touch with the people who are really the experts on this in my office, who've spent a lot of time involved in the negotiations and the discussions.
Okay, thank you.
Thank you, Raquel Xalabarder from the Universitat Oberta de Catalunya. I have a comment more than a question, and please do not take it in very good faith. It's for the IFPI representative. I very much agree with you that address media is bad policy. I would even say it's bad law. The Court of Justice is not always right. And we have had two examples today, the rap case and the address media case. Maybe we should start questioning or be careful what you ask for, right? Because maybe you don't want to hear the answer. But having said that, let me just make a little comment on, especially because of your comment in the previous panel. I understand that you are very much in favor of remuneration rights when this benefits producers and performers in the case of synchronized phonograms into an audiovisual recording, because the phonogram producer and performer, they are not in charge of the exploitation of the audiovisual recording. But instead, in the previous session, you were very much reluctant about implementing residual remuneration rights. Welcome, because this is precisely the situation that authors and performers are once they have transferred their exploitation rights. I know you will have an answer for that, but please let me point at the discrepancy in a position. That's the position that authors and performers are very much in when they have transferred all their exploitation rights. They are not in control, but they still want the remuneration. So just please take it in good faith, but I think it was worth pointing it out.
Thank you, Raquel. And you know what? I was expecting that. No, look, the point really is, obviously we would love to have exclusive rights that would remain. That would be the best position, because exclusive rights provide the strongest negotiation position against the users. There's no doubt about that. Unfortunately, the minimum level in Europe in this respect is a remuneration right. Do we believe that's fair? No. But it is what it is. And better to have remuneration rights than nothing. But clearly, I fully agree with you, we should have exclusive rights. And then obviously, then parties can negotiate. And in some cases, yes, maybe it makes sense to negotiate all rights free at the point of sync. In some cases, not. But under the CJU decision, that is not possible. So right owners are deprived the possibility to negotiate fair deals, whatever they may be. And obviously, remuneration right also takes away that freedom to contract the best possible deals with the users. But thank you for the question or comment.
Okay, thank you. A very strong conclusion to dwell on. Thank you very much for coming. We're running out of time because everyone is hungry, so let's go to lunch.
One housekeeping information. Let's try to reconvene at 3 p.m. if possible. Lunch will be served in the room that will be pointed out by our hostess. And I will also recommend that you ask for the tour to Mafra, to the National Palace of Mafra, is already available for Sunday. For those of you who can stay until Sunday, it's a full day tour to Mafra and Queluz. So if you are staying with us long enough, I really recommend that you ask for this tour. It's not to forget. Thank you very much.
Ladies and gentlemen, please take your seats. We are going to take off in 2 minutes. Fasten your seatbelts. You shouldn't put your table in upright position because you don't have it. We have only table here, but we need it. You have got table? Sorry, but important, you shouldn't put it upright position. So, ladies and gentlemen, there is a very short announcement.
Before we start our work this afternoon, just a very short reminder to you. Do not forget, after the end of our meeting today, that there is still another event, and that at 8 o'clock we can meet again, and you are invited together with your partners at Palacio Estoril, not here, but at Palacio Estoril. At 8 o'clock it will be a prize award ceremony whereby we will be careful not to be long with speeches, but instead having marvelous music by two famous performers of Portugal, Julio Pereira and Carlos Mendes, and also a nice cocktail with something accompanying the cocktail. So thank you and see you then also. Sorry.
So, ladies and gentlemen, mesdames et messieurs, señoras y señores, I have the pleasure and honor to open this session of panel 3 on the rights of broadcasters and film producers. I have been thinking of what is the reason that these two categories of rights are linked together in the program, and I found a simple answer: television. Both broadcast programs and films appear on screens, television screens, but now not only on television screens, but also on the screens of PCs, tablets, also everything, mobiles and so on, with the related problems, challenges and legal issues. And the other thing is that I think that in both categories, the differences between the two basic systems, the common law just copyright on the one hand, and the civil law related rights systems, seems to be more significant, with some tricky borderline issues. And if we really address those issues and turn down some stones, we could see very interesting things under this law. I don't recommend that we do so, and we should rather proceed in the spirit of the slogan of the next first speaker, Ted Shapiro, aka Mr. Peace, Love and Copyright. He's a keynote speaker, and I'm sure that in addition to his excellent presentation, there will be some touch of love and also fun and humor, which is very much needed in this post-lunch period when people in general rather use the time for siesta. You have got the floor.
Thank you very much, Mihaly. Good afternoon, everyone. Thank you so much to the organizers at Alai and Alai Portugal for inviting me. It's an honor to be up here and to see all of you and get to talk about one of my favorite subjects, copyright. Although I admit that I'm not a big fan of related rights, but yeah, they're all right. So I'm going to try and give a bit of following really how the earlier reports, give a bit of an overview of the broadcaster situation based on the replies. Same with audiovisual producer rights. I thought it would be interesting to add a kind of EU-level look, and then talk about some trends and issues. In approaching this, I was trying to think, where do audiovisual producer and broadcaster rights sit? Where do they belong? And if you thought about where did they belong in medieval society, where, you know, they the king and the church, were they towns and guilds, were they just serfs? Really from the copyright and related rights perspective. So we know broadcasters and audiovisual producers tend to be rich. They're not always rich. You have a lot of small indie producers. So where would they fit? And that's really for you guys to sort of chew on and what you think. I mean, obviously the authors are the king. They got to be the king, the authors. But of course, who is the author can vary from country to country, as we know. I guess another way of looking at it is which side of the tracks do the producers and the broadcasters live? I've always thought really about copyright and related rights as related rights were these like rights that live on the wrong side of the tracks in Autorsburg. But of course, you know, there are lots of very different categories of related rights, and I don't want to get into the hierarchy of rights without causing a bloodbath that goes against the notion of peace, love, and copyright. And in fact, when it comes to the related rights that I'm talking about, or the rights that I'm talking about, it's actually copyright, related rights, or special rights. It's all of the above when it comes to these categories. If you look in aggregate at the replies that came in from the various Alai members. 22 countries last time I checked, most from Europe and Middle East. We got 13 EU members. The Swiss pitched in, the Brits pitched in, and the Israelis. From North America, we've got the US and Mexico, the South Americans, Argentina and Colombia, and from Asia, Japan and Korea. When we think about giving rights to these categories of right holders, I guess we're thinking about what do we want to achieve. And when it comes to giving rights normally to the economic operators like broadcasters or audiovisual producers, it's normally about incentivizing them to invest in the content, to give work to authors and performers. And has been mentioned before, of course, and because this is Alai, we have to think a lot about how we reconcile differences between different legal traditions, the two predominant ones in particular. So, with respect to broadcasters' rights, the survey says that they usually have exclusive economic, statutory, neighboring rights, or sometimes we call them related rights. The object of protection tends to be their signal, although if you've ever been to a WIPO meeting, you can listen to the delegates talk about what is the object of protection for broadcasters. They've been talking about it for like 30 years now. So there is a bit of a debate on that matter. They sometimes have full-fledged communication to the public rights. They usually have making available rights and a number of other post-fixation rights. Turns out they don't often have protection for pre-broadcast signals. The US, for example, does not have a distinct related right. If the broadcaster is the producer, he's likely to have copyright by virtue of the work made for hire doctrine. We see that presumptions are not usually the practice with respect to broadcasters, unless, of course, they are also the producer. Turns out that piracy is mostly a huge problem. There were one or two that said, oh, it's not that big of a deal anymore in our country. Victor's going to talk about that more. With respect to their content on UGC platforms, that is generally a contractual issue. We haven't seen anything like the crazy stuff that the Belgians and the Germans have done with respect to statutory remuneration rights in the context of Article 17 when it comes to these rights holders. With respect to litigation and jurisprudence, again, this varies heavily across the different replies that came in. We do see a trend for broadcasters to challenge new technologies that are trying to use their content without clearance. And so there's been quite a lot of litigation in that area. I'll talk a little bit about it more. With respect to the one-stop shop, generally the answer is no, although in some countries it is theoretically possible. So there's a quick sort of run-by for broadcasters. With respect to the audiovisual producers' rights, the survey says that they also often have exclusive economic statutory neighboring right. They also have some remuneration rights, it was mentioned earlier. For example, for private copy, in some cases they have statutory remuneration rights on top of for retransmission. Again, in the US, the work made for hire doctrine consolidates the rights by operation of law into the producer, so they have copyright. There are other permutations. The Argentinians have another system where I believe that the producer is the co-author. You have a similar thing like that in the UK and Ireland, where the producer is also considered the author, I believe. There are, in most territories, except for in the US, where of course it not really necessary, you have presumptions of transfer. Usually they leave behind remuneration and moral rights. Raquel wants them to be unwaivable, unstoppable, inalienable, etc. I would argue, though, that in countries where the presumption of right was scooping up the full exclusive right before a remuneration right existed, when the producer acquires an exclusive right minus a remuneration right, he's getting less. So maybe he'll start paying less, and it'll come out the other end because the pie rarely gets bigger. Again, with respect to UGC, again, it is mostly contractual. For piracy, see Victor. For Windows, see Victor. For the piracy window, see France. With respect to CMOs, there are a lot of audiovisual producer CMOs out there. They tend to be regulated. For example, in the EU, of course, we have the CRM directive. With respect to litigation and jurisprudence, specific cases were not widely cited, but there are some out there. With respect to the one-stop shop vis-a-vis retransmission, generally not the case, and more generally, it's less and less that producers are a one-stop shop at all, because it's becoming harder and harder for them to consolidate all the rights because of all of the legislative interventions to prevent that. So I thought it would be interesting to talk a little bit about the EU level. Broadcasters have related rights in the EU. They've had them for quite a long time, and the world still continues. We could tell them that in Geneva. They don't have a full communication to the public right, and we learned just recently that they don't have a retransmission right. They do have a broadcaster veto, so I thought you could have argued that in order to have the veto, you needed to have a right in the first place, but of course they also have other people's rights. So the Court of Justice, in its wisdom, has said that they don't have a retransmission right. There's this thing called direct injection. I'm still trying to figure it out. I've lately been trying to figure out where it happens. Where does direct injection happen when the channel provider is in one country, he's registered in another, and he's delivering his signal to distributors in multiple other countries? There's a single act of communication to the public for which both the broadcaster and the signal distributor are responsible, but where did the broadcaster side of it, for example, where did that happen? Was it in their country of origin? So there's a lot of questions around direct injection, going to be a lot of great discussions with collective management organizations across the EU. And as is the case that we heard it earlier, member states can go further with respect to the related rights that they give to broadcasters. We saw that in the Seymour decision. There have been many cases before the Court of Justice. A lot of the broadcaster ones are around things about the scope of rights. In some of the cases that I've been involved in with broadcasters, it's funny because sometimes there are other rights holders that are pushing for a broader exception because of the link to the remuneration right, and if they win, it weakens what the broadcaster has. So I'm thinking about, for example, whether private copy applies to catch-up or NPVR. In the VCast case, they said no. But in the meantime, Some broadcasters would like to get their snouts into the private copy levy trough, and in Germany, they brought a case in order to get private copy levies, and that case is up before the Court of Justice. In the AKM Canal Plus case, we may get some ideas about where certain acts of communication to the public by satellite take place. The Australian case is about ketchup that I mentioned before, and recent decision, the RTL one I mentioned. We had a great debate about address media. There's also a Canadian Supreme Court that went the same way as the Court of Justice, I think, in that, but I'm neutral on those matters. SBS case that said that that needed to be overturned with direct injection, ITV case, and so lots going on. More recently, broadcasters have been, along with sporting events organizers, have been arguing to the European Commission that a specific instrument is necessary to deal with live event piracy, and that's an ongoing debate. On the audiovisual producer-related rights side, they have rights in the first fixations of their films. Again, they don't have a full communication to the public right. They don't have a retransmission right at EU level. They do have private copy levy, remuneration right, and member states can go further. Of course, they have the making available right. Generally, they control the author and performer rights. This was mentioned this morning about the importance of the producer being able to consolidate all the rights in order to finance the film, produce it, and distribute it. That ability to consolidate is challenged by a lot of recent legislation. They tend to be less litigious at the EU level. There's a Luxon case, a kind of contrived case that came up between a producer and a director that really killed any notions of work made for hire in Europe. Too bad, too many rights holders, too little time. There's the UPC, which is site blocking case. Interesting issues going around now with audiovisual producers in the context of the copyright that ought to be retained by independent producers. Increasingly, particular smaller audiovisual producers find themselves caught in between bigger platforms and more powerful author performers armed with lots of new protections. So those poor, starving producers living in the cold part of Copyrightsville. Yeah, I know it sounds unlikely. But anyways, so trends and issues for discussion. The audiovisual sector is a global business, but what's on the horizon? It seems to be booming at the moment, but of course there is a delicate financing system. It's a risky business, and there's this thing called artificial intelligence out there where you can just tell the computer the movie that you want to make. It could put us all out of work, except that we have to figure out the copyright implications of artificial intelligence. If artificial intelligence can't make an audiovisual work, I suppose it could maybe make an audiovisual fixation. There is no audiovisual producers related right treaty. I would say, so what? We don't necessarily need one, but we do need to ensure protection for audiovisual producers because it's a global business. There are two systems that dominate. Sometimes they conflict. Really, in my career in the last 25 years, as a disclaimer, folks, I work for a lot of big studios, platforms, broadcasters, all these bad guys. And many of them are based on the other side, not all, but many of them are based on the other side of the Atlantic, coming with another conception of copyright. And my job has been for really the last 25 years trying to fit those two things together. And it's mostly doable, but there are sometimes conflicts. And we've been talking about them, some of them today. Mihaly mentioned some different points. There's the question about whether something is an audiovisual work or a fixation, with, of course, the implication that if something is a fixation, it has less protection. Is this something that we should worry about? I haven't seen a lot of practical difficulties with that in my career, but I do believe that there are things that could happen. private international law. Now, there's so many different areas. Well, we should always talk about jurisdiction first. The court has, let's assume the court has taken jurisdiction, and now they need to decide which law to apply. This can come up in so many different possibilities. The big discussion I'm seeing where I'm getting millions of questions about, and I think it was Raquel alluded to it a little bit earlier, when it comes to the new remuneration provisions in the 2019 directive, there's a provision that says that 2 of those rights are not subject to contractual override. And then there's a reference to the anti-circumvention rules in the Rome I Convention. And that says that where all the elements are European, you can't choose another law to apply. But then we get all these questions when not all the elements are European. And there's going to be a lot of stuff. Exclusive rights and contractual freedom seem to be an endangered species if you watch the legislative developments in the last few years. Everybody wants a remuneration right. Boy, they're all the rage. The producers are screaming for remuneration rights. They spent the last 20 years saying that the authors and performers shouldn't have them. You heard Laurie get twisted around a little bit, but he came out pretty good, I thought, when Raquel came after him there. But everybody wants a remuneration right. Everybody wants a piece of the action. Everybody wants protection from bullies. But you know, there's always somebody bigger out there. There's always going to be somebody bigger out there. And so it comes back to the question, what is the best formula to incentivize creation? And yes, you're right. It is exclusive rights. It is contractual freedom. And I will leave it there and only make a pointer that when it comes to broadcasters beyond Rome, see Gustavo. Thank you very much for your attention. Peace, love, and copyright to you all.
Thank you, Ted. Once I have received a Creative Commons license from you to use your slogan, I don't want to receive the same for the pictorial presentation because it will be a trademark certainly or something like that. But your way of referring to one-stop shop, please give it to me. Yes, thank you. Now, the next speaker would have been Commendatore Paolo Marzano, but unfortunately he was not able to join to us. But what a great consolation, ladies and gentlemen. Victor, in addition to having masterminded and organized this great Congress and also being a generous host, he has also volunteered to replace Paolo here. I think, ladies and gentlemen, these so many contributions to Alai, you, the participants, I think that this is really the time to give him a big
Bravo, bravo, bravo.
Thank you very much. Thank you very much. I would say it is, thank you very much. It is customary to thank the organization for having invited me for this wonderful, but it just would seem a bit awkward, so let's skip this part. Even because it was at a short notice, a very, very short notice. I hope Paolo Marzano gets well soon. It's nothing serious. But let's talk a bit about piracy and exploitation windows, which was the subject that was assigned to Paolo Marzano and that I took a step in. Well, we will talk about the answers that we received from some of the national groups in relation to windows and piracy. We will try to speak about how to enhance protection of audiovisual producers in the international framework of copyright and neighboring rights protection. We will try to give some suggestions in relation to how to reduce the streaming digital gap along the audiovisual value chain. What do I mean by this? We know that we are in a new world where consumption is based on streaming, and how easy it is to get income from stolen content. So we really should look at where the money is going, because it certainly is not covering for the investment that audiovisual producers make, and they are the ones that are taking the risk. So my idea is that we should look at where the money is going to. So basically, in relation to the answers that we got from the national groups, France has the Windows system that is more recent and is very, very interesting because it's based on an agreement. Some of the players entered the agreement and got shorter windows, and other players did not want to join the agreement, and therefore they are stuck with longer windows. They have to wait longer to begin exploiting. So Netflix, for instance, accepted to promote and invest in national content, and so the window was shortened to 15 months after theatrical release. And Prime Video and Disney did not want to join, so they are stuck to 17 months. The free TV window begins at 22 months and ends at 36 months after theatrical release. In Greece, we have 30 to 90 days from theatrical release to DVD and VOD, which is the next window, and then 90 days before the pay TV starts. Italy, also 90 days, but it was reduced to 30 days during the pandemics for obvious reasons. Now, in relation to quantifying the damage caused by piracy, we also had very interesting responses based on studies, which you can look at in this slide. I would call your attention to South Korea, where it has been concluded that 25.9% of the total amount of content available and 38% of total movie content available is illegal. So it really is an important slice of the whole market. The numbers are astonishing, and you can look at them in the slide. But this is what I would. And another conclusion that is interesting is that in the US, which is the first one, as you shall see in piracy numbers, 26.6 billion illegal viewing for movies, but 126.7 billion for television. Television is now the most significant victim of piracy. Now, it was also, in movies, it was also a reflection of blockbuster films that were released later because of the pandemics. Now, the ranking of piracy per country is before your eyes. The US, Russia, India, China, Brazil, France, Turkey, and so on and so forth. In the ranking by object, as I said, television is the first one. Then comes publishing, that is important also, and then film, music, and software. These are some numbers that Muso found. 52% of video piracy in 2021. This represents an increase of 15% over 2020. 95% is streaming, 65% is direct access, but 28% is search engine result. So this helps to see what is the role of search engines in making piracy easy. Now, how can we minimize, because we can never avoid completely, the above referred damages? There are several solutions. First, acquiring anti-piracy technology. So welcome back DRM, watermarking, fingerprinting. This must be strengthened and updated against any content leaks. Intelligence gathering, subscribing to security services that are available on the market. Anti-fraud services, hiring know-how, delisting pirate websites from search engines. But this is just a part of the solution. It's incredibly easy to acquire services that mislead the users as to the legitimacy of content. Pirate content is like illegitimate content. You cannot tell the difference. And sometimes it's even better in terms of quality. And it also does not know any borders. And technologically, sometimes it's easier and it's faster to download or to stream content from pirates' websites. They are very, very, very ahead in terms of technological advance. The consumer wants to have access to the whole offer of contents without having to subscribe to different services, because it's very expensive. And this is where the pirate enters, because it offers the consumer all the contents available without having to pay. Now, how to enhance the protection of audiovisual producers in the global framework? Now, we should start by reviewing the definition of audiovisual producers, because there is no audiovisual producers as such in the international framework. In Europe, we have directives that are giving producers of the first fixation of films some rights, but this no longer reflects the reality of audiovisual producers. Film producers is not the same as audiovisual producers. The audiovisuals are the entrepreneurs who assume the financial risk of investing in the production of audiovisual works. Could be a film, but it could also be a different series, serial, or a documentary, or animation, or whatever. The category as such was not protected by the international framework, and it finds some room for protection only when the member states or the member states through the treaties award copyright to audiovisual producers. There are several countries that award copyright either originally granted or acquired from authors. So basically, audiovisual producers can be considered authors in some countries. In other countries, they are just equivalent to phonogram producers. In Europe, this is mostly the case. Luckily, most national legislators award them a status equivalent to that of phonogram producers. Generally includes communication to the public in public places. But this right is absolutely essential and is not granted by the European directives. It should be, but it is not. They have the right to make available, right of lending, reproduction rights, but they don't have the great communication right, communication to the public right, which is the basis of several other rights, as it is, for example, in France. So this is one thing that the legislature should look at. The notion of film, technologically limited. Film is a cinematographic work or a fixation technique. Now, the notion of audiovisual production should encompass any material support, analog or digital, of images, accompanied or not by sound, through which the visualization of the audiovisual work by the existing technological means is possible, as well as any other means of fixing, making available, or interactivity that may be determined by technological innovation, as well as video games, which are made available via the internet. So, various studies are clearly demonstrating the role of the producer. The producer needs to recoup investment, and they should be expressly granted the right to communication to the public, which would include broadcasting, retransmission, and keep those rights that they have. Now, in addition, and this is very important, without legalizing unauthorized reproduction or making available, international legislators should start thinking about creating an equitable remuneration for audiovisual producers at the expense of those players who actually benefit from illegal streaming of content. I'm not saying the pirates, I'm saying those that work for the means, the infrastructure, and the technological devices that actually enable piracy, such as the electronic communication operators, providers of proxy service and VPN services that are really mostly used for piracy purposes, providers of IPTV services generally are illegal as regards content licensing, and also advertisers. Today it's very easy to find out how much money, and is absolutely huge, like $100 million a year, very easy to get from CyberLocker, for instance. It could be something inspired by AVMS, because what we have in AVMS is we look at the content sector and we look at the carrier sector and we say, these guys need content. And as they need content, they need to invest in content. So in order for them to have their activity working and producing income, they have to invest part of that income into producing content. And this is the idea that could be imported for copyright and related rights. It must be updated. It is no longer adapted to the world of streaming. It's a new form of private consumption that may involve reproduction and making available, but we cannot charge the user, the final user, and we do not want to chase our consumers because they are our fan club. We do not want to charge them. So what we need is to find means to finance the existence of content. This is what I think that should be done. Now, in a set of very quick conclusions. So audiovisual producers need more legal certainty and a future-proof definition. By the way, the definition that I read is actually the one that we have in Portugal. I think it's quite broad and encompassing. Exploitation windows. Exploitation windows are likely to disappear because over-the-top television is quickly gaining domain over the market, bargaining for short time lapses in relation to the theatrical release. Damages, they will always exist. They are very, very significant, very, very high, but we could probably try to find some means to minimize those damages. These are new forms to follow the money. This strategy should be envisaged to bridge the value gap existing between those who produce content, invest, need to recoup it, and those that actually benefit from the existence of content. As I told you, AVMS could be a sort of inspiration. Thank you very much.
Thank you very much. Ladies and gentlemen, there was a period before the Congress when it was possible that we would remain alone with Ted on the podium, which would have been excellent for Ted because he could have had 60 minutes to speak, and also it would have been excellent for us to listen to him, because there was a danger that Gustavo cannot leave La Ciudad de Santísima Trinidad de Puerto de Santa Maria de Buenos Aires, in brief, Buenos Aires. But finally, he has made it, and it's a great relief to me because I wanted to say a lot about the draft Broadcasters Treaty, mainly supporting it, and I know that he will speak about that in the same way. We were together once when we spoke about that in Peru. It was the last pre-COVID meeting in Latin America, excellently moderated by Sylvie Forban. Elle était magnifique comme toujours. And we spoke about broadcasters' rights, and it was very clear that we were on the same length, which is expressed in the title of his article, published in the Social Science Research Network in 2019, the title of which is "It is Time for an International Treaty for Broadcasters." Gustavo, tienes la palabra.
Muchas gracias, Mejali. Adelanto que voy a hacer mi presentación en español. Les doy tiempo para que se coloquen los auriculares y le hablaré lento para que los traductores puedan llevar adelante la tarea sin inconvenientes. Agradezco una vez más a los organizadores por el excelente congreso que han preparado, este hermoso país, esta hermosa ciudad, y me sumo también, por supuesto, en agradecimiento a Víctor, que ha sido un anfitrión con sus colegas, por supuesto, de primera. Bueno, la pregunta es si sigue siendo necesario un nuevo tratado sobre el derecho de los organismos de radiodifusión. La pregunta tiene sentido porque después de 22 años uno dice, bueno, no tenemos tratado y siguen sobreviviendo, ¿no? Pareciera que Darwin tenía razón. La supervivencia del más fuerte se repite, y si los organismos de radiodifusión continúan activos, pareciera que tan mal no les ha ido. Sin embargo, eso no significa que no requieran un tratado actualizado, debido a que Roma se ha tornado obsoleto, pero que Roma sea obsoleto no significa que los radiodifusores sean obsoletos. ¿Por qué? Porque si fueran obsoletos, también tendría que ser obsoleto el artículo 11 bis de Berna y los correspondientes del TODA, TOYEF, Beijing. Siendo los radiodifusores todavía, y yo creo que durante mucho tiempo, uno de los principales actores en la comunicación al público de obras, y siendo que muchos otros titulares de derechos de autor y de derechos conexos actúan mancomunadamente con los radiodifusores, ya que la señal portadora de programas lleva consigo obras y prestaciones de distintos titulares, pareciera que no puede ser obsoleto el radiodifusor. Por supuesto que hoy día compite, y compite con dificultad frente a las plataformas. Como bien nos han dicho anteriormente, las plataformas tienen menos regulación, los organismos de radiodifusión en algunos países, como el nuestro y casi todos los de Latinoamérica, requieren una licencia del Estado. El Estado ejerce controles fuertes sobre los radiodifusores, controles que, por ejemplo, para darles un caso, en mi país tuvimos una presidente que tenía un deseo enorme de hablar en público casi todos los días y le robaba a los radiodifusores casi 1 hora por día, prácticamente todos los días de la semana. Entonces la programación había que cancelarla porque la presidenta deseaba hablar. Y por supuesto que los radiodifusores tenían que suspender la programación. No le pasaba a las plataformas, ni le pasaba a los canales de cable, pero sí a los radiodifusores. Entonces, el radiodifusor está sujeto a una cantidad de limitaciones y controles, tal vez no en todos los países, pero sí en muchos, y a su vez responsabilidad editorial y obligación de transmitir noticias y catástrofes y eventos, donde compite de algún modo con cierta deslealtad respecto de él, de otros distribuidores de contenido. Entonces, ¿es obsoleto Roma? Sí, no es obsoleto el radiodifusor, ni obsoleta la actividad. Sobre todo porque hay algún tipo de contenidos donde sigo siendo el principal canal, entre ellos, por ejemplo, el deporte. Así, la resolución del Parlamento Europeo del 2021 dejó en claro que es necesario tener algún tipo de protección adicional para los eventos deportivos. Hoy día los radiodifusores son prácticamente el canal y el modo de proteger los eventos deportivos, y así seguirá siendo, y esperemos que este año lo disfrutemos todos ya hacia el mes de noviembre y que salgamos campeones. ¿Sí? Alguno de los que está acá saldrá campeón, no sé quién. Hay muchos que pueden salir campeones, no solo Argentina. Bien, entonces es necesaria la puesta al día de Roma. ¿Por qué es necesaria? Ya han dicho que los medios de comunicación han cambiado, la televisión por internet, y sobre todo, entre otras cosas, la capacidad de que los programas sean transmitidos en diferido por el mismo radiodifusor o por un tercero en su nombre. Esta posibilidad no está considerada en Roma, no está considerada en los ADPIC, porque habitualmente el stream, el flujo, es un flujo en tiempo real. Pero ahora la tecnología nos permite grabar, le permite al radiodifusor grabar, a veces con la participación en la grabación directamente por parte del usuario, otras veces lo pone a disposición para que luego lo vea. Esto no está en Roma, no está en los ADPIC y requiere una solución. Esa solución es uno de los grandes motivos de discusión en la discusión que tenemos en OMPI, y ahora vamos a ver una posible solución a la que hemos llegado. En términos generales, el esquema de tratado que está proyectado hoy día, que es un texto que ha preparado el chair del Comité de Derechos de Autor y Derechos Conexos, que viene desde el año 2014, ha ido aumentando, y en los últimos 2 años el chair, con la participación de colaboradores, hay un texto bastante completo que podría ser la base de un acuerdo. Ese acuerdo tal vez no sea perfecto, como dice Mihaly, lo mejor es enemigo de lo bueno, y en este caso creemos que, por mi parte, creo que es algo posible, aunque tal vez no sea exactamente lo que piden las partes. Todos saben que en una negociación, con que estén medianamente satisfechas todas las partes es suficiente, porque si hubiera uno que estuviera perfectamente satisfecho, probablemente habría alguien que estuviera perfectamente insatisfecho, y de ese modo no habría nada. Para que haya algo, todos deben ceder, y yo creo que en este texto, que es el que está disponible, con ese número en la página del comité, tenemos una solución que, con todavía un poco más de trabajo, estamos cerca de una solución. El derecho exclusivo de los organismos de radiodifusión está estructurado primero bajo la premisa de una independencia basada en la señal. Este es un tema importante porque el gran tema de Roma y el gran tema que hoy día todavía se discute es que la señal obviamente no protege los contenidos, protege el flujo electrónico, que es portador de programas que pueden tener derecho de autor o no, programas que pueden ser del organismo de difusión o no, porque los puede tener bajo licencia o los puede haber adquirido, pero la protección está dada sobre la señal, sobre el vehículo, sobre el continente y no sobre el contenido. Esto está claro en el primer artículo de este texto, así como de algún modo estaba claro también en Roma. Pero, sin embargo, esto no satisface a todos, porque hay algunos países donde hay un temor, vinculado a su propia legislación interna, de que proteger la señal acompañe una protección adicional sobre los contenidos, que le agregue una segunda capa de derechos a los contenidos. Para los países de tradición civil, como Europa, Latinoamérica, esto no es un problema, porque nosotros tenemos bastante claridad respecto al derecho conexo y para nosotros la distinción es clara. Pero en sistemas del copyright, y particularmente para Estados Unidos, la protección de la señal podría significar, de acuerdo a su legislación, una protección adicional o una doble protección respecto de los contenidos. Y más allá de que es una cuestión de coordinación, esa coordinación obligaría a modificar la legislación interna, y modificar la legislación interna es un paso que ningún país quiere dar. Entonces hay que buscar una solución intermedia, donde por un lado mantengamos la protección de la señal, pero a los fines de poder atender necesidades de otros países, de algunos países, también se pueda buscar un método de protección que no sea necesariamente, exclusivamente el derecho conexo, sino algún tipo de protección por derecho de autor, por otro derecho conexo o por la competencia desleal, de tal modo que podamos recurrir a distintos mecanismos siempre que la protección sea adecuada y efectiva. Esta expresión, que no sé si decir que es una expresión mágica, una expresión de deseos, pero bueno, la protección adecuada y efectiva debe lograrse y debe manifestarse y debe en el proyecto de texto notificarse al director general, al director de la OMPI. Por supuesto que hay un capítulo de limitaciones y excepciones, hay medidas tecnológicas, hay información para la gestión de los derechos, lo cual ha sido muy importante, como vamos a ver hacia el final con algunos casos recientes de Europa y de América Latina, donde la información de la gestión de derechos ha facilitado algunas medidas para que los organismos de radiodifusión continúen con esa supervivencia que mencioné al principio, ¿no? Voy a presentar 3 artículos nada más del texto, pero son los 3 artículos que me parece a donde gira el problema actualmente. El primero de ellos es la protección de las transmisiones diferidas a través de los programas almacenados. Esta expresión, almacenamiento de programas, ha sido un modo de soslayar la expresión el derecho de fijación. En Roma y en NADPIC tenemos el derecho a la fijación, que tiene el titular de la señal, el derecho exclusivo a la fijación. Este lenguaje no ha sido seguido en el tratado y como el problema persistía, la solución que se encontró fue mencionar los programas almacenados, ya sea por el propio radiodifusor o un tercero en su nombre, a fin de que estén disponibles para el usuario o para el mismo radiodifusor o un tercero y puedan ser emitidos con posterioridad. Se menciona por primera vez en este documento la modalidad de puesta a disposición, aunque no dice puesta a disposición, pero usa el mismo lenguaje para que el público pueda acceder en el momento y lugar en el que lo desea. Con lo cual me parece que este artículo podría salvar esa grieta, ese bache que había entre dos sistemas que fue tema de negociación durante muchos años. Probablemente todavía se siga debatiendo alrededor de este lenguaje, alrededor de este artículo, pero creo que es un puente para salvar la distancia que había entre derecho de autor y copyright para el problema de las grabaciones o la fijación de los derechos. El otro artículo es un artículo que se generó a partir de la solicitud de algunos países, donde solicitaban en concreto que no fuera el derecho conexo el único modo, sino que por legislación interna podían tener medios adecuados y efectivos que funcionaran igualmente, con igual eficacia que el derecho conexo. Los organismos de difusión quieren derecho conexo a toda costa. ¿Por qué? Porque les interesa la independencia de los derechos, obviamente. No quieren depender de otros. Y si la protección va a ser por derecho de autor y tienen que conseguir la habilitación del titular del contenido, pareciera que su derecho es de segundo nivel. Como hoy nos explicaba Ted, pareciera que son de segunda categoría, ¿no? Los titulares son the content is the king, dice la frase. Pero también sabemos que hoy día distribution is the King Kong. Entonces, si los radiodifusores tienen que pelear o tienen que competir con otros medios de distribución que se comportan como King Kong muchas veces, necesitamos que tengan un derecho independiente y no subordinado, o que tengan que conseguir autorización para defender la reproducción o la retransmisión no autorizada. Pero bueno, aquí también el esfuerzo negociador llevó a un nuevo texto donde, más allá del derecho conexo, también se puede conceder o podría reemplazarse el derecho conexo, el derecho exclusivo, por algún mecanismo que puede ser derecho de autor, otro derecho específico conexo, por ejemplo, el derecho que tiene el productor audiovisual sobre la fijación, que mencionó antes Víctor, y también Ted, la protección a través de la competencia desleal o la apropiación indebida. En muchos países hay sanciones criminales respecto del robo de señal, captura y retransmisión indebida de señal, y esto no es necesariamente derecho de autor, sino que es derecho penal, derecho criminal, o también a través de las normas de telecomunicaciones que podrían penalizar la captura indebida de señal y la retransmisión sin autorización del titular de la señal. Entonces, estos medios de protección colaborarían para también lograr un puente entre sistemas jurídicos que parecen antagónicos, pero que deben ser coordinados a nivel internacional. El tema aquí es el trato nacional y de qué modo también el radiodifusor negocia con el titular de contenidos cuando no son sus propios contenidos, de tal modo que las licencias le permitan perseguir infractores de modo independiente. Si el titular de la señal no puede perseguir de modo autónomo a los infractores y está dependiendo de que lo haga el titular del contenido, que tal vez es de otro país y que tal vez ya se desentendió de ese contenido. ¿Por qué? Porque una vez que la emisión está realizada, algunas emisiones ya en el corto plazo pierden valor. Si ya no tienen sentido para el titular del contenido, el radiodifusor se queda sin remedio para poder perseguir infractores. Entonces, el estar dependiente de otros lo debilita. Hay que buscar los medios para que, ya sea por presunciones o por cláusulas contractuales, cuando el radiodifusor es licenciatario exclusivo, tenga posibilidad de perseguir de modo autónomo a aquellos infractores que, al tiempo que piratean la señal, al mismo tiempo están infringiendo los contenidos protegidos por algún tipo de los derechos, ya sea derecho conexo o derecho de autor. El tercer artículo cierra un poco el ciclo del artículo anterior, que son aquellas previsiones por los cuales se pueden ejercer esos derechos cuando dependan del derecho de autor. No cuando es el derecho conexo, porque el derecho conexo lo pone al organismo de difusión en un plano de independencia y autonomía. Pero cuando depende del titular del contenido, la licencia debería ser clara. Y si no es clara, habría que establecer algún sistema de presunciones de tal modo que no dependa de terceros. El caso que un poco para mí ejemplifica esto voy a ir primero para adelante, después vuelvo hacia atrás, fue este caso, que es un caso del Reino Unido, donde efectivamente los productores fonográficos consiguieron una indemnización por la infracción a sus derechos, pero en ningún lado aparece el organismo de radiodifusión. En este caso, la plataforma TuneIn lo que hace es poner a disposición miles, decenas de miles de señales de radio para que el usuario, a través del link, acceda a la transmisión en tiempo real o casi real de la difusión de cualquier lugar del mundo, con lo cual, estando hoy aquí en Portugal, yo podría escuchar las noticias de Argentina, con alguna horario de diferencia, en tiempo real. Para el usuario es muy cómodo. ¿Por qué? Porque no tengo que andar sintonizando uno por uno, porque en un mismo sitio elijo el acceso a través del link y voy directamente a la radio. Ahora, ¿hay permiso de TuneIn para linkear? Esa fue una discusión que se lo dejo a otros, porque no vamos a entrar en el tema del link y comunicación pública, pero más allá de que fuera ilícito o no lícito el link, lo cierto es que también tiene una función pro que permite grabar. Ese grabar afecta tanto la grabación de la señal sin autorización, como que afecta también a los contenidos transmitidos por la señal. En este caso era música. Entonces los demandantes fueron Warner y Sony. Warner y Sony consiguieron su indemnización, pero en ningún momento aparece un reclamo de los radiodifusores. Y esto es muy difícil porque el radiodifusor suele ser local, como dijo Ted, y ese radiodifusor tal vez no tenga intención de ir a reclamar a Inglaterra, salvo las mismas radios de Inglaterra o otro país de lengua inglesa. ¿En qué se afecta? Y se afecta en que se reduce la publicidad, se reduce las suscripciones, lo que fuere. Bien. Vamos hacia atrás. Casos que han tenido cierto éxito. En Uruguay, más allá de que Roma está obsoleto, los radiodifusores siguen ejerciendo sus derechos. En este caso, en la República Oriental del Uruguay, se consiguió una medida cautelar dinámica para que se bloqueara el sitio Roja Directa donde se transmitían espectáculos deportivos, básicamente fútbol, pero también otros espectáculos deportivos. Y aquí el solicitante fue Fox Channels, era un radiodifusor. El juez no entró demasiado en profundidad para analizar cuál era el derecho exclusivo de propiedad intelectual, de exclusive intellectual property. No lo dice, lo da por supuesto. Sí habla de los derechos de transmisión, que son más claros. No queda claro que en Uruguay haya un derecho de propiedad intelectual sobre el contenido del partido de fútbol, sobre la transmisión. Sí tiene un derecho sobre la emisión misma. Pero bueno, funcionó el sistema y se logró bloquear una actividad ilícita. En Perú, aquí el Indecopi, que es muy activo y tiene acciones administrativas muy ágiles, en un plazo de menos de 6 meses, logró bloquear también, mediante medidas dinámicas, cautelares, diversos sitios, en este caso también a pedido de la Liga Nacional de Fútbol Profesional, ya no de los radiodifusores. Si bien ustedes ven ahí que en la publicidad aparece Teis Sports, Fox y otros, y DirecTV y otros, los que iniciaron el reclamo fue directamente la Liga. La Liga como titular del espectáculo deportivo y de la fijación audiovisual del espectáculo deportivo del cual se consideró titular. El derecho conexo fue útil y reemplazó el derecho sobre la señal. O sea, el radiodifusor no inició la acción, la iniciaron directamente los titulares de contenido que habían dado licencia para la transmisión sin contar con el organismo de radiodifusión. Esto genera, bien, por un lado, porque se logró bloquear una actividad ilícita, pero pareciera que no están dadas las condiciones para que el organismo de radiodifusión por sí mismo lo pueda hacer y tiene que acudir al titular del contenido, en este caso el organizador del espectáculo, que es la Liga Nacional de Fútbol, la Liga como la conocemos. En este caso también de Perú, y más o menos por la misma época, mejoró todavía el sistema de control porque lo que se logró es bloquear sitios no que transmitían en vivo, sino que permitían lo que se llama el stream ripping. El stream ripping es la posibilidad de hacer un download, de bajar un contenido en tiempo real, fijarlo y luego que se convierta en un archivo que sea compartido o visto fuera del momento en que transcurrió la emisión. Aquí los bloqueados no fueron los canales que transmitían, sino las plataformas que ponían a disposición un software y un sistema que admitía la baja o el download del contenido para fijarlo en un archivo. En los casos italianos, que tal vez sean más conocidos por ustedes, también se consiguieron medidas cautelares dinámicas. En este caso lo consiguieron los titulares de las señales y actúa de modo parecido a como actúa en Europa. Estos son casos anteriores a los peruanos, y no hubo ningún inconveniente en bloquear. ¿Por qué? Porque los sitios estaban destinados casi exclusivamente o exclusivamente a la piratería de señales. Entonces la cautelar se concedió, y se concedió de modo dinámico para los nuevos URLs que lo reemplazaran. En este caso, parecido a Perú, aquí los que fueron condenados fueron plataformas que brindaban servicios de compresión y descompresión para facilitar la comunicación. No transmitían de modo directo, pero brindaban un servicio que permitían la piratería, facilitaban la piratería. Entonces, en estos casos ocurrió algo similar y fueron bloqueados. Resumen, necesitamos un tratado. ¿Por qué? Porque hay un ecosistema, no es solamente unos intereses que están en pugna. En Roma se vio bastante claro estos intereses en pugna, estamos hablando de hace muchos años, 60 años, y de hecho hasta la CISAC en su momento tuvo una opinión negativa respecto de la aprobación de Roma, pero lo que quedó claro, como dice Blanco Labra, un autor, que era un matrimonio de tres, un matrimonio de convivencia. Radiodifusores requerían los derechos de los productores fonográficos y de los intérpretes, porque si no, no había contenidos para transmitir. Los productores fonográficos requerían necesariamente de los intérpretes y también de los radiodifusores, porque si no, no vendían discos. Estamos hablando de la época incluso de la payola o aquellos servicios que pretendían que por la radio se hiciera promoción de los discos, ¿no? Cuando existían los discos. Y el intérprete, por supuesto, necesita de los dos, porque su fama llega a través de la radio y a través de los canales de televisión. Y todos ellos necesitan de los autores, con lo cual son sistemas que requieren armonía. Y esta armonía hoy día está dañada, porque los organismos de radiodifusión no tienen derechos equivalentes y claramente están por debajo, como servidores, como nos explicó Ted. Entonces me parece que hay una tarea pendiente, pareciera que estamos cerca, yo creí que estábamos cerca hace unos años, pero siempre, nunca es suficientemente cerca, esperemos verlo, y este ecosistema requiere que este actor en particular se sume a esos derechos actualizados, como ocurrieron con Beijing, con el Tratado de la OMPI sobre derechos de autor y Tratado de radiodifusores. Gracias.
Gracias, Gustavo. I am very glad that you are from a developing country. Actually, when the December 1996 diplomatic conference took place, developing countries insisted that there should be something to do with the rights of broadcasters. And it was the Philippines which invited us to organize a worldwide forum about that. In developing countries, televisions, first of all, are very important channels of creativity, and therefore there is a lot of support from the broadcasters of those countries. Also very much important that developing countries are more active in the, let us say, the international market concerning certain sports, and then sport event protection is also needs adequate protection of broadcasters' rights. So I'm very happy that Gustavo has been from a country of Di Stefano, Kempes, Messi, Batustita, and Aguero, etc. So we don't have too much time, but at least 10 minutes, according to the discussion with Victor. We had already discussion within the panel before that. There were some references, for example, between Ted, Victor, and myself about some proposals made by Victor. So I may give the floor to any member of the panel if they wish to make any comments. But if not, I open the floor to discussion. I can see, yes. I mean that there is, I can see that somebody is there, but due to the lamps, I cannot see who. Jan, yeah, sure. Please, you need a microphone. Shall I bring it to you? This way, this way.
Thank you, Chair. I have a brief question, possibly for the whole panel, which is about money and costs and rights acquisition. In this very scattered landscape of broadcasting and webcasting that you have described to us, it's very difficult to grasp really and to understand its mechanisms. I think there is a cost race in all this, following probably the budgets of the major platforms that the rest have to adjust to, and also the acquisition of rights that they do, and probably you may agree, I don't know. This also leads to demand for longer protection or acquisition of longer periods of rights, and a sort of a lock-up mechanism by that. What to do about that? Well, there is an interested party I have not mentioned yet, namely the audience, the public may be interested also in what we are coming to here. I can just very, very briefly mention, for example, the issue of public service. Can they still exist in this landscape? Some would say, well, if they can't, well, who's sorry? But obviously they have a problem to follow this cost line and this budget line and offer to the broad audience interesting and valuable programs. Not that the rest of the landscape does not offer that, but it's very, very scattered landscape. So my simple question is this a problem at all? Who should be sorry? Is there anyone who really should be sorry? Or is it just, well, this is how the market works, quite simply?
So who would like to take the floor on this marginal issue, money? Ted?
I didn't really understand the question.
Okay, it's better. You can speak about anything.
Okay. Well, money talks and bullshit walks. I didn't really understand the question.
The cost race, really. That if we are into a real cost race, who would be the victims of that? The audience, or minor broadcasting entities, or something like that?
So I mean, because the costs go up because of various remuneration rights or things like that. I mean, the amount of money that's being poured in to invest in the acquisition of rights, and I referred to it, things are kind of booming at the moment, but it's a delicate ecosystem and it's highly risky. And I mean, there are indications because, well, there's this war, and then there's of course been this pandemic that you may have heard of. There are indications that we may be headed very fast towards a brick wall. There's a streaming war going on, as you know, that's also raising costs. But ultimately, all of these things get passed on to consumers. That's what always happens. And those that can't pass it on to their consumers ultimately go out of business.
That was the right answer, correct answer, even if I didn't pose that question, wasn't it?
So
I did, sorry.
Okay, very good. Any other question or answer or express of happiness? Yes, to the left. And we take something from the right also to establish political balance. Do you have a microphone by chance?
I think so. Yeah.
Yes, okay.
Sounds good. Bernd Jugenholz, I have a question to our host, Victor Castro. You gave a very forceful argument in favor of updating and extending the neighboring right of audiovisual producers, which was quite interesting, and I agree with you that it is a quite antiquated notion as we know it now, the first fixation of a film. But I was wondering, in the audiovisual world that I know in Europe, nearly always copyrights already end up in the hands of the audiovisual producers by way of a variety of mechanisms, contract being the main one. And in addition to that, we have all these mechanisms that the Article 14 bis of the Berne Convention allows, the presumption of transfer or the direct allocation to the film producer. So I rarely see audiovisual producers without copyright in practice in the product that they have produced. So the obvious question here is there really a need for this neighboring right on top of the copyrights that the audiovisual producers already get through the operation of these various instruments? And in connection to that, I have the question, if you do beef up this neighboring right, which is rather dormant in practice, there's not much case law about it. And in fact, most film producers don't even know they have it. I talked to many. They were always pleasantly surprised when I told them that under the EU directives, there is actually another right that they didn't know about. But if we beef this up to the level of a true copyright, wouldn't that completely undermine the argument for having these mechanisms that concentrate copyrights in the hands of the producers? Because, well, this is a sort of you can't have your cake and eat it problem. Either you get strong neighboring rights, but then you do away with these mechanisms, or you just keep it as it is. But I don't see the argument for both. But that's not my answer. That's not your answer, presumably. So I was wondering what you think about this.
Okay, Brent, may I say that we have got also a discussion within the panel. May I say that you perhaps have found that we do not agree always about everything, but about this point we do agree. I am very much against the extension of this kind of extension of the rights of film producers, and I can see even danger of saying that phonograms, videograms, and then we should apply the same rights. I saw the danger in Eastern European countries, but they did this. I mean that they said that copyright and related rights, and they began applying related rights, the low-level rights for a shorter period, practically for what are audiovisual works. So I do agree with that. But for example, there is already a right of making available to the public. So it's quite broad.
I agree with you, but I think that recent case law from the EU law, from the EU court, has been allowing some doubts in relation to what the member states could do, and the difference between protection for phonograms is in relation to audiovisual is quite clear. I think that audiovisual producers really, in practical terms, they are concentrating all the rights by contractual ways, but in fact they need to strengthen their position in relation, for instance, to over-the-top television, the new dominant presence in the market. And I think that it would be very, very important to have a clear framework. And the framework is relying on provisions that the member states have. So far it has been working, but in the future I think that it would be more important to clarify the rights that they don't have and that they need. But I can see your point. Maybe in practical terms it may not be critical for the moment, but in the future I see that there may be trouble ahead because of not having a clear-cut definition and because of not having a clear-cut framework and the international protection of copyright and neighboring rights.
Thank you very much.
Okay, maybe there are also some comments about the broadcaster's rights. I know that, Bernd, you would have had also some comments about that. I recommend your article published on Evir about that. So, anybody here? No? No? Over there? Okay, so let's go ahead.
Thank you very much. This is a question actually for Victor. I found very interesting your proposal about follow the money in terms of seeking remuneration from intermediaries, platforms, and service providers that support unlicensed illegal services that are in violation of copyright. And you referred to, for example, the precedent of remuneration for private copying. But my concern and my question for you is, well, private copying is a limitation and exception under copyright law, so it's a legal activity. If we start going down the path of seeking remuneration from platforms and services for streaming sites that stream without license, are we not somehow creating a system of compulsory license where that activity is then basically made legitimate? So if a hosting provider is paying remuneration, how do you then go to that hosting provider and say, oh, now you need to cut off your service to this pirate website, and by the way, you need to filter to make sure this content doesn't come back on your service? That's my question for you.
Yes. I mean that that's okay to have a rights to remuneration, but not to authorize piracy, for example. It's not a very good idea. And actually, the European Court of Justice said this in a way concerning private copying. So that's it.
But I was wondering what.
Okay,
but it was Victor's proposal.
I give the floor to.
Yes, Victor. Yes. How many of you believe that private copy exception is only in practical terms only for a copy made with a legitimate source? Everybody makes copies. Nobody really cares about the source. So we are pretending that the exception of private copy is about a legitimate source. How many of you do we acquire the phonograms or the video that provides the possibility for a copy? I think that we are looking to the wrong side, because the world has changed. Everybody uses streaming, everybody accesses content. The world has been completely upside down because of the internet. We must look at what is really happening, and there are millions being made about because of this easiness to have access. It's not even necessary to be a technical savant, because it's very easy to acquire means to use illegitimate content. Now, I see the theoretical problem about the exceptions. I don't agree with, of course, the European Court when it says that exceptions are rights. They are not. But I think that we really definitely should think out of the box in order to minimize the impact that piracy is causing. Because we cannot fight piracy, we cannot attack the users, as I said, and this is something that, in fact, is happening in private copy. We cannot attack, we cannot prevent, we cannot control. So what do? We try to compensate. We try to compensate the right holders by asking the value chain before the user gets access to the content to pay, to contribute. And the ones that really pay and contribute on a first basis are not the consumers, although in the end, it can be reflected on the consumers. But this will be ultimately a market situation where they need to compete in order to lower the costs for the consumer. So I think that in the end, they will not tend to reflect those costs over the consumer because they will need to compete against the other offers.
No, thank you so much. I mean, I agree with you. You know, we have to address piracy in an out-of-the-box solution. I guess one thing I worry about, I also agree we cannot be going against end users, but platforms, intermediaries, maybe they need to have more responsibility to fight the piracy in the first place, instead of it all being the responsibility of the copyright owners.
Although I like to mention something, still in the time of CD-ROMs, at the Hungarian Copyright Council, there was a question about that. And we considered the following. There are two kinds of CD-ROMs. One, which must be more expensive because this is for legal downloading of music. There is something which is cheaper because you download from illegal sources. So no, at least it's possible. Somebody goes into the shop and they say that I like to have the cheaper one. I like to download from illegal sources, and for that there is no private copying. So we said, so actually I was also there, that, okay, what about to say that no authorization of piracy? We collect the remuneration of private copying, and if happens, very rarely happens, by chance, 1 million of times that somebody really goes against illegal downloaders, that we calculate that somebody has paid already that tiny amount of private copying levy. So, okay, I know that it's not acceptable, but there is also some kind of contradiction between that. Ladies and gentlemen, I don't know whether there is anybody who would like to say something. It's not possible anymore because we have to go to a coffee break, and there will be still another session. So I conclude this session in the spirit of peace, love, copyright, and related rights. But I'd like to invite you to applaud my dream team of panelists.
Maybe I just wanted to say that we should reconvene at, let's say, in about 20 minutes, 10 to 5 p.m. 10 to 5 p.m. Thank you very much.
Yes.
6:30 because we're half an hour late.
Okay. So just Ladies and gentlemen, let's take our seats. The next panel is about to begin. In fact, it's beginning. Panel number 4. Boa tarde. Parabéns por organizar esta maravilhosa conferência. That's all the Portuguese I can produce for the day. But it's well meant. This is a wonderful conference, and thank you for staging it, Victor and his team, in such a wonderful manner. This panel is about, my name, by the way, is Bernd Jugenholz, but I guess you already guessed that. This panel is about database protection and the press publisher's right. Rights invented fairly recently, the database right in the late 90s, the press publisher's right much more recently. Here in Europe, rights that as yet have no global coverage, although we never know. These are rights very distant from copyright. Rights at best remotely related to the traditional neighboring rights discussed in previous panels. And if in those sessions we've been examining our neighbors, now we're going to have a look at the scary aliens living across the street. And we all know and are afraid of them, aren't we? The ones that always have their curtains shut. Indeed, the rights we're going to discuss in this panel are almost the antithesis of copyright, almost the opposite of copyright. Under copyright, we have the golden rule that there's no protection of facts. The golden rule expressed in the Berne Convention that there's no protection of news of the day. And the golden rule codified nowhere that creativity is king, originality. And here we have rights that protect data, that protect news to the level of snippets, whatever they are, and require no creativity whatsoever. Victor Hugo would turn in his grave. Ladies and gentlemen, we have a great panel for you. 3 experts on the topic. Estelle Derclay, professor at the University of Nottingham. Irini, over there. Irini Stamatoudi, professor at the University of Nicosia, over here. Tristan Adzi, professor at the Sorbonne University in Paris, sitting next to me. Estelle and Irini will be speaking on database protection. Estelle will focus on the sui generis right, Irini on other ways of protecting databases, and Tristan has the daunting task of tackling, explaining, and more generally introducing the press publisher's right. Estelle, you're up as our very first speaker. May I invite you to the floor?
Thank you very much, Bernd, for already. No, I'm sure this is for Bernd, not for me. Thank you very much, Bernd, for your introduction, and I would like to thank, je voudrais remercier les organisateurs de la conférence pour m'avoir invité, et c'est vraiment un honneur et un plaisir d'être ici à Estoril pour vous présenter, to introduce you to, well, I'm sure it's not an introduction, but I don't have 2.5 hours, which I usually have when I teach the sui generis, right? So I'm going to concentrate on a little bit of the past, but much of the future of the right, if there is any future for it. So first of all, the database directive, it's old. It's from 1996 for those in the know. And so I will concentrate on the most important developments from 96 to 2022, but mainly the new things. And then policy options to revise the directive, and especially the Data Act, which has been proposed as a regulation this year by the European Commission, and then conclude. So, first of all, the elephant in the room, which we're not going to talk about, is copyright. Copyright doesn't protect databases very well because you know that very well as well. We have a high level of higher level of originality, which databases do not generally fulfill. And so therefore, I'm going to concentrate on the sui generis right because it was created by the EU in '96 to, as a stopgap for this lack of protection by copyright. But there is a harmonization of copyright protection in the database directive. It has to be reminded. And obviously, one of the things as well that the directive does is give a definition to the word database, which is the same definition for both the copyright chapter of the directive and the sui generis right chapter of the directive. So what, in a nutshell, does the sui generis right protect? The substantial investment of the database producer in obtaining, not creating, that's important, obtaining, so that means gathering, collecting, not creating the data, verifying or presenting the contents of the database, basically data, works, or other materials. And the rights have been broadly interpreted by courts. I will speak a little bit about that in a minute. There is one mandatory and imperative by that I mean that cannot be contracted out exception. That's not really an exception, it's a right of the user because it's the right of the user to take insubstantial part of the directive. The rights are the rights of extraction and reutilization refer to a substantial part of the database. And then only 3 optional. Optional, that means that the member states don't have to have them. They are totally free to implement them in their national law. 1 for non-electronic databases for private purposes, 1 for teaching and research, 1 for public security reasons, or an administrative or judicial procedure. So very limited number of exceptions there. And the term of protection is 15 years, renewable under the condition that you make the database producer make a new substantial investment. And as Irini will talk about in the next presentation, there is a possibility that's left in the directive to add plenty of other protections to copyright and the sui generis right. Most importantly, contracts, technological protection of technology protection measures, and fair competition. So what has happened between, I would say not really 96 because it was in 98, which was the deadline for transposing the directive. There's been a number of decisions by the Court of Justice, 11 to be clear, and the first 4 decisions, which involved football fixtures and horse racing fixtures, date from 2004, and they in the main deal with the same problem. The creation of data is not protectable. You only can obtain protection through the sui generis right if you collect the data. So that was the important part, one of the important things that the Court of Justice said in these 4 decisions, but also it interpreted the rights of extraction and reutilization extremely broadly, very much like in the copyright framework. And then there's a number of other decisions I have no time to discuss, but then there's the most defining one, the most important one, which comes again on the rights after a long expansion or broad expansive interpretation of the rights, is the CV Online Latvia case, which I will talk a little bit about in a minute. And then in the meantime, there's been a number of other initiatives by the Commission, the EU in general. There was a regulation of the free flow of non-personal data, so nothing to do with the GDPR, so I'm only really talking about non-personal data, so data that is not something that's private to a person, that identifies them. A number of initiatives like Creative Commons, especially CC0, open licenses by the public sector, like governments, the Open Data Directive, which in the past was called the Directive on the reuse of public sector information, so all this government data trying to be opened up. And then in 2019, we've had the new exceptions, not only to the sui generis right, but also to copyright in the CDSM directive, which I will briefly talk about as well. And then obviously, what happened in the last few years is the IoT problems, big data, machine-generated data, AI, and machine learning, to sort of put them all in the same bag. So what happened in CV Online Latvia? You'd think, well, the sui generis right, broad rights, quite protective, very few exceptions, you can renew it as much as you like, it's quite a strong right. And then all of a sudden, not all of a sudden, but there is a case that comes to the Court of Justice, the CV Online Latvia, which deals in very short for the facts, if you don't know them, it's CV Online Latvia is a website with job ads in Latvia, and Melons is a competitor, and it aggregates plenty of different job ads websites and put them all on its site. So it's an aggregator, it's a meta search engine if you want. So here I've reproduced the wording, the exact wording from the Court of Justice, which states in an interesting way, because it didn't state it so clearly before, that the sui generis right is intended to prevent a situation in which a user, through his or her acts, causes significant detriment. It takes that from one of the recitals of the directive, significant. So it has to be quite a big detriment, related quantitatively or qualitatively to the investment. And then it goes on and says, instead of a broad, expansive interpretation of the rights of the database producer, it says it is necessary to strike a fair balance between, on the one hand, the legitimate interest of the makers of databases in being able to redeem their substantial investment, and on the other hand, that of users and competitors of those makers in having access to the information contained in those databases and the possibility of creating innovative products based on that information. And aggregators such as Melons contribute to the creation and distribution of products and services with added value in the information sector. They allow the information on the internet to be better structured and to be searched more efficiently. They also contribute to the smooth functioning of competition and to the transparency of offers and prices. So that's sort of reminiscent a little bit of the McGill case from '95, also from the Court of Justice, where you had these TV listings where copyright in the past existed, it doesn't anymore, where, you know, there was a competitor who was trying to make a big aggregation of all these different TV magazines that you had to buy for each TV channel. And it restates that the main criterion for balancing the legitimate interest at stake must be the potential risk to the substantial investment. So it's interesting because it sort of waters down a little bit the broad rights that we had before and make it a bit more competition friendly, this case. So that's an evolution, and it's very recent since it dates from last year. Now, the exceptions, I'm sure that many of you from the EU will know them, so I'll go also very briefly over them. There is one new exception, not only to copyright, but I've put Article 7.1 of the directive because that's the sui generis right for reproductions and extractions made by research organizations, think universities, and cultural heritage institutions, think museums and archives and the like, for TDM purposes. And that's only for the purpose of scientific research. So it's quite limited. It's only for certain people, for certain purposes that you can do TDM, but it's imperative, so it cannot be contracted out. So that's the beauty of it. Now, on the contrary, Article 4 of the CDSM directive has a general TDM exception for anyone, but then it can be contracted out. So that can be said to be a failure to some extent, because then all the IP savvy database owners will basically have terms where you can't do TDM or you have to pay to do it. Then we have an Article 5. It broadens a little bit the teaching exception that we have in the database directive, which is good, and it's also imperative. An exception for preservation purposes, which didn't exist before, that's good as well. And then finally an exception for use of art of commerce works and other matters, subject matter like databases for cultural heritage institutions. And that's it. So I've looked actually at the reports, the country reports. There were 13 country reports, and also looked at the UK, because even if the UK has exited, we still have the sui generis right. It's now a purely national right, it's a UK right. And they all say that obviously they have the sui generis right in these all 13 member states, because of the directive. They had to implement it, but interestingly enough, there's one member state, and I forgot to write which one it is, so they won't be shamed today. You can read the country reports to find out which one it is. It says there's no TPM protection for databases, which I was quite surprised about because that's in breach of the InfoSoc directive, actually, which has incorporated this obligation for member states to protect databases which are protected by the sui generis right by the anti-circumvention measures which protect TPMs. And then, interestingly, there was a question in the questionnaire, the Alai questionnaire for this year, asking whether in their member states the sui generis right was efficient. And in short, the main answer in chorus, a little bit from the member states, these 13 member states plus the UK, is no. Or actually it's moderate, or it's not very efficient, or we have no proof, or there's no data found. And one of the reports, I think it's a French report, but correct me if I'm wrong, even cites the study from 2018 from, that the Commission ordered, where it's true, they didn't find, well, it's true. The answer was they didn't find any economic data to state, well, it's efficient or it's not efficient. We have no proof that it is efficient. So that's the situation in the member states. What was interesting, though, and again, I think it's in the French report, which I must say is very long and detailed, which I found very useful, which says basically it works, but it frustrates the database producers when it doesn't work, in the sense that there are sometimes hurdles to prove your substantial investment. From my personal experience, having read quite a few decisions from the different member states, it does work when the facts are simple and you can prove your investment. You bingo, it works in the sense that you win the litigation. So I was surprised to say that. What was the answer? Well, maybe I should reread the question. What did that mean, efficiency? And then finally, there was a question relating to the relationship between freedom of expression and competition on the one hand, and then the sui generis right, and then the countries, the 13 countries plus the UK, have none at all, or very limited case law on this. And an interesting thing that came out is that the case law generally comes from the interaction between this open data directive and the transposition in those member states. And there were two contrasting answers, actually, one from the French report, one from the German report, if I understood it correctly, that in France, with the notrefamille.com case, there is actually not a possibility anymore to assert the sui generis right on government or public sector information, whereas in Germany it's still possible. So there's a discrepancy here, and that's interesting. So that's for the country reports and the situation in the member states. Now I was asked as well to say a little bit about the now old, because it's 5 years old, a bit more, EU data producers right. And to be fair, it's more Bernd's domain of expertise, and it's dead. So I won't spend too much on it. We're very happy to take questions at the break if you have a question, but you have the reference here. It was never introduced. At the end, it was talked about back in the days in 2017 to introduce an intellectual property right, again, it's a neighboring right, on data as such, not a database that's comprised of a lot of data that's collected in a database, but data as such. Never saw the light of day, and in fact, we are in a situation now completely reversed to this with the Data Act. So what's happened since this 2017 proposal to have the data producers right? It disappeared, never talked again. And then there was a review of the database directive. In 2017, first the Commission had a public consultation, and then they commissioned a study, of which I'm a co-author with Lionel Bentley and others, and an evaluation report based on that study. And then they announced that they won't do anything, because the different policy options, as I will give them in a second, there were several, but they said we won't do anything, mainly because in 2019, in a few months, we'll have the elections, and then if we propose a directive now, it will be thrown out, the proposal will have to be reintroduced. But they said we're open, and we would like to revise it eventually. So, and in 2021, they proposed to revise the directive, and mainly to deal with machine-generated data and Internet of Things products. And they commissioned another study on the database sui generis right, yet again, not just on the directive like we did, the study in 2018 was the whole directive, but here on machine-generated data and IoT. They had a public consultation, which closed in September 2021. And then finally, it came a little later because it wasn't in the last quarter of 2021, but in February 2022, sure thing, they come out with the proposal for the Data Act, and they even had a consultation again, asking people, what do you think of the Data Act in May 2022? Now, the policy options that they could, that they had in front of them, the Commission had in front of them, was to repeal completely the sui generis right. Indeed, if it's not efficient or we don't have proof economically that it works or it doesn't work, why should we keep it? Or exclude completely this machine-generated data from the sui generis right. That's what they want to do in the Data Act. Or include machine-generated data. They refuse to do that, so they're opening it up. They don't want databases of machine-generated data to be protected by the sui generis right. Or the better option would have had to look at the entire directive and revise many, many different problematic aspects of it. And I've listed some of them, the PR aviation case Irini will talk about. One of the things that they've broadened the exception in 2019, but we're nowhere near the same amount of exceptions that we have in copyright. And as Bernd was saying, you know, it's a big alien. I mean, if you are protecting databases, there should be as much, if not more, exceptions to the database sui generis right than we have in copyright, because it's almost protecting data, even if it's not protecting data, like raw data as such. It boils down to very, very close to something like that. So a lot of things they could do, but they haven't done, because what we have now is no revision of the sui generis right, no revision of the directive, the database directive, but what boils down to basically a mouse, as we say in French, the elephant has given birth to a mouse, just an Article 35 of one sentence describing the relationship between the Data Act rights, which I will explain very briefly, because I'm sure my time is limited, and the database sui generis rights. So what does this article currently say, because that's the proposal still, in order not to hinder the exercise of the rights of users to access and use such data in accordance with Article 4 of the regulation, or of the right to share such data with third parties in accordance with Article 5 of this regulation. The sui generis right provided for in Article 7 of the database directive does not apply to databases containing data obtained from or generated by the use of a product or related service. So when they say product or related service, you go in the definitions of the Data Act, and you will see that's basically an IoT product, so it's your fridge that's connected to the internet and generates data when you open it, close it, temperature, or lights that switch off when you pass by, and that kind of product or related service. But it is very broad, and I was just to give you an anecdote, I was thinking about it when I was in Heathrow, because now they have toilets, at least in Terminal 2, where you have a green light and a red light to indicate if somebody's in the toilet. And I was like, oh my God, how does this work? Do they have a camera? And no, it's when you basically open or close the toilet. So there's a sensor there. So, I mean, is this IoT? I mean, the provision in the directive, the regulation is quite broad, and you can think, that could be something that's basically something that falls into the scope of the Data Act. So what is this Article 4 and that's Article 5 in short? Article 4 is the right of the user, so you own the fridge that's linked to the internet, you have the right to access the data that's generated by the fridge from the data holder, so basically the person who generally, it's not always the case, but the person who sold you the fridge. And Article 5, you have the right to actually, as a user, share that data with other people, so not just for accessing for your own purposes, but share it. And what does this provision say is that the database sui generis right does not apply to the data that's obtained from or generated by this IoT product. But in fact, it's unclear or at best confusing or wrong, because in fact, data which is obtained, that's one of the conditions for triggering the sui generis right. If it's obtained and it falls within the database definition and there is a substantial investment, if you can prove that, then the database with that data falls into the scope of the directive. So it basically assumes that databases which have obtained data, the sui generis right doesn't apply to them. But it does apply. So actually it does change the scope of the database directive, although it says no, it doesn't. So it's not very well phrased, and if they really want to change the scope, they should say it more clearly. Then another problem is the retroactive aspect of the issue. I mean, does the Data Act apply to databases prior or only post Data Act when the Data Act is actually, adopted? Nothing in the Data Act. So it made me think about Ole Andres in the Court of Justice not saying anything about retroactive aspect. There's nothing here, so you don't know. Basically, it's very uncertain. The other thing that it doesn't do, but implicitly you would think that it would close the door so that member states can't actually create their own little national rights on machine-generated data. It doesn't do that. It's not clear either. And another problem, and I could list other problems, but I see my time is up. There's nothing about the relationship between the sui generis right and this famous open data directive in the Data Act at the moment, anyway. So, conclusion, and this is my last slide. Do we have now a more balanced sui generis right thanks to the Online Latvia case and also to the new exceptions from 2019? I don't think so. We need to go further. We need to revise the directive more. But this is out. This is something that the Commission has made very clear. We're not going to revise it. We're just going to have this Article 35 in the Data Act. So I think there's a lot to be done to further open data. I mean, the Data Act is a good step forward to do that, but we have to see how it's going to be continued. But more worryingly, it's not just the Data Act, there's the AI Act, the Data Governance Act, the DSA, the DMA, the Open Data Directive, the GDPR, and this famous regulation of the free flow of information, of personal data that I talked to you about before. And also sectoral, there's also sectoral directives in environmental sectors or automotive sectors. It's a very complex network of interactions of different EU legislation. So if you're interested, I would refer you to all these different readings, and there's far more than this. There's the Max Planck Institute statement on the Data Act, there's the European Copyright Society, of which I was president last year, on the Data Act, and plenty of other readings if you're interested. And thank you very much for your attention. Obrigada.
Thank you very much, Estelle, for this rapid and very interesting expose of what's going on in the field of the sui generis right. It's still an ongoing discussion. By the way, if you have insomnia, try the Data Act. I guarantee you will not reach the section with the sui generis right in it. Okay, that brings me to our next speaker, Irini Stamatudi, who will be speaking about other ways of dealing and protecting databases. Irini, the floor is yours.
Thank you, Bernd. I would first of all like to thank the organizers for their kind invitation, the excellent choice of place and venue, and most of all I would like to thank the audience that is still here to listen to us. So I will be speaking about database protection outside copyright and the sui generis right. I won't be covering the Data Act because Estelle has already talked about it. I will essentially focus on unoriginal databases. I won't refer to pre-EU database directive regimes of protection which do not apply any longer, such as the Nordic catalog regime or the Dutch protection for non-original writings. And of course, when I refer to databases, I will refer within the notion of the EU database directive. Now I'll start with some practical and empirical data, what producers were occasionally doing in order to protect their unoriginal databases. That's the data producers themselves have produced. First of all, they tried to render them original. How do you do that? Only in terms of selection or arrangement of their contents. Instead of including all Indonesian restaurants in a catalog, one could make a selection of those ones that worth the visit. Or instead of including all local newspapers of a particular period, one could include only the ones dealing with articles on a particular topic. The other way is to restrict the use of databases on the basis of contracts. That has become clearer after the Ryanair case, for databases that do not fall within the scope of the database directive, which means that they are neither protected by copyright nor by the sui generis right. Of course, there are other restrictions by contract law or use cogens legislation, such as consumer law or the law on personal data. And then another choice are technological protection measures. This is a practical solution, not really a legal one, although they're usually coupled with terms and conditions. And then that brings us to register forms of IP protection, such as trademark protection, or through trade secrets, or through the filing of a case on the basis of unfair competition law or misappropriation. So you can see on your screen the various ways listed, the alternative forms of protection, and I'm just mentioning, although this is not the purpose of the paper, that these forms of protection can theoretically coexist with the sui generis right by reason of Article 13 of the Database Directive. Let's start with trademarks. Trademark protection of very limited importance for databases. This is relevant only for famous brand name databases whose added value is mainly due to the source and origin, which means that these databases are closely identified with a particular producer, and this is usually the case for financial or statistical information by a certain accredited company, as well as scientific databases that are linked with the name of a reputable publisher. And because that publisher is involved, you believe that the database is reliable, for example. Now, we have cases where the unauthorized use of materials from a database in a manner that creates a likelihood of confusion as to their source may also be actionable in some jurisdictions. And we have also the cases where the use of a trademark in a manner that lessens the capacity of a famous mark to identify and distinguish goods or services could also be an unlawful act, and this is known as the doctrine of dilution. But in this case, you need to have, of course, a famous trademark. So we see that trademark law is of primarily assistance against those uses of the database that involve the trademark and confuse the consumer as to the database's origin. That brings us to trade secrets. We have a special directive on trade secrets in the EU. It covers, according to Recital 14, know-how, business information, and technological information. This is a very broad definition. One could say that, well, the Trade Secrets Directive essentially focuses on information, of course, information which is valuable because it is secret. However, one could also argue that it covers databases themselves. Databases can also be trade secret. Insofar they are secret, they have a commercial value because they are secret, and reasonable steps are taken to keep it secret. One has to bear in mind that this is a rather vulnerable right, since reverse engineering and parallel innovation are allowed, and in some cases they're even encouraged. And of course, trade secret protection is not an exclusive IP right protection, it's a form of misappropriation. So, trade secret protection could perhaps be useful for unpublished databases, databases for internal use, or censor-produced data. As long as something is made known, is published, for example, it is no longer protected. On top of that, a claim of breach of secrecy requires a relationship between the owner of the secret and the defendant, involving either a contract or a confidential relationship, or the use of illegitimate means such as spying, theft, or bribery. And that brings to contracts. Many people would argue that contract law is the most appropriate form of protection because it allows for flexibility. The parties can tailor design the terms of use of a database according to its aim and purpose, the value of the database, and the commercial circumstances. For example, a publisher may allow certain uses for free and may charge for some other. Now, according to the Ryanair case, one may use contract law to prevent extraction and reutilization of even insubstantial parts of the contents of a database that does not come under the scope of protection of the Database Directive, is not protected by copyright or by the sui generis right. And of course, this type of databases are also not subject to the exceptions and limitations provided in the database directive. Yet, in some jurisdictions, there are particular provisions. For example, we had the prison case of 2016 in the Netherlands, where the court ruled that contractual provisions in a database manual are unenforceable, even though the database in question was an unprotected database. Of course, there are restrictions to contract law. Privity is the most important one. Contracts bind only the parties signing the contract and not unrelated third parties. It works well, perhaps, for database producers with a limited group of customers and an ongoing relationship with them, but it may be less satisfactory for databases that are sold in hard copy form or marketed through multiple levels of distribution. If control of the copy is lost, you find, for example, a database in hard copy on the ground, it goes without saying that you're not bound by the initial contract. And of course, we have no uniform contract law provisions in the European Union, which means that a contract may be valid in one country, may not be valid in another country. This is a problem for databases that are marketed internationally. And of course, when there is a lack of uniformity in a contract law, that also has an impact on enforcement. You cannot enforce something you do not have, and also enforcement may change from jurisdiction to jurisdiction. In some cases, you may get specific performance. In some other cases, you may only get damages, and you also need to prove damages. That brings us to technological protection measures. Pros and cons. They can be extremely effective, easy and more economical to rely on than legal rights. Could work as an argument against the need for additional legal protection, since they cover the object in practice. They also cover insubstantial parts of a database, and not only substantial parts, as the case is with the TPMs in relation to the sui generis right. Yet, they can be circumvented, and they do not prevent the use of a database once someone has obtained an authorized copy in accessible form. They are effective primarily for databases in electronic form, and what is most important, anti-circumvention protection applies only to protected databases, protected by copyright or the sui generis right. So it does not apply to unoriginal and not protected copyright, databases. In Nintendo versus PC Box, the Court of Justice emphasized that the use of TPMs to control access to and use of IP must be proportionate. And it also said that it's disproportionate if it prejudices fundamental rights such as freedom of expression under Article 11 of the Charter. If that is the case with copyrights and the sui generis right, what if no copyright or sui generis right exists? Can TPMs be used without limits? Food for thought. And that brings me to the last alternative way, misappropriation or unfair competition. As a general rule, any act or practice carried out in the course of industrial or commercial activities contrary to honest practices constitutes an act of unfair competition. Of course, it may not be an act, it may be an omission also, causing confusion, acts that are misleading, acts damaging goodwill or reputation, slavish imitation, and so on. Standards of honesty and fairness differ from country to country, so as they reflect the economic, sociological, and moral aspects of a given society. In the US, the seminal case dates back to 1918, when the Supreme Court held that the Associated Press had a claim against INS to prevent it from copying news items from the war front gathered by AP at great trouble and expense, and make them available to INS subscriber newspapers for advance publication. That was the misappropriation doctrine. Then, of course, US courts developed on this doctrine further, but since we don't have enough time, I'll just give you the general output. According to US law, data, in order for data to be protected, data that goes into databases, of course, it should be hot. Any claim is linked to directly competitive markets in order to avoid chilling the development of new collateral database products. Competitors could then freely use information for different purposes, such as developing specialized niche databases, or
entrepreneur could analyze historical financial data from the stock exchanges in order to predict future trends for investors. That rings a bell. It reminds us the McGill case, although the McGill case was not a case about unfair competition law, but a case about competition law. And of course, unfair competition law does not confer as such exclusivity. It is not a delineated property right that can be transferred. It comes into play once an unfair act has taken place and its requirements change from country to country. Now, although Article 13 of the Database Directive allows member states to offer databases protection through unfair competition law on top of the sui generis right, of course, such competition laws, unfair competition laws, are not harmonized, and this was one of the reasons why the sui generis right has been introduced. We have variations in the different states. You see them on your screen. I don't have enough time to analyze them. These are from the 2018 EU report. And that brings me to my conclusions. There are alternative forms of protection for unoriginal databases, which are, however, subject to the requirements and limitation of each one of those legal bases. None of them focuses expressly on investment, as the sui generis right does, but this is, of course, another discussion whether we need it or not. Contract law and technological protection measures are perhaps the most effective means of protection despite their limitations. Privity of contract, lack of harmonization, difficulties in enforcement, and so on, and they can occasionally secure a stronger, though limited, because of privity and anti-circumvention, protection compared to the one provided by copyright and the sui generis right. Protecting databases by other means than the one prescribed in the Database Directive is a difficult exercise, subject to many restrictions. This is also evident in the Alai national reports. From the 22 replies received, only 11 mentioned other means of protection for databases, 6 of them unfair competition law, 5 of them trade secrets, 4 contract law, 2 TPMs, and there are 2 mentions for patents, 1 for the press publisher's right, which is a good bridge for the next talk, of course. None of them could produce any evidence concerning the efficiency of those types of protection. Thank you very much.
Thank you, Irini, for this very interesting expose of alternative regimes. It demonstrates how important it is to analyze neighboring rights, or more generally the grant of IP rights, within the broader context of what the law already offers. We often overlook these alternative regimes. Thanks also for keeping time. That also applies to Estelle, by the way. Well done. That's a hint, Tristan. You're up next. No pressure, sorry. No, it's my pleasure to introduce Tristan. France was way ahead of the pack in implementing the new press publishers' rights. In fact, it was already implemented before there was a directive. Well, almost. But that does give France a head start vis-a-vis other countries and lots more experience with this fascinating new right, this alien among neighboring rights. And I think we're all very keen on hearing your talk. I give you the floor.
Merci. Merci à tous, merci en particulier au groupe portugais de m'avoir invité et de m'avoir demandé de présenter ce sujet sur le droit des éditeurs de presse, des éditeurs de publication de presse, pour reprendre les termes français de la directive. Je me demande si je ne devrais pas demander aux appariteurs de fermer l'amphithéâtre pour vous éviter de fuir, parce que 1, le sujet est très difficile, 2, il est tard, 3, je vais m'exprimer uniquement en français, et 4, il n'y aura pas de slides. Donc, avis aux amateurs, accrochez-vous. Alors, que dire? Et c'est peut-être 5e point, que les 22 rapports nationaux qui ont été reçus traitent très peu du droit voisin des éditeurs de presse. Donc pour quelqu'un qui avait l'ambition de faire un rapport général, à partir des réponses au questionnaire, c'était compliqué et je dois dire que j'ai été contraint de dépasser ce qui figurait dans les réponses au questionnaire. Alors, néanmoins, les 22 réponses donnent quelques indications géographiques en réalité. Sur les 22 groupes qui ont répondu, 13, on vous l'a déjà dit tout à l'heure, sont issus d'États membres de l'Union européenne, et la raison pour laquelle leur réponse a été relativement simple, c'est qu'ils ont tous dit qu'ils avaient transposé l'article 15 de la directive sur le droit d'auteur et les droits voisins dans le marché unique numérique, ou qu'ils étaient en passe de la transposer avec un petit peu de retard. Et en général, la réponse s'arrête à peu près là. Et puis, il nous reste 9 autres groupes, qui sont donc des groupes issus d'États non membres de l'Union européenne. Et eux, les réponses aux questions sont très simples. Existe-t-il une protection spéciale des éditeurs de presse dans votre pays? Non. Et en complément, généralement, il n'en existe pas parce que le droit d'auteur sec, classique, s'applique aux publications de presse, et certains États, et notamment le Japon et les États-Unis d'Amérique, ajoutent que la doctrine du work made for hire s'applique et que donc l'éditeur de publication de presse est bien titulaire des droits copyright et non pas neighboring right, en ajoutant que, notamment pour les États-Unis, compte tenu des limites apportées au copyright, c'est un droit qui n'est pas très efficace. Alors, quels enseignements en tirer? Eh bien, c'est relativement simple. La plupart des pays non européens n'ont pas de droit voisin ou de droit spécial en matière de publication de presse, et la plupart de ces pays se servent classiquement du droit d'auteur. Alors la conclusion, cette conclusion est un peu approximative, ce n'est pas la conclusion de mon rapport, elle est un peu approximative dans la mesure où il existe tout de même des États hors Union européenne qui ont légiféré sur la question de manière plus ou moins proche de la nôtre, notamment l'Australie, mais les Australiens n'ont pas répondu au questionnaire, et le rapport suisse, lui, nous indique qu'il est probable que le Parlement suisse s'intéresse à la question d'ici quelques temps. En dehors de l'Europe, en dehors de ces quelques exemples, pas grand-chose, et on peut noter que l'ex-État membre qu'était le Royaume-Uni n'a pas souhaité participer à la directive d'Amun, et en tout cas n'a pas souhaité créer ce droit voisin. Alors ça pose immédiatement la question de la légitimité de ce droit voisin et de son opportunité. Est-ce que le législateur européen, et vous le comprendrez que je vais centrer mes analyses sur la directive européenne, est-ce que le législateur européen a bien fait de l'instituer? Est-ce que c'est une bonne idée? Est-ce que c'est une mauvaise idée? La réponse n'est pas évidente. Au premier abord, c'est un droit de propriété intellectuelle qui est, somme toute, très limité. C'est ce que je voudrais vous montrer d'abord. Et c'est un droit, et ce sera la seconde partie, qui a été et qui est fortement contesté. Commençons donc par la première partie, un droit qui est limité. Le droit voisin des éditeurs de publication de presse, tel qu'il est prévu dans la directive européenne, est doublement limité. Il est limité d'abord quant à sa portée, il est limité ensuite quant à son opposabilité. S'agissant de la portée limitée de ce droit voisin, il a été conçu avec une finalité bien précise, qui est de permettre aux éditeurs de publication de presse d'autoriser ou d'interdire, mais en réalité de monétiser, la diffusion des articles de presse sur Internet par différents prestataires de services, agrégateurs d'informations, services de veille média, etc. Et évidemment, il faut le citer, la cible qui est dans la ligne de mire, c'est Google. Et dans ces conditions, la première limite qui est apportée à ce nouveau droit voisin, c'est qu'il ne joue que online, il ne joue que dans le contexte d'Internet. Et donc quelqu'un qui reproduirait sur papier un article de presse ne se verrait pas interdire cet acte sur le fondement du droit voisin. Plus précisément, il y a un droit de reproduction en ligne et un droit de mise à la disposition en ligne. Alors il semble néanmoins que certains pays, en tout cas c'est ce qu'explique le rapport croate, soient allés plus loin qu'une protection simplement online. Mais ça semble être une exception. Deuxième limite, le questionnaire insiste là-dessus, on a voulu préserver ce qu'on appelle la liberté de lier. Et donc, il est indiqué dans la directive que le nouveau droit voisin ne joue pas en matière d'hyperliens. Les hyperliens sont soustraits à l'application de ce nouveau droit voisin, mais cette restriction n'est pas du tout évidente à saisir. Alors, il est intéressant de voir que dans la proposition de directive, le texte prévoyait que seuls les hyperliens qui ne constituaient pas des actes de communication au public étaient exclus de la protection, ce qui voulait dire, à contrario, que les hyperliens qualifiés d'actes de communication au public par la Cour de justice entraient dans le champ du monopole. Je vous renvoie à la jurisprudence compliquée de la Cour de justice sur le sujet. La version définitive de l'article 15, elle n'est pas aussi subtile, elle semble vraiment exclure tout ce qui a trait aux hyperliens. Et un nouveau problème intervient, c'est que la plupart des publications de presse, d'une manière ou d'une autre, quand elles sont relayées sur Internet, elles le sont en totalité ou en partie grâce à des hyperliens, ce qui fait que si on ne veut pas vider le nouveau droit voisin de sa substance, il faudra quand même interpréter cette exclusion de manière à peu près raisonnable, ce qui, à mon avis, va poser des difficultés. Troisième limite, le questionnaire insiste toujours là-dessus, les publications scientifiques et universitaires ne sont pas considérées comme des titres de presse et ne sont pas soumises au droit voisin. L'idée ici, semble-t-il, c'est de permettre un développement de la politique d'accès aux résultats de la recherche, d'open access, et ça ne doit pas être freiné par un monopole intellectuel qui existerait sur ce type de publication. Dans un registre un peu voisin, on a voulu préserver la liberté d'information, on a voulu préserver le domaine public, et il y a tout un tas d'exclusions. Ça ne s'applique pas aux simples faits, donc aux informations brutes, telles qu'elles sont relatées dans un article de presse. Ça ne s'applique pas aux mots isolés, c'est assez évident, mais c'est écrit, je ne suis pas sûr qu'on ait besoin de l'écrire. Ça ne s'applique pas aux très courts extraits de publications de presse, et là le texte est un petit peu compliqué. Et ça ne s'applique pas non plus aux utilisations à titre privé ou non commercial, je cite le texte, des publications de presse faites par des utilisateurs individuels, ce qui veut dire que, grosso modo, pour être soumis au droit voisin et demander l'autorisation, être obligé de demander l'autorisation, il faut être en principe un fournisseur de services qui opère, ce que dit la directive, contre rémunération. Autre limitation, la durée du droit voisin, elle est extrêmement brève, 2 ans à compter de la publication de l'objet protégé. Initialement, le projet de directive avait prévu 20 ans de protection, on a jugé que c'était beaucoup trop long, qu'en réalité, le nouveau droit voisin n'avait de sens que quand une information était d'actualité et que, passé 2 ans, elle n'était plus beaucoup diffusée sur Internet et que le droit voisin perdait son sens. Une limitation d'ordre territorial, c'est sans doute lié au fait que la plupart des États hors Union européenne ne reconnaissent pas ce droit. Il faut être une entreprise établie dans l'Union pour pouvoir prétendre à son bénéfice. Et enfin, une dernière limite, mais elle est très évidente, on est très très loin du droit d'auteur et plus on s'éloigne, moins il y a de raisons d'accorder un droit moral. Et il est évident que tous les droits dont je vous ai parlé ici sont des droits patrimoniaux et il n'y a pas de droit moral. Alors deuxième élément, c'est l'opposabilité de ce droit qui est limitée. Il y a 2 règles à vocation pratique bien sûr, mais qui à mon avis ont une portée symbolique importante concernant ce droit voisin, ce nouveau droit voisin que je voudrais évoquer en 2 secondes. La première règle, je la qualifierais de super clause de sauvegarde. Ce matin, dès les premières interventions, il a été question de ce qui est indiqué à titre liminaire dans toutes les législations sur les droits voisins. Les droits voisins ne portent pas atteinte aux droits d'auteur, ne doivent pas être interprétés dans un sens défavorable à l'auteur, etc. Cette clause de sauvegarde, qu'on trouve dès la Convention de Rome, elle est évidemment très importante. Elle crée une forme de hiérarchie, même si ce n'est pas dit comme ça, mais entre droit d'auteur et droit voisin. Or, ici, on a une super clause de sauvegarde, en ce sens que la hiérarchie est beaucoup plus claire. Le texte nous dit que le nouveau droit voisin est inopposable, et il n'est pas inopposable qu'aux titulaires du droit d'auteur, il est inopposable à tous les autres titulaires de droits de propriété intellectuelle. Ce qui fait qu'il y a une vraie hiérarchie dans la propriété littéraire et artistique, et que le nouveau droit voisin, il est tout en bas de l'échelle. Il doit fléchir dès qu'il entre en conflit avec un droit voisin classique de première génération, ce dont on parlait avant, et évidemment, il doit fléchir quand il entre en réaction avec le droit d'auteur du fait d'une opposition du titulaire du droit d'auteur. Ça fait dire que c'est un droit voisin des droits voisins, on peut dire que c'est un droit voisin de second rang, on peut dire que c'est un droit voisin au rabais, mais il n'est pas tout à fait dans la même catégorie que les droits voisins classiques. Et puis, autre règle symbolique, la version initiale de la directive ne se préoccupait pas vraiment du sort des auteurs. Or, avant l'éditeur d'une publication de presse, il y a des auteurs, des journalistes, etc. Et la dernière version, ayant entendu les critiques, le législateur européen a réagi, et il est indiqué dans l'article 15, version définitive, que les auteurs des œuvres qui sont intégrées dans une publication de presse reçoivent, je cite, une part appropriée des revenus que les éditeurs de presse perçoivent au titre de leurs droits voisins. Alors évidemment, c'est une bonne chose. Évidemment que les premiers intéressés, si un article de presse est diffusé, ça devrait être les auteurs. C'est la logique du droit d'auteur. Mais si la solution est a priori satisfaisante, elle est quand même bizarre. Et en un sens, c'est un peu le monde à l'envers. C'est-à-dire que on va intéresser les auteurs à un droit qui ne leur appartient pas, et c'est en créant un droit voisin nouveau qu'on va permettre aux auteurs de participer. Bon, pour qui est habitué à la propriété littéraire artistique, c'est les auteurs d'abord. Or là, ils sont bénéficiaires indirects d'une protection qui ne leur est pas accordée. Alors, c'est déjà une critique en réalité, et je voudrais vous montrer dans la deuxième partie, qui sera plus brève, que le droit est un droit qui est contesté. Il l'a été à deux moments en réalité. Il l'a été en amont, c'est-à-dire au moment de sa consécration ou lors de son processus de consécration, et puis il l'est aujourd'hui au moment de son application, ce qui n'est pas tout à fait la même chose. Alors, d'abord l'amont, le fait que pendant le processus d'adoption de ce droit voisin, il a été fortement contesté. Je ne vais pas évoquer ici tous les arguments pour ni contre le droit voisin. Je voudrais juste insister sur 2 ou 3 points qui me semblent importants. Évidemment, positivement, la presse souffre du fait que des entreprises comme Google diffusent des publications de presse sur Internet sans demander d'autorisation, sans verser de rémunération, etc. Bon. Et c'est même peut-être un moyen pour la presse de survivre dans l'environnement numérique. On en est à peu près là de la situation. Bon. Et donc, sous un premier angle, on peut se dire que le droit voisin est bénéfique en ce sens qu'il va permettre de favoriser le pluralisme de la presse. Aucun titre de presse ne va disparaître du réseau. Et ça préserve aussi, du coup, le droit du public à l'information. Bon, c'est assez juste, mais c'est quand même paradoxal de dire d'un monopole intellectuel qui permet à des éditeurs de dire non, je ne veux pas que telle entreprise diffuse mon titre de presse, que ça va faciliter la liberté de l'information. Enfin, il y a quand même quelque chose qui ne va pas. On sait tous qu'on fait de la propriété intellectuelle et que le droit d'autoriser ou d'interdire, bah, précisément, ça permet d'interdire. Et interdire, ça veut dire que ce sont des contenus qui ne sont pas ou ne seraient pas communiqués au public. Donc la motivation est un peu ambiguë, elle est bicéphale en quelque sorte. Autre élément, ça nous concerne tous, je pense, le fait que à une époque où la propriété intellectuelle n'est pas bien comprise et où elle est même contestée dans son principe, c'est jamais très bon, je crois, d'étendre le nombre de titulaires, surtout en s'éloignant de ce qui est censé être le cœur de la matière, comme je l'indiquais il y a quelques instants. Une autre critique qui est un peu liée, ça tient à la cohérence de la propriété littéraire et artistique. Avant, si on reprend les exposés de la première partie de la journée, en gros, et en simplifiant un petit peu trop peut-être, mais les droits voisins, c'était 2 grands secteurs de la création, c'était la musique et l'audiovisuel. Bon. Aujourd'hui, il faut ajouter la presse avec ce nouveau droit voisin. Alors, pourquoi pas, mais dans ce cas-là, il y a quelque chose d'illogique, parce que il y a les éditeurs de presse, mais il y a d'autres éditeurs dans le paysage de la propriété littéraire artistique qui, eux, ne souhaitent pas de droit voisin. Alors, entre celui qui en voulait un et ceux qui n'en veulent pas, tout d'un coup, la propriété littéraire artistique manque de cohérence. L'éditeur de livres, évidemment, n'a pas de droit voisin. L'éditeur de meubles, l'éditeur de jeux vidéo, l'éditeur de vidéos, tout court, etc., l'éditeur de musique, bien sûr, eux n'en veulent pas, et alors, de loin, notre matière ressemble à quelque chose de difficilement compréhensible peut-être, et ça fait des droits voisins une qualification un petit peu fourre-tout. Je ne crois pas qu'il soit à l'ordre du jour d'étendre la catégorie à ces autres éditeurs qui pourtant occupent à peu près les mêmes fonctions que l'éditeur de presse, mais dans d'autres secteurs. Autre critique, j'ai pratiquement terminé ce point, il me restera un dernier point mais très rapide. Autre critique, la place des auteurs devrait rester centrale dans la propriété littéraire et artistique, me semble-t-il. Ici, je vous l'ai dit tout à l'heure, ils interviennent à titre subsidiaire, c'est-à-dire qu'on les autorise, enfin, ils doivent participer aux revenus générés par le nouveau droit voisin. Bon. Du côté des éditeurs, maintenant, le résultat que ça produit, c'est que, et ça rejoint vraiment tout à fait le débat qu'il y a eu tout à l'heure sur le producteur de films, ça fait des éditeurs de presse les personnes pratiquement les mieux dotées de toute la propriété intellectuelle. Parce que dans beaucoup de systèmes juridiques, avant le droit voisin ou en parallèle du droit voisin, les éditeurs de presse sont très souvent titulaires ab initio, initialement, du droit d'auteur. Alors en France, avec une sorte de bizarrerie qu'on appelle l'œuvre collective, mais qui a le même effet qu'aux États-Unis ou au Japon, comme les rapports nous l'expliquent très bien, que le work made for hire. Parallèlement à ça, dans certains pays, s'ajoute le fait que les auteurs d'œuvres journalistiques cèdent leurs droits aux éditeurs, mais que la loi prévoit souvent des mécanismes de cession automatique ou de cession présumée qui s'ajoutent déjà parfois à des statuts du type œuvre collective ou work made for hire. Sans compter que les éditeurs de presse qui officient en ligne peuvent sans doute prétendre au statut de producteur de base de données. Et là, tout d'un coup, on vient leur rajouter à ces mêmes personnes le bénéfice d'un droit voisin. Est-ce que c'était vraiment nécessaire? J'en suis pas certain. Et j'en suis d'autant moins certain, et ce sera mon dernier point en 2 minutes, qu'en envisageant la question de l'aval, l'application du droit voisin a été très contestée. Alors, le droit voisin est fragile dans ses fondements, en tout cas c'est ce qui ressort des critiques qui ont été émises au moment de son adoption, et il a été surtout, et là je parle, alors c'est pas un rapport général, je suis obligé de parler de la situation française, parce que comme ça vous a été dit, on a transposé le droit voisin très tôt, puisqu'il était prêt, il était dans les tuyaux, et pour une fois, on n'était pas en retard, on a créé le droit voisin, ce qui fait qu'on a hérité des premiers contentieux, pour tout dire. Et dans les pays ayant consacré ce droit voisin, l'attitude de Google, pour ne pas citer Google, a été de dire, après tout, c'est un droit de propriété intellectuelle, donc je ne suis soumis à ce droit que si j'exploite vos publications. Et donc, je vais décider de déréférencer vos publications, sauf à ce que vous me consentiez des licences gratuites, ce qui fait partie aussi du jeu normal de la propriété intellectuelle. Bon. Et ça a conduit les entreprises de presse en France, les éditeurs, à s'en remettre aux autorités garantes de la concurrence, à l'autorité de la concurrence, en invoquant un abus de position dominante de la part de Google. Et on a assisté à un véritable feuilleton français, dont je vais vous épargner les détails. Il a été demandé à Google de négocier de bonne foi avec les éditeurs de presse dans la mise en œuvre du droit voisin. Google ne s'y est pas plié dans un premier temps. Google a été condamné à payer 500 millions d'euros pour avoir fait de la résistance à cette obligation de négocier de bonne foi. Et parallèlement à ça, qui était un contentieux provisoire, mais avec une sanction extrêmement énergique, vous l'aurez compris, Google, voilà, on a enquêté sur le caractère anticoncurrentiel des pratiques et Google a finalement plié, a accepté de prendre divers engagements en soumettant plusieurs versions à l'autorité. Et la dernière version a été adoptée le 21 juin 2022, ce qui fait que tout semble bien se terminer après un épisode qu'on peut qualifier d'un petit peu sanglant. Je vous épargne les détails de ces engagements qui sont assez longs et je ne pense pas que ce soit particulièrement important de l'envisager. Alors, depuis, Google est très vertueux. Google a passé des accords avec un certain nombre d'éditeurs de presse et on peut imaginer que le mouvement va se poursuivre et que tout va bien se terminer. Simplement, ça suscite peut-être une dernière réaction qui fait écho à un rapport américain, des États-Unis d'Amérique, qui a été publié en juin 2022 et qui est cité dans le rapport national des États-Unis, selon lequel, aux États-Unis, il semble que la voie de la création de la modification de la législation sur le copyright en faveur des éditeurs de presse n'ait pas été envisagée après beaucoup de réflexions comme une bonne idée, qu'il serait préférable de modifier la loi antitrust pour tenir compte de cette situation. Et je me demande si finalement ce n'est pas un signe qu'un droit de propriété intellectuelle, comme le nouveau droit voisin, n'arrive pas à exister par lui-même. Concrètement, en France, il n'existe par lui-même que parce qu'après on a fait jouer le droit de la concurrence. Et je me dis que finalement, à l'image de ce que semblent vouloir faire les Américains, peut-être qu'il aurait été une meilleure méthode de passer directement par le terrain du droit de la concurrence sans créer forcément ce nouveau droit de propriété intellectuelle. Voilà. En conclusion, je voudrais juste vous présenter mes excuses pour avoir un peu trop centré mon analyse sur le droit européen et sur le droit français, mais il faut dire qu'il n'y avait pas grand-chose dans les réponses aux questionnaires nationaux parce que beaucoup de pays n'ont pas ce droit voisin et parce que pour une fois on avait une expérience en France qui peut-être pourrait être intéressante pour les autres. J'ai dépassé mon temps de parole, je m'arrête là et je vous remercie.
Thank you very much, Tristan, for this probably an introduction to this new right for many people in the audience, although others will have already been working with this or started to convert this new right into money. And that's, of course, what it's all about. You pointed us to a phenomenon that I think that typifies every neighboring rights debate. As soon as one category of producers or intermediaries gets a right, someone else says, oh, but I do almost exactly the same. I want the neighboring right too. It's like what was said earlier. Everyone wants remuneration, right? Everyone wants a neighboring right. It's almost you're not a serious entrepreneur if you don't have your own neighboring right. This, of course, is not a good argument for a neighboring right. But it does remind me of older discussions we had, possibly even at Alai in the 1980s, about granting a neighboring rights status to scientific publishers, and in some countries that has actually been realized. Okay, we have all observed our time brilliantly, particularly the panelists. Compliments for that. Let's give a round of applause to our panelists before we forget. So we actually have quite some time for discussion, and these topics really deserve discussion. To kick off, I have a quick question to each of you, and then I'll give the floor to the audience. My first question is to Estelle. You mentioned the study that you conducted together with a few colleagues for the in the UK and in Brussels, I believe, for the European Commission on the need to revise the database directive, a study you did a couple of years ago. One of the recurring questions is there any proof at all that the database right had any positive impact on the database economy or the database industry, whatever they are in Europe? Because that's why we had this right in the first place, to incentivize database production in Europe to catch up with the United States, who are way ahead of us in this field. Did you find any such proof?
Okay, thanks, Bernd, for asking the most important question, I would say. Yeah, we had just to give you a bit more background, we had a few lawyers and then we have a few economists, and the economists were tasked with that very question, right? So one of the big challenges, and that was the same challenge in 2005 when they couldn't find information, but we tried to dig, or they tried, I didn't do that. They did, thankfully I didn't have to dig that information. It was really, really hard to find any evidence. First of all, the only thing that's available in terms of some sort of report is the Gale, G-A-L-E, Gale directory of databases, but it's very, very minimal. I mean, the database industry is much, much bigger than what's in the Gale directory of databases. And that was already a challenge to try to get that information from them without paying a huge amount of money. So it's the irony of the report. So that didn't lead much anywhere. And then the economists tried to find data from publishers, because you think publishers, so you look into statistics on publishers. But publishers is a bigger sort of category than databases, right? So it didn't give you much of an information. Anyway, to cut a long story short, I don't want to take too much time, you can look in the report, but basically they couldn't find any proof, like you say, of its effectiveness, scientific or economic proof, whatever you want to call it. And now that's the economic bits of stuff. Now, in terms of the law, like I briefly said in my report, I mean, when it is litigated and when the facts are simple, it works. So it does give some, maybe not an incentive, but it gives definitely a reward for having done the database, for the database producer. In that respect, yes. But that's the law speaking. It doesn't mean that they need the right in the first place. It just gives them the reward. It doesn't mean that they needed the incentive to get the right. I hope I answered your question.
Only this one. Okay, we'll do microphone sharing. I also have a question to Irini. You discussed some interesting case law from the European Court and also national courts on the interface between contract law and database law, and the protection of technological protection measures. And in the context of discussing that, you raised the interesting question, but you didn't answer it. is there no limit to the use of TPMs in a situation, in technological protection measures, in a situation, for example, where there is no underlying IP right at all, where the stuff that's being TPM'd, being enveloped by this technology, is in the public domain, for example, or is there?
I guess I dug myself into that. I should have avoided this question. Well, the principle of proportionality, speaking like a civil lawyer, the principle of proportionality is not a principle found only in copyright or the sui generis right. It's a general legal principle which applies in all areas, including contract law. So I would say that TPMs perhaps is a form of contract law, because if you want to use something, you need to accept the terms of conditions to use it, and TPMs are part of these terms of conditions usually. So in fact, one can be based on fundamental rights to provide restrictions to contract law, or generally restrictions. For example, another provision that is actively used in law is the abuse of rights, which is found in civil codes. So I think, yes, there are limitations, not limitations based on copyright or the sui generis right, but limitations based on general civil law.
That's a decent answer, thank you. Finally, Tristan, everyone in Europe, and it's still, I think, mostly Europe that's dealing with the press publishers, right, is trying to make sense of the new rules in Article 15 of the DSM directive, and not only about what is exactly protected, but also what is not protected. There's this specific exception, which seems to me rather relevant, which allows the online use by aggregators of individual words or very short extracts of press publications. And on top of that, there's the recital 57 of the DSM directive that says that the PPR should not extend to mere facts reported in press publications. So my question is, and I guess you feel that one coming, how many words are okay?
J'ai pas la réponse. Personne ne l'a, je crois. Enfin, et tous ces garde-fous, parce que c'est vraiment ça, c'est-à-dire qu'on voit bien que le droit voisin des éditeurs de presse, on est en terrain sensible parce qu'on est confronté directement à la liberté d'information, et que donc il ne faut pas limiter les communications sur Internet, et alors les mots isolés, les très courts extraits de publications de presse et les informations brutes sont exclus du périmètre de la protection. On voit bien l'idée qui est derrière ça, de ce garde-fou. La propriété intellectuelle ne peut pas s'appliquer à ce qui relève du fonds commun. Voilà. Maintenant, la limite, je suis incapable de la fixer, et d'autant moins capable de la fixer qu'il y a quand même un paradoxe, c'est que le droit voisin, et c'est pour ça que j'ai repris le titre, c'est pas le droit voisin des éditeurs de presse, c'est le droit voisin des éditeurs de publication de presse. Alors, vous me direz, ça change rien. Oui, a priori, dans le langage courant, mais en fait, ça change parce que droit voisin des éditeurs de publication de presse, c'est à la fois les éditeurs de presse et les agences de presse. Or, une agence de presse diffuse des contenus qui sont des œuvres parfois protégées, mais diffuse aussi beaucoup de contenus extrêmement brefs qui sont purement descriptifs d'une information factuelle et qui donc ne sont pas soumises au droit voisin. Donc d'un côté, on nous dit ces agences bénéficient du nouveau droit, mais de l'autre côté, un de leurs cœurs de métier est exclu du nouveau droit, c'est-à-dire diffuser des nouvelles brutes. Donc je dois avouer que je ne sais pas du tout, et je ne vois pas un législateur national s'amuser dans un article de loi à dire au-delà de 2 mots et demi, au-delà de 51 termes, espace compris ou je ne sais quoi, le droit voisin joue. Ça va susciter des contentieux, c'est certain, me semble-t-il.
Yeah, it's the big question. I think the German legislator tried to do it in the pre-proposal and then gave up. I haven't seen it anywhere in the law yet. So this brings us to the audience. Are there any hands raised? Yeah, I see a hand up there, and it is...
Hi, Anna from
Anna.
Google.
Anna
Ramale from Google. And my question, hi, thank you all for the presentations, they were really interesting. My question goes to Estelle, actually, and it's about Article 35 of the Data Act. And I would like to know your opinion on the exclusion, so the fact that the sui generis does not apply to machine-generated data. My question is that Article 35 talks about data obtained or generated, but what happens if on this data there is a substantial investment on verifying, for example? So does this mean that the sui generis right does not apply and that's it? Or can there be still sui generis if there is a substantial investment afterwards? Thank you.
It's a very good question, which I don't have an answer to, because it's not very well phrased. And when you read it, it seems to me that you could interpret it both ways. So it's a conundrum. I hope they will change it. That's one of the things that you can criticize on the way that it's phrased. If you said obtained, why didn't you say also verified, etc.? So, al contrario, if you didn't say it, that means, you know, it's still protected. But that defeats the point then, you know. Why did you have an Article 35 to try to exclude machine-generated data and phrase it that way if the point is to exclude it completely from the sui generis right? So a logical interpretation would be to say, no, it includes all verified, you know, presented, obtained data that could be machine-generated. That's how I would interpret it, but, you know, it's only me. I'm not the Commission and I didn't draft it. So I really, really hope that all the comments that were sent to the Commission via the consultation in May will actually have some effect so that they redraft it. I hope I answered your question.
Estelle, speaking of the Data Act, do you have any idea of the length of the legislative project? When will we actually see the Data Act?
Before coming, I checked, and there's nothing new. No, unless somebody has got some insider information. There was some sort of information on Euroactive that the Czech presidency was looking into it, and also into Article 35, but nothing very substantial about it. Nothing more than that. So we're waiting, unless somebody has more information than me.
Okay, I see another hand there. Isolde.
Merci beaucoup. En fait, c'est une réflexion qui m'était venue lors du panel précédent, mais je crois qu'elle vaut également pour ce panel-ci. Pourquoi développer autant de droits voisins? Et j'ai l'impression que l'univers dans lequel on vit actuellement n'est pas un univers où on est en train de développer des droits voisins à l'ancienne, où essentiellement on crée des droits et on a à se soucier beaucoup du fait qu'éventuellement c'est le consommateur qui va devoir payer plus cher parce que ces droits-là seront répercutés dans le prix que payent les consommateurs. Je crois qu'au contraire, ce qu'on vit maintenant, c'est une recherche de droits voisins parce que la personne que l'on vise, ce n'est pas le consommateur ultimement, ce sont les plateformes. Et les plateformes, elles auraient à verser des centaines de millions de dollars par année en redevances de droits d'auteur ou de droits voisins. Elles n'auraient même pas besoin de monter le prix de leurs abonnements ou de l'argent qu'elles reçoivent. Et je crois que c'est pour ça qu'il y a tant d'industries comme ça qui cherchent à développer leurs propres droits voisins parce que leur interlocuteur, ce n'est plus le public en général, ce sont les plateformes. Et du point de vue du législateur, je crois que de ce côté-là, il y a aussi une approche, mettons, une politique sociale qui est très importante. C'est que ces énormes entreprises siphonnent, je ne sais pas si on dit ce terme-là en Europe, mais siphonnent l'argent des contribuables pour ensuite l'amener dans des paradis fiscaux. Et ça fait de l'argent qui ne retourne pas autant dans la société. Et ça fait en sorte que les gouvernements ne sont plus capables de financer la santé, l'éducation, l'infrastructure. Et c'est pour ça que la recherche de droits voisins pourrait être favorisée par les autorités publiques parce que c'est une façon de ramener l'argent dans le circuit économique national, contrairement à ce qui se fait maintenant. Merci.
Thank you, Isolde. That's an interesting comment, but it's not really a question. Is there anyone who wants to comment? Tristan?
Oui, sans doute. C'est vrai que tout ce dont on parle depuis tout à l'heure et qui est différent des droits voisins de première génération, déjà les droits voisins classiques de première génération sont effectivement orientés vers les plateformes maintenant, et on parle des bases de données, on parle du droit voisin des éditeurs de presse, on a parlé du droit voisin des producteurs de vidéogrammes, comme on les appelle en France, ou d'œuvres audiovisuelles. On va parler des manifestations sportives, on en a déjà un peu parlé, etc. On parle du relais des organismes de radiodiffusion sur les plateformes, donc effectivement, à chaque fois, c'est tout à fait la même histoire. Mais il va falloir s'arrêter parce que... Enfin, la manifestation sportive, le lien avec le droit d'auteur, il est quand même très très léger. Autant, alors à la limite, l'éditeur de presse, et je pense que c'est presque pour se justifier, le législateur européen insiste bien sur le fait que ça porte sur des publications qui portent sur des œuvres. Le mot œuvre est répété à l'envi comme ça ça donne l'impression qu'on est vraiment encore en propriété intellectuelle. Mais un jour, on va nous dire, et ça remonte à des thèses très anciennes mais qui reviennent au goût du jour, les droits de la personnalité, c'est des droits voisins. Oui, mais à ce jeu-là, le droit de propriété corporelle, c'est un droit voisin du droit d'auteur. Il lui ressemble quand même un petit peu. Enfin, on inverse les problématiques, mais je suis assez d'accord avec toi.
I'm just going to say one word, just to say that the sui generis right was there to harmonize the law. So there was already, and as you know, Isolde, I'm speaking in English for the benefit of everyone, there was already some copyright actually in common law countries. So it's a different dynamic for the sui generis right. And in Europe we tried to harmonize it so we didn't have a hodgepodge of different, like Irini was saying, mainly unfair competition law or contracts, etc., to sort of boost the industry. So it was a slightly different reason why we incorporated in Europe. But I would tend to agree with what Tristan has said for the other new rights.
Okay, we have time for one more question. And I see 2 hands immediately raised. You have to decide between yourself who's going to ask the question. Will you remain friends?
Bueno, me preguntaba si podía hablar en español, si no puedo hablar en francés. Tengo una pregunta para el profesor Tristan Azzi. Profesor, me preguntaba si cree usted que el sistema de protección en el sector del periodismo en Francia, es decir, el régimen de obra colectiva y las cesiones automáticas de los periodistas a los editores antes de la aprobación del derecho conexo, ¿cree usted que era efectivo? Porque en España, por ejemplo, nosotros también tenemos la obra colectiva y en 2014 se puso de manifiesto un value gap que hizo cambiar la normativa en ese sentido, como pasó en Alemania en 2013, es decir, ya había un problema de value gap. En Francia también hubo un acuerdo con Google en 2012. ¿Era suficiente la legislación que ya tenían?
Ma conviction, en France, c'est quand même très particulier parce que le statut des éditeurs était déjà assez intéressant pour eux. Je le répète, ils cumulaient au minimum le statut, alors très souvent de titulaire de droit sur une œuvre collective, comme vous l'avez dit, qui fait que d'emblée, ils étaient titulaires à titre initial des droits sur l'œuvre envisagée dans sa globalité. Et il cumulait ça avec, et de manière très certaine et ferme depuis la loi Adopi, avec un statut des journalistes qui était un système de cession, qui est un système de cession automatique assez large d'ailleurs, puisque ça peut concerner plusieurs titres de presse qui appartiennent à un même groupe, etc. Donc moi sur le papier, l'argument selon lequel c'était pas suffisant, j'y crois pas trop, mais c'est pourtant un argument qui a été invoqué et qui a fait mouche, qui a fonctionné. Alors il faut voir aussi que derrière tout ça, il y a une considération pratique qui est liée au contentieux. C'est quand on parle d'œuvres collectives ou quand on parle de droits des auteurs sur des œuvres qui seraient cédées plus ou moins automatiquement à une entreprise de presse, à un éditeur de presse, il faut que ce soit des œuvres protégées par le droit d'auteur. Donc ça suppose dans le contentieux de prouver l'originalité. Et c'est quelque chose dont on n'a pas parlé, mais c'est le cas pour beaucoup de droits voisins, y compris les premiers droits voisins. Ils ont un énorme avantage qui fait que je pense qu'on a tendance à se rabattre dessus aujourd'hui, de la même manière que parfois dans certains contentieux, on n'invoque même plus la concurrence déloyale à titre subsidiaire, on l'invoque uniquement. Quand on sent que la preuve de l'originalité va être compliquée, il vaut mieux aller directement sur le terrain des droits voisins ou directement sur le terrain de la concurrence déloyale ou parasitaire. Et je pense que c'est un des arguments qui a sous-tendu la création de ce droit supplémentaire, alors que sur le papier, il existait déjà deux statuts favorables au bénéfice des éditeurs, je crois. Il y a sans doute d'autres raisons, mais voilà, la principale que j'identifie, c'est celle-ci pour l'instant.
Okay. As you can see, our time is up. Let's give our panelists another round of applause. Thank you very much. And move on to our last session of the day, Article 17.
Mesdames et messieurs, ne quittez pas vos places parce qu'on va commencer tout à l'heure avec la session sur l'article 17. Les gens qui vont parler, s'il vous plaît, peuvent arriver. Un autre avis, si vous voulez aller à Mafra et à Queluz le dimanche, vous pouvez déjà faire vos réservations. Merci beaucoup.
So, good afternoon, or rather, good evening. My name is Dario Moravicent. I will be chairing this session, the last one of today. I would, in the first place, like to thank the organizers of the 2022 Alai Congress for their invitation to moderate this session, and also to welcome all those participating in it. A special word of thanks is due to Margarida Almeida Rocha and Vitor Castro Rosa for all their work in putting up this Congress. So the purpose of this last session is to debate Article 17 of the Copyright in the Digital Signal Market Directive. As is well known, Article 17, which is probably the directive's most debated provision, has introduced quite a few changes into current copyright law in Europe. First of all, because online content sharing service providers that perform acts of communication to the public or are making available to the public protected content are now deemed to be performing acts of use of such content. Secondly, they are now obliged to obtain authorizations from rights holders, for example, by concluding licensing agreements. Thirdly, if no such authorization is granted, then these service providers will be liable for unauthorized acts of communication or making available to the public such content. Some exceptions are, however, allowed by Article 17, notably if service providers demonstrate that they have made best efforts to obtain authorizations. But as it is easy to guess, a host of legal issues arise from this provision, both in what concerns its transposition into domestic laws of EU member states, and also in what concerns its future application by courts around Europe. This is notably the case of how copyright exceptions and limitations and freedom of expression in general can be preserved under this new regime. The directive seeks to ensure a fair balance between the interests of rights holders and those of users, but whether or not that balance will in fact be achieved to a large extent depends on how the directive is transposed and how it will be applied by national courts. In order to discuss these issues, we have 4 distinguished panelists that will be addressing Article 17 from different angles, and they are according to the order of their presentations. First, Burak Özgen, that is on my extreme left. He's a senior legal advisor for GESAC. Then Alexandre Dias Pereira on my extreme right hand, professor of the University of Coimbra, where he teaches copyright law, and also currently the director of the Coimbra University Press. Then Eleonora Rosati on my right hand, who is originally from Italy, but now a professor at the Stockholm University, where she heads the Institute for Intellectual Property and is well known, I suppose, to most of all of us as both a prolific author and a blogger in IP matters. And finally, on my left-hand side, Jan Bern Noordeman, a specialist attorney for copyright and media law and a honorary professor at the Humboldt University in Berlin. My thanks sincerely to all of you for having made yourselves available to participate in this debate. Each of our speakers has kindly prepared a short presentation. They are all very well aware that they are the only thing standing between yourselves and the cocktail that will be served in about an hour and a half, so I'm sure they will be very brief and straight to the point in their presentations. Nevertheless, I think it will be very much worthwhile listening to them. We'll start with Burak Özgen. He has chosen to present 2 key points on how Article 17 is supposed to improve authors' remuneration, licensing and reporting obligations of online service providers. Burak, the floor is yours.
Thank you very much, Dario. It's really an honor to be able to address the Alai Congress. Thanks very much for the invitation and for the opportunity. As Dario mentioned, that I will speak today on the 2 key points, how actually Article 17 is supposed to improve the remuneration of the authors. And this will be a little bit different than the other presentations, which will mainly focus on the removal related provisions of the Article 17. But considering that the main focus of the Article 17 has from the very beginning been the facilitating the licensing market and then allowing the services to get a license and for the right holders to be remunerated for the usage, it is a really important part of the and actually, if not the main part of the directive. There are two key issues here relating to the licensing and the remuneration of the creators. One is the licensing of the content, the actual thing, and then the provisions put in the paragraph 2 of the Article 17.8 on the transparency and accuracy of usage information. And there are a lot of things there. First of all, the legal nature of this licensing obligation. The Article 17.1 specifically says that the OCSSPs shall obtain an authorization because they're undertaking an act of communication to the public. But because of the user-generated nature of the services, special liability regime has been prepared, created under this directive as an alternative to the full liability. And when we look at it, the 17.4a restrictions is different than the 17.4b and c restrictions, and the only restriction that is mentioned in the directive for licensing is in Article 17.5 based on proportionality. This is on the ability of the OCSSPs on how widely they can proactively seek licenses from the relevant right holders, but it's not a restriction on the need and on the actual necessity to get a license. We are understanding it from the language of 17.6 that makes for all sizes of services to get a license and as an obligation, and then we see it from the European Commission's guidance as well. When we look at the member states, countries like France, Slovakia, Lithuania specifically cite that this is an act of communication to the public as described in their national law, and hence the licenses are subject to the same rules. And in Italy, it is specified that OCSSPs must obtain a license in accordance with high industry standards of professional diligence as a different extra thing in the national laws. And Croatian law specified it as a licensing obligation in an article. And in some countries, like very few, like Estonia, they didn't say anything, but it follows from the very text that it's an act of communication to the public that needs to be licensed accordingly. So what is the consequence of not giving any effort or any best effort of getting licensed before we are looking at what best effort is or what the mitigation measures are? It is based on the justification to adjust the business model to have such a restriction, but it's not certainly an opportunity or an advantage given to the OCSSPs to try to delay negotiations or impose lower tariffs and then choose instead using the limited liability regime for the removal of the content based on the information coming from the right holders. If you are not giving the effort on getting licenses that are offered to you in the fair terms in an objective manner, then not having the license and having the content on the platform should lead to full liability and should lead to asking the damages for the right holders. And the guidance is, European Commission guidance addresses this issue by saying service providers refusing to conclude a license offered on fair terms which maintains a reasonable balance may be considered not to have deployed their best effort to obtain an authorization. So guidance could have been stronger and clearer to say that the result of this is full liability, which is actually following and normally, which is otherwise an exclusive right, and whose only restriction is, as I said, on the ability of the service to reach how widely the service can reach for finding the right holders. So what is the best effort in that sense is an important thing, and directive doesn't give so much elements on that, but the Commission guidance does. And then first of all, it says case-by-case analysis, which is reasonable. And the other one is requirement to contact at least the CMOs and the non-right holders as the minimum effort that needs to be shown by the services. And when it comes to startup services defined in the 17.6, it says that all of them at least needs to go to CMOs that are relevant, that are representing the relevant right holders, whether their type of content is prevalent or less common, which is an important point, and also asking that they need to conduct these negotiations in good faith, a critical point, as I said in the previous slide. Germany says specifically who can be contacted, including the right holders who are offering the license to the services. Italy mentions that CMOs and the non-right holders as the example of receiving licenses and any action on the receiving licenses. Has not been adopted yet, but in the explanatory notes in the Swedish proposal, there is an expression saying services will be held liable for not entering into licensing agreements where CMOs has offered licenses under the CRM directive, because those licenses are based on objective criteria and in good faith. And we see also right now in the negotiations in Latvia and Bulgaria for the transposition of the law the same point. There is another issue for the right holders who are not members of CMOs or not part of the non-right holders. For that, there needs to be a structure on the OCSSPs allowing those people to contact them, maybe with the set procedures, and then offer their licenses, after which the services needs to quickly engage. Pass-through licenses, 17.2. This is the license that actually the requirement that the licenses received by the OCSSP should cover the acts of the uploaders who are acting on a non-commercial basis or who do not generate sufficient revenues. And it's another sign that this provision is about making those services part of the ecosystem and then making sure that they're remunerating the creator rather than actually totally breaking down or shutting down the business model. Guidance suggests, Commission guidance suggests to specifically transpose this provision. And when you look at the transposition laws, everybody put exactly the same thing on a copy-paste basis. An interesting question is what rights to license? So communication to the public, making available, obvious, because they give access, but the definition of OCSSPs also include the storage. So communication to public, you access, but do you need to license the reproduction right? Or, I mean, don't you need to license the reproduction right, actually? So has there ever been a discussion on whether there has been a reproduction right on the services or not? There has been on the communication to the public. So can an OCSSP have neither knowledge nor control over the reproduction of a protected works for whose communication to the public it is liable? And if you find the service liable for that, are you going to apply another liability regime for reproduction? Right, considering all the justifications and confirmation given by the Court of Justice in the Polish complaint case for the balance that needs to be struck by the Article 17. And how can the pass-through licensing can be effective if the reproduction right is not covered and the uploaders are still liable for the act of reproduction that they are doing? So, important point, guidance makes a huge legal error in this respect. It says that the making available and communication to the public in this process includes also the acts of reproduction carried out in this respect. And then it says the member states shall not oblige OCSSPs to get a license for reproduction. We were a little bit shocked when we saw this, and then we thought the Commission could not have just do that because of the lobbying activities by the big OCSSPs at national level to address these issues, so they just adopted the law, they are proud of it. So we found out actually this is coming from the position of the legal service of the Commission in another case at the level of Court of Justice regarding the private copying on the cloud-based services. And then there, the Commission given its observations saying that actually this is an act of making available, not a reproduction. In any case, the reproduction is assimilated in the process of the making available as the general position. And obviously and clearly that the Court of Justice has very strongly and clearly refused this view of the Commission by specifying this in its paragraph 31 and 32 in the Strato versus Austro-Mecana ruling. And then I think this is now open as an issue legal discussion. When we look at the national transposition, France and Croatia specifically mentioned the need to license the reproduction right. Austrian law does not mention it, but in the explanatory notes, they say the same regime of the communication to public should also apply to the reproduction right. And the Bulgarian draft has had discussions on this issue as well. Sorry about that. So, having the licenses in place with the services, the second point is the transparency and accuracy of the usage information. Why is this important? In the online licensing environment, you get paid to the extent that you prove or that you show, identify the usages of your content. There's a revenue pool based on the revenues or other elements of the services, and then you are identifying your contents by saying, I have this amount of content that has been used, and according to the usage of your content, you are getting your remuneration. So the more you can identify, the more you can get paid. And the more you know about the business model and how much and how the service generates money, then you are growing the basis of the remuneration on which that you need to get your share as the right holder based on usage. And the OCSSPs refused any information or any cooperation on this, as they refused any liability on the act of communication to the public or any act of copyright. So the Article 17.8 paragraph 2 provided some elements here, and so what needs to be provided by the services. So the guidance says, and also in general, there is a reporting in agreed format and time frame, which is already coming from the CRM directives, Article 17, which now applies to all services, including the OCSSPs as they're in the system now. And guidance does not say many useful things in that, despite the fact that we have given so much information on this. But it says service providers should be transparent with right holders with respect to the criteria they intend to use to identify and remunerate the content. It's very important. In practice, what would it mean? What we would seek if, essentially is reporting on all types of authors' work, regardless of the sound recording. For instance, when a work is used in an audiovisual production, series, and in film, regenerated content, live content, or studio versions, and all these things that are not attached to a sound recording, integrating rights information into their systems when we correct their failures, and then not to duplicate the same failures again and again, which is a huge, huge pain right now, but we hope this article, it will improve, and allow verification reports by third-party technology providers, so you can hire technology providers to check if what they report is really corresponds, what is actually happening. And the other one is obviously an essential element of any licensing agreement is the possibility of an audit, which they have refused so far. So when we look at the member state transposition, this is usually transposed in the same way with some variations. In France, instead of the adequate information, they specify this precise information, and in Italy and Slovakia, it has been enacted actually as an obligation, as was specifically mentioned. So that's all I have to say. I hope it's in the limit, and I'd be happy to answer any questions if you have. Thank you.
Very much, Burak. I now hand over the floor to Alexandre Dias Pereira, who will deal with the topic upload filters for obvious infringement. Alexandre, please.
Muito obrigado, muito boa tarde a todos. Em primeiro lugar, je suis très heureux que Alai est venu au Portugal et qui est ici au Estoril à faire son congrès annuel. Et je veux remercier le président Frank Godsen et aussi la présidente portugaise Margarida Almeida Rocha, et en particulier Victor Rosa, qui a fait un travail vraiment exceptionnel. Et à tous, je salue bien. J'espère que vous avez un bon temps ici au Portugal. C'est un pays sympathique. Mais je veux parler en anglais, excusez-moi. Alors, so the topic is upload filters for obvious infringement. English or something close to English. We could say that it's now well accepted that online sharing platforms have to use these technological measures so that they exclude liability for copyright infringement, at least those large platforms such as Google, social, and other ones. This has been stated by at least but I think the court said it in this judgment of 22 June 2021. It's that the implementation of adequate technical measures is a requirement to avoid communication to the public of works uploaded by users of, I would say, commercial online sharing platforms. Of course, there is a difference because the court said it is not even an act of communication to the public, while the directive states the principle that these platforms do an act of communication to the public, and then they can exclude liability for such acts. However, SIENDO is not all about Article 17. It applies to the law before the directive. And so, but it's important because the principle is there, the idea that all use hateful ID content technologies, well, they are just, or they can be those adequate technical measures. And then in Portugal, we also want to implement the directive, and we are looking at the guidance given by the Commission. But then we have a problem because the use of automated content recognition technology meets the best efforts clause, but the Commission expressly states that in the present state of the art, no technology can assess to the standard required in law whether content which a user wishes to upload is infringing or a legitimate use. So these are the words of the Commission. But then they go and they say that when an upload matches a specific file provided by right holders, automated blocking, preventing the upload by the use of technology, should in principle be limited to manifestly infringing uploads. So those obvious, so to speak, infringements. And then the Commission provides a set of criteria which will be, we will not have time to go into detail. We just look at the conclusions, and they say that what is manifestly infringing, so it's exact matches of entire works or of a significant proportions of a work, and they give the example of using the recording of a whole song as background in a user-created video, so you can get all this in those guidances, as well as uploads of an original work which has simply been technically altered or distorted to avoid its identification. So those would be two cases of hardcore, so to speak, manifestly infringing uses. Those considered not manifestly infringing would be content for which the right holders have not given a blocking instruction to the online content sharing provider, as well as uploads which match only partially with information provided by the right holders because the user has significantly modified the work in a creative manner. For example, adding elements to a picture to create a meme. This corresponds basically to the parody exception. And they also had the quotation exception, so uploads including short extracts, which represent a small proportion of the entire work identified by right holders. And here they talk about user-generated video, including an extract of a feature film or an extract of a song. So if you use the whole song, it would be an infringement. If you only use an extract, it would be a quotation or a creative use. For these cases, there should be ex post human review by platforms' copyright compliance officers. A kind of data protection office now applies to copyright. So good prospect for lawyers. And now we enter into the 50 Shades of Copyright, to use this very famous title, adapting to the context, concerning the rapid ex-ante human review of uploads containing earmarked content identified by an automated content recognition tool. In these cases, in particular, where it is time sensitive, and then we come to broadcasts of sports events, Champions League, European football champions, and so on, Formula One, probably, tennis, at least the Grand Slam. For these cases, the guidance say to us, those who are trying to help the legislator how to implement, to do a good implementation of the directive and therefore to comply with European Union law as best as we can, it says, well, despite it is not manifestly infringing, it should not go online. Like, it should stay down. Then there should be a warning to right holders for ex-ante approval. So you call the right holders, or send an email or some notification, and then if they say okay, you can put it online. Otherwise, if they say no, keep it down, you keep it down. And now we have this copyright dilemma. So it means, for me, as trying to understand this directive, this Article 40, Article 17 in this particular situation. So it means that for the Commission, earmarking of any content and control of uploads by rapid ex-ante human review before going online? Because the guidance also read that the interpretation of Article 17 must allow the effectiveness of the exceptions to be safeguarded and their purpose to be observed. And then we start to find a shift in copyright law, where exceptions become mandatory user rights. We don't read this yet in the guidance, but we will find it in the judgment in Poland, where this users' right doctrine becomes at least case law. At the same time, we find also a major challenge for software designers. So how to design a mosaic of filters as exceptions and limitations are not fully harmonized. So it will be complicated, at least, because this is not fully harmonized in the European Union. Each country still has its own, within the list provided by directive of 2001, so it will be complicated, at least. Or at least it will be a very nice chance for copyright lawyers, as it will become an even more relevant legal sector for internet businesses. So it means that internet businesses should hire more and better lawyers, those who excel in copyright, as well as in data protection and so on. But it will be very complicated for software designers, I'm afraid. So notice and take down, or notice and stay down, where do we stay? And then we come to the opinion of the Advocate General. If the guidance raises some questions, then we try to, well, probably the Advocate General thought about this better than I could think about it. And he has a very clear opinion. He says that the filters, as blocking filters, should apply only to cases where the unlawfulness of which is obvious from the outset, so those obvious infringements. As well as that users should be allowed to flag uploads where they think they are doing a legitimate use. And then he goes on and he says that the legislature considered that false positives consisting of blocking legal content were more serious than false negatives, which would mean letting some illegal content through. Right holders cannot require zero risk as regards possible infringements of their rights. And I would add, the same applies to users. Users cannot also demand zero risks for the exercise of their user rights. So they should not be so afraid of filtering technologies. So, but the advocate then adds that when the unlawfulness is not obvious, the question should not be addressed by those copyright officers of online platforms, but rather by the courts themselves, because it can be a matter of sacrificing, limiting users' rights as basic freedoms, where basic freedoms are involved. And so in my last, I think it's my last slide, I hope so. When we now have this judgment, Poland, which will be detailed with more proficiency than me, certainly.
where we find this idea that, in fact, you cannot use filtering systems which do not distinguish adequately between unlawful content and lawful content. And as we saw on the guidance of the Commission, technology is not yet available to draw a clear line between what is lawful and unlawful. So the question is, should we simply forget about filters? I would say no. So what kind of filters? What can we ask software designers to write? Well, I would say those filters which are able to identify those integral reproductions or substantial parts of the work. So I think the German case will be very illustrative on this and also very pedagogic also in this concern. But for other uses, in my opinion, in my humble opinion, they can only but flag, so give a warning, but they should stay up. They should not stay down. So there should be freedom of online communication. Well, the Avocato General, the Advocate General, I cannot read his name, sorry. He states the basic principle of freedom of communication online as a basic human principle in the digital environment. So if we want to preserve this principle, we have to allow, in my view, that these legitimate or presumably legitimate uses should be allowed to go online first and then discuss about it. In return, should right holders get nothing? I think we should reconsider the system of copyright levies. I know it's a very, well, we could have a Congress only to talk about it, but probably we should, as also Victor already said during his presentation, we should ask platforms to pay some copyright, some equitable compensation, so that this, of course, it will have to be managed by collecting societies. It is not possible to do it in an individual basis. But at least I hope if these enterprises, if they are better functioning, I think something will go to the end of the line where you will find the creator, the author, as well as the artists. And those are, and also some industry, of course. Without industry, arts and creation will be, well, it will be only, it will not be so important. And so I think this could provide some compensation to right holders while allowing at the same time freedom of online communication. Thank you very much. I hope I didn't go beyond my time. Thank you.
Thank you, Alexandre. You have certainly provided the audience with matter to discuss. We will now listen to Eleonora Rossati. She will discuss the significance of the judgment of the European Court of Justice of 26 April 22 in the case opposing the Republic of Poland and the European Parliament and the Council of the European Union for the national transpositions and applications of Article 17. Eleonora, the floor is yours.
Obrigada, Dario. Thank you very much. Good evening, everyone. I would like to start by thanking Victor and the Portuguese Alai Group for the invitation. And indeed, in the few minutes at my disposal, I will be touching upon the implications of the recent judgment of the Court of Justice in the Polish challenge to Article 17 for the transpositions and applications of Article 17 at the national level. Now, the image that I've used, of course, without clearing the relevant rights, might apply to this audience at this time of the day, so I will try and keep my remarks as short and concise as possible. So, as you know, shortly after the directive was adopted, the Republic of Poland lodged an action against the European Parliament and the Council, alleging that Article 17, and more specifically paragraph 4 of that provision, would be contrary to the Charter of Fundamental Rights, and notably Article 11 therein, that is about freedom of expression and freedom of information. So this member state requested the annulment of the provision in part, or if that was not possible, as a whole. The Advocate General, indeed, the opinion was recalled just a few moments ago, advised the Court of Justice not to invalidate Article 17, and the Court of Justice substantially agreed. It also noted that it will not be possible to invalidate just part of the provision, so it will be either everything or nothing, and the option in the end was to go for nothing. But of course, the Court of Justice, despite the fact that this was a judgment rendered in a Grand Chamber composition, so 15 judges instead of the usual 3 or 5 that hear copyright disputes, was not shy in actually saying how Article 17 should be interpreted and transposed at the national level, and provided quite an extensive guidance to the member states. And in particular, the Court of Justice found that there will be 6 key safeguards embodied within Article 17 that member states should be complying with when it comes to transposing and applying the resulting national provisions. So I will not repeat them because they are listed on the slide, but what does this suggest for national legislatures? That a minimalistic transposition of Article 17 is likely to be okay from a fundamental rights perspective, because if the EU text is okay from a charter standpoint, so will be a copy and paste type of transposition. So, is it possible to go beyond the text of Article 17 and adding elements that are not there, or subtracting from what is in the EU text? The answer seems to me to be in the negative, or at least if a member state wanted to depart from the text of Article 17, would be doing that at significant risk. Because indeed what the Court of Justice is suggesting is something that is in part obvious, in part ambiguous, and in part to be seen. What is obvious? Among the 6 key safeguards, the Court of Justice was adamant in noting that a generalized ex-ante blocking system will be incompatible with the Charter of Fundamental Rights. So this indicates that member states, like my own, I would say, that provided for an ex-ante blocking of content pending the resolution of a complaint, will probably not have done their homework correctly. But also member states that allowed for an indiscriminate ex-post blocking of content probably will not be doing their homework right, because indeed the type of assessment that the Court of Justice requires is one that is indeed a very precise, if not surgical one. And that leads me to the second point that I think follows quite straightforward from the judgment, and it is that a statutory provision that allowed for some presumed lawful uses, as it is the case indeed of some member states, we will hear more about that in a moment, also will be likely be acting in breach of EU law. And the same will be true for those member states that provided, just to think of a possible approach, for a statutory approach to presume unlawful uses. So what is required in a nutshell is not to alter the very delicate normative equilibrium that Article 17 itself does embody. And why is that so? Because Article 17 is formally part of a directive, but in substance reminds one very much of the provision that you will find in a regulation. It is so detailed, so normative in its content, that member states probably should be doing as little as possible to avoid finding themselves in breach of EU law. Then we heard indeed in the previous presentations from my fellow panelists that the Court of Justice employs the language that exceptions are rights of users. This, of course, is not something that was invented in the CJU judgment in the Polish challenge. It comes from an earlier case law of the court itself. And here, for example, the most explicit reference dates back to the Ulmer case concerning digitization of library collections, in which the Court of Justice at some point said, without elaborating much upon that, that indeed some exceptions in the InfoSoc directive are rights of users. What does that mean, though? It is for sure a right to have the content that was unduly removed reinstated on the platform, but is it also a right that entitles entitles a user, for example, to seek damages from a platform that unduly blocked the content that they uploaded, would it be possible for member states that allow this kind of initiatives for users to join together in a class action against a platform that indeed did not allow lawful content to be posted on a consistent basis? It remains to be seen. And then one final point that I would like to make before concluding is that another reason why a member state should not be so creative is because Article 17 is not the end of the story. And in particular, there will be another key legislative text that will be relevant to the application of Article 17 at the national level, and I'm referring to the Digital Services Act. This is a regulation that is likely to become reality very soon. It is an horizontal type of harmonization effort. It is a regulation and not a directive. And indeed, it expressly states that it is without prejudice to the EU copyright framework, including the DSM directive. So one might think the DSM directive and the DSA have nothing to share, but that will be really a short-sighted assessment of the relationship. As I said, Article 17 says many things, but does not say everything. So for the parts that will not be subject to Article 17, the DSA will likely find application. And here I have selected some provisions of the DSA that will be relevant to the application of Article 17. So for example, Article 17 excludes the availability of the hosting safe harbor for activities that fall within its scope of application, but for those that do not, the DSA safe harbors will find application. Then, of course, there is an important achievement of the DSA that is about the handling of complaints, the notice and action requirements. Also here, a member state that thought of doing these things on its own then might find itself in a system in which incompatibility with EU law will be again achieved. And the same will be true for transparency obligation, the regime for trusted flaggers, and so on. So, as of today, there are 8 member states, the last time I checked that was the number, that have yet to transpose the DSM directive to CUR, Portugal being one of them. So, what is the best way forward? Probably right now will be to have a text that is as close as possible to the EU counterpart, because doing anything that is creative might be in breach of the CJU guidance and might be also not future-proof when the Digital Services Act comes into force. On a final note, I would like to stress that not everything will be Article 17, and right now, indeed, we have focused on these upload filters, etc., but probably right now, something that is more pressing is to understand who is and who is not an online content sharing service provider. There are some examples that are rather obvious, but for others, I'm not so sure. So, in the short term, it is indeed a matter of understanding who is subject to the scope of application of this provision and who is not. And with that, I conclude and thank you for your attention.
Thank you, Eleonora, for these very stimulating remarks. I finally have the pleasure of handing over the floor to Jan Ben Nodeman, who has chosen to present us the German solution to avoid overblocking. Jan, please, the floor is yours.
Thank you so much, Dario, and thank you to the Portuguese group for inviting me. It's really a great honor for me to speak in front of Alai, I must say. And yeah, I would like to, after we've heard from Alexander and from Eleonora, what should be the underlying principles to implement nationally Article 17, what is the German solution and what may be the upsides and downsides of it. Could I have my slides, please? Thank you. there you go. I'm not, maybe as a kind of introductory remark, this is not a very patriotic presentation. As you will see, it's rather critical of the German solution. The Germans have implemented Article 17 not into their Copyright Act because they thought it was too difficult and too complicated and would make the already pretty complicated German Copyright Act more complicated, but they've created an own act for it, the so-called, and now I want you to all pronounce the word, Urheberrechtsdiensteanbietergesetz. Is probably the longest word you've ever seen. And I know we Germans are very good in creating long words, but this is really, I think it's a record. But that's why nobody ever pronounces Urheberrechtsdiensteanbietergesetz. We all say Urdak in Germany. So there you go. But that, of course, was just a preliminary remark. To understand the German implementation and how it went, I think the political background is also important to understand. In Germany, and I know that also in some EU other countries, but not in all, there were demonstrations on the street against what was formerly Article 13 and now was in the end numbered Article 17, as you can see here. I think it's a Munich picture, but there were thousands of people on the street against it. And that had somehow pressured the German government to make unrealistic promises. For example, they had promised that the German implementation could live without upload filtering. Believe it or not, yeah? And I think Alexandra said that it's now state of the art in copyright law that Article 17 requires filtering. For example, in one of the last YouTube reports, YouTube reported that in the first half of 2021, there were 2 million copyright complaints a day, yeah? When it comes to YouTube. So how can you do without automated filtering? But, well, the German government had promised it, so that's why they were somewhat under pressure to come up with a solution, and they really tried hard. First of all, they provided injunctive relief for qualified associations against OCSSPs to fight overblocking on behalf of users. So qualified associations, for example, consumer protection organizations, can file injunctive relief against OCSSPs who overblock. That's one of the first tools. You have a second group of tools against right holders who file unjustified requests. For example, right holders who file unjustified requests would be fully liable, for example, for damages occurred to the uploader, or if they do that repeatedly, the right holders, they may be temporarily denied filings. Yeah, filings, of course, meant notice filings, and that then lead to filtering. But the core of the German Urdak is that there should be no blocking of users presumably authorized by law, so presumably legal. Yeah? So what does that mean, or what did the German legislator understand from it? So it needs to be a combined use of works. So not the use of a single work, but you have to combine different works with each other. And on top of that, second condition is a minor use. Minor use, and that's maybe all of you heard about this, that's the famous 15-second rule of the German Urdak, which is, for example, 15 seconds of a film or 15 seconds of a song. So in case you do not go beyond these 15 seconds, you are within the presumed legal use. The use is presumably authorized by law. In case it's a combined use, or that's the second alternative, it's an alternative, it's not an additional condition, but it's an alternative. you have a combined use that is flagged as legal. Yeah? And there you go. So if you have these uses presumably authorized by law, they must not be filtered, and they must stay up until the end of the complaint procedure, which is up to 1 week, also set out in the law. There are certain exceptions, for example, for first publications. We heard about this by Alexander already. That's mainly targeting live content, and we have a red button for trusted flaggers, trusted right holders under certain pretty narrow conditions. What also is interesting to note, I think, is that these uses presumably authorized by law until the end of the complaint procedure, up to 1 week, as I said, you have no liability of the OCSSP, but on top of that, also the uploader is not liable if it's a mere minor use, and also important, a remuneration is paid to the rights holder. Yeah? Something that goes a little bit along the lines with what Alexandre has suggested on his last slide. If I can give you an example, of course it's a very extreme example, yeah, and I don't know where it will happen, but you know, it will shape the discussion, I think, if we build extreme examples. So it could be a use presumably authorized by law if you put a full-length movie up on YouTube and put a photo at the beginning and at the end, because then it will be a combined use of works, and if you flag it as legal, YouTube must not block it, and it needs to stay up until the end of the complaint procedure, which could be up to 1 week. So that, I think, may raise certain issues, in particular with Article 5 InfoSoc Directive 2001. It may be an exception limitation the German legislators included into its law, which is in breach of Article 5. As you may also know, looking for example at the Soulier decision of the CJU a couple of years ago, any use without the author's consent that is not listed in Article 5 is an infringement, paragraph 34 of the Soulier decision. So I think, you know, providing a rule that an infringement or something that may be an infringement has to stay up against remuneration comes very close to an exception, and we will have to wait and see whether this one is in line with Article 5. And one more thing, why I think Eleonora's approach, I think, goes into exactly the right direction. It's not only that we enter the dizzy waters of Article 5, and also maybe we will have a difficult relationship with the DSA, there's also the harmonization aspect, I think. Look at what the Germans have done to Article 17 with their very detailed implementation. It's different in other member states. For example, the Dutch have implemented what I always call copy-paste. Yeah? They've just done, you know, Article 17 and pasted it into their national law. So how about the OCSSPs, the YouTubes and TikToks of this world? What are they going to do with something they have to let through their filters under German law, but what is not so clearly, you know, which may be manifestly infringing under Dutch law, and they will be held liable under Dutch law, although the Germans, you know, kind of force them to remain up. So if I was YouTube, I would reintroduce geo-blocking. Because, well, if you want to avoid liability, that's probably what you will have to do. And I think that's also, of course, extreme example again, but I think that shows that these kind of detailed formalistic approaches, as Eleonora has said, they tend to endanger the harmonization aspect of Article 17. So, as a conclusion, the Germans have tried very hard to prevent overblocking, but their very formal solution, 15 seconds or flagged as legal in case of mashups. This may be in breach of Article 5 InfoSoc Directive, but I think what is more, it contravenes the harmonization through Article 17 DSM Directive, unless all others follow the Germans, and I don't think that this will be the case. Thank you.
Thank you, Jan, for this very interesting presentation. And well, with this plaidoyer for full harmonization, I think we have much food for thought. I would now like to open the debate to the public, and all those interested in asking questions to our speakers are now kindly asked to raise their hands. Yes, I see someone over there.
I'm having already a microphone, so maybe for speeding up, and then the others, is that okay? Thank you. Here's another German, Thomas Dreyer from Germany. There is also another narrative you could lay over the German famous Urdak, and that is Germany was implementing the directive even before the EU came out with the consultation and before the Polish decision was rendered by the Court of Justice of the EU. Now, the opposite reading of your reading, Jan Nordemann, would be that the Germans went ahead with an example, they just tried it, and interesting enough, the EU guidelines kind of followed it quite precisely, as did the Court of Justice in weighing the different fundamental rights. So, bottom line, what may happen is that according to the judgment of the Court of Justice, the differentiated approach will prevail, and all those who have a stricter blocking policy would have to adjust to the consultation, German example, Court of Justice, in order to achieve harmony.
Yeah, I think that's a fair comment, and you need to know that the Germans were before the guidance of the Commission and before the Polish decision. But still, I think if I read the Commission guidance correctly, it doesn't say you should introduce a 15-second rule into the law. It's rather, factors that courts should take into account when they weigh, the fundamental rights, the interests involved. The problem is really with a very formalistic German approach that if the others, as I said, do not follow, it kind of leads to separation of rights, and the harmonization effect of Article 17 really is endangered.
So we have another question over there.
Thank you.
Could you please introduce yourself before you ask your question?
Okay. My name is Johan Kaas, and I represent APO Artists, the European Organization for Performer Organizations. Thank you for that kind remark. I fully agree. And also thank you to Alexander, because I like your proposal on the last slide, and I still don't understand why that was never considered to be an option as the complete alternative for Article 17. But I'm gonna try to keep it as short. I think Burak already knows the question that I'm about to ask. Because I took a photo, and I will delete it afterwards to respect your copyright. I took a photo of your first slide. It says 2 key points on how Article 17 is supposed to improve authors' remuneration. Now today we've addressed different categories of right holders, also the neighbors, the performers. So actually my question is, can you give me at least 1 point on how Article 17 is supposed to improve performers' remuneration? Because if you look at Article 17, and the other slide you showed spoke of member states shall provide that an SSP performs an active communication to the public when it gives the public access to uploaded works. Now, nowhere in Europe that right is given to performers. The European acquis does not give performers an exclusive right on communication to the public. In the music sector, they have the right to an equitable remuneration, but they do not have the position to grant anyone authorization for broadcasting or any form of communication to the public. So, again, my question, how is Article 17 supposed to help performers improve their remuneration?
This is working? Yeah. And you will probably know what I will answer. I mean, first of all, I think the question is not really about Article 17, what you're asking. I think it's much more about the qualification of the acts undertaken by the online services in terms of the rights of the performers. And I think it requires another type of effort. But currently, under the current system, the rights of the producers and the performers follow the path of the making available right. And then in that respect, anything that is theoretically, I cannot elaborate in the details, that is theoretically benefiting the right holders in the sound recording by improving the revenues for the sound recording should obviously benefit the performers performing in that sound recording. The other thing, probably what you're asking, is whether a remuneration right for the performers or qualifying it as an unwaivable right to remuneration or equitable remuneration under the communication to public as it is in the broadcasting or public performance. I think it's then another issue that needs to be clarified by EU law and then not an interpretation of Article 17. That's what I can say.
More questions? Yes, here, please.
Thank you. Can you hear? Yeah. Thank you very much.
Please introduce yourself, please.
Julien, yeah. I'm Julien Cabet from Université Libre de Bruxelles. My question builds upon what Professor Dias Pereira has been saying regarding the mosaic of filters and the difficulties in building these type of systems. And we'll always assume that it's difficult because there is no harmonization of the exceptions. But I wanted to share with you another difficulties, which is maybe the elephant in the room as well, is that there is no harmonization of the infringement tests. And if we do some comparative case law analysis, we see that we have very different tests for assessing the similarities that are relevant from an IP and specifically copyright perspective. So, for example, is the overall impression the test in France, in Belgium, or in the Netherlands? There are very different solutions in the jurisdictions. So there is no harmonization of the infringement test. The second thing is that even though we want to build something that would be efficient and actually tackling what is manifestly infringing, we need enough data for training the algorithms. Therefore, data based on a correct solution as to is it an infringement. And my question then is it possible to build filters that would be tackling only what is manifestly infringing if we do not have enough harmonization of infringement tests and if we do not have data to build these systems?
So, difficult question. Question difficile. But I would say this directive, which looks more like a regulation indeed, it's probably the largest article I've ever read. Article 17 is more than physiologic. I think it goes beyond that. It's anyway. If you read this article in detail, you see that first, authors or right holders in general, now they have an obligation to mark works or other subject matter. So they will have to use the digital right management technology. So they will have to identify their works and they will have to reserve. So copyright, all rights reserved. They will have to do it as nowadays, so day-to-day business. Otherwise, there is like a presumption that you're allowing your work to free flowly on the internet. So I think this is the first point. So the DRMs now are mandatories for right holders. Otherwise, if you don't identify and if you do not tell the platforms how you are able to, how you want it to be used, it's like you are saying that oh, you can use it freely. Even to commercial, those large commercial platforms, so-called GAFA, no? So you have the obligation to mark, to identify your works. And then you have the obligation to oppose, or at least to enter into to have a reasonable attitude towards platforms. Because if you don't give a reasonable answer, if you are not, so to say, reasonable, it is understood that you did not have a reasonable negotiation procedure, and therefore the use is authorized. That's what I find in Article 17. So filters go much, they appear much later in the process. Concerning the mosaic, in fact, it's a problem. Perhaps it's time for the European Union to consider a general regulation of copyright and related rights, as it did in data protection. Why not? If we want to be a union, you have to have something in common. And copyright, if you want to have a single market, what's the problem about having a general regulation for copyright in the European Union? I sincerely don't see any ghost behind that. So, but of course, it's political. It's no longer science. It's not academic, practitioner. It's political. It's a political decision, and I may have an opinion, but it will not count much. Concerning remedies, indeed, we also identified. I think you talked about remedies. Yes? No. So okay. So the mosaic and the mosaic about exceptions, and also the mosaic about. Oh, so that's a major text for computer engineers. I don't know, a problem for my son. He just entered into computer engineering. Now I will ask him how to design the system. But
thank you, Alexandre. Okay, one other question, please, sir. Could we have a microphone here, please?
It's more a sort of a reaction to what Eleonora explained in her beautiful presentation. You were asking the question that we see many times nowadays: what are user rights? I think we don't have to be afraid of that expression. User rights can be anything like we already experienced before in other areas of law, with one word having different meanings. When you say users have rights, it does not have to mean that they have, per se, effective rights just as a holder of a neighboring right or a copyright would have. A user right can as well mean, I think, the right to an exception. And this is, of course, if the user's right is based on fundamental rights like freedom of expression, then it is a very, very strong right. But it can, I think, also take the form of a simple exception. And this is not new. It's quite simply what we always have had in general civil law, I think, where you can, if you are the owner of a piece of land, you have a very strong right. But there can be other types of right owners that infringe on your general right. For instance, the so-called right to go to the possession of someone else through the possession owned by someone in order that you can access your house. This is also called a right, but it is not a general right as forceful as that of the owner of a piece of land or a house, I think. Wouldn't you agree that we don't have to be afraid of the expression and that many of the battles around it are a bit unnecessary?
Thank you very much for your comment. I do agree with you that indeed sometimes words may mean just words, but it is something that also needs to be framed within the European experience. For example, if we take the InfoSoc directive, Article 5 is titled Exceptions and Limitations. What does that mean? There is abundant academic literature whether exceptions are the same thing as limitations or they are something different, And so there is actually a very interesting contribution by a fellow Portuguese, Tito Rendas. He has written a book about exceptions and limitations and then an article about exceptions, limitations and rights of users. So perhaps it might be the case that this language that has been used quite, freely over the past few years now might acquire a new meaning and come with different sets of consequences. Also in the case of the Court of Justice, I mentioned the court speaking of rights of users, but already before there was a discussion about exceptions and limitations themselves, and the Court of Justice did not really ponder on which approach would be correct. But the Advocate General in the VG Ward case indeed offered some thoughts and said that exceptions and limitations are not exactly the same thing. So to conclude, I agree with you that sometimes words scare us for no reason or make us feel joyful and excited for no reason. But in the European copyright system, it is a debate that has been taking a very precise shape, and so perhaps this reflection is worth having because it might lead to different type of consequences.
Thank you, Eleonora. I think your comment concludes very beautifully our panel. I think there are no remaining questions, so I would like to thank very much our speakers for their contributions. A big applause, please. And now I hand over the floor to Vítor Castro Rosa,
I
please.
would just like to thank everyone for being here. This is the first day, we conclude the first day of our Congress, so we hope to see you all here tomorrow, and we also hope to see you at the GESAC Alai Prize Award event this evening at Hotel Palacio. Thank you very much.